Morning, everybody. Welcome back. We're going to see what the Senate's been up to. You know, I woke up to a tweet that said there was a Cold War in the Senate, and I don't know how to unpack that yet. I really hope that we have Senate Republicans show up and, block any shenanigans, let's say.
Committee will come to order.
Here we go.
Today we'll hear from two judicial nominees. Judge Benjamin Cheeks, nominated to the U.S. District Court for the Southern District of California, and Judge Serena Murillo, I hope I pronounced that right, nominated to the U.S. District Court for the Central District of California. Congratulations to both nominees and their families and friends. Senator Padilla and Butler will introduce the nominees from their home state. First, I want to note the fact that we started this hearing. Senator Graham has a conflict in his schedule. We're hoping he'll be able to join us, but they told us to go ahead with the beginning of the hearing. So now we'll have an introduction of our nominees. Senators from California are not here at the moment. We expect them any minute. I just left Senator Padilla in a meeting. But I thank the individuals for joining us. So I'm going to swear in the nominees and be prepared as soon as they arrive. I ask them both to come forward to the witness table. Please raise your right hand. Do you affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. The record, please be seated. The record will indicate that both answered in the affirmative. I'm going to, at this point, I'm going to recognize you to make your opening statements. You each have 5 minutes. Judge Cheeks, you'll be first.
Thank you, Chair. Thank you to Chairman Durbin, Ranking Member Graham, and members of this committee for convening this hearing. Thank you to the senators from my home state, Senator Padilla and Senator Butler. And thank you, President Biden, for nominating me. This is truly, truly the honor of a lifetime. I also want to thank the people who have joined me here in person to support me. First, my wife of 17 years. She's also been my best friend for 27 years. She is by far the best thing that's ever happened to me. Together we have 2 beautiful boys, aged 6 and 8, and the 3 of them are indeed my reason for living. Also here is my mom. She is my biggest cheerleader and my biggest fan, and she's the person that's glowing, that's right behind me. She raised 3 college-educated kids as a single parent and taught us the value of hard work, determination, and the value of a quality education. I won the lottery with having her as my mom. Also, here's my cousin Anthony. As a military veteran, a police officer for many years, and former police chief, he has been a positive influence on my life in more ways than he knows. The godmother of my kids, Kathleen, is here. She has been in my life for 12 years, and we have shared nearly every major holiday together. You are the family that we chose, Kathleen, and thank you for your years of support. Mladen is here from New York City. I've known Mladen for 20 years, from back when I was in law school here in DC, and he was in graduate school. Thank you, Mladen, for your love and never-ending support. Richard is also here from New York City. Richard and I work together as prosecutors at the Manhattan District Attorney's Office, often discussing case strategy and our love for our jobs. Richard, you are a remarkable man, and I'm lucky to have you in my life. My law clerk, Michelle, is here. Thank you for assisting me in setting up chambers with Alex. I truly appreciate your passion for the law and eagerness to learn and grow. I also want to thank all of my friends and family who are watching this from home, as well as the court family of district judges, magistrate judges, clerks, staff, prosecutors, and defense attorneys in my home district. Your support has been nothing but short of amazing. And lastly, I want to thank my alma mater, American University Washington College of Law, here in DC, for giving me the quality education that started me on my journey to this moment. And with that, I welcome your questions.
Thanks, Judge Meeks. I'm going to let Judge Murillo make an opening statement, and then we'll turn to the California senators.
Thank you, Senator. Chairman Durbin, Ranking Member Graham, and members of the committee, thank you for convening this hearing. I am profoundly grateful and deeply humbled to sit here before you, and I thank President Biden for the honor of this nomination. Thank you also to my home state senators, Senator Padilla and Senator Butler. I'm grateful for the opportunity to thank the community of people whose love and support have sustained me. First, I'd like to thank my husband, Christian, the love of my life and my confidant. Without his support, none of my personal or professional accomplishments could have been achieved. He is the bedrock of our family and an outstanding and loving father to our children. To my children, thank you for being with me here today. You guys make me proud every single day, and you remind me of why your dad and I work to uphold a system of laws that have benefited so many. To my dad, Joe Murillo, his parents, Jesus and Dolores, my aunts and uncles, especially my tia Tencha and my tia Tito, who changed the trajectory of our family's lives by making it possible for my dad to obtain higher education. I'm also grateful to my incredibly resilient and loving mom, Virginia, who is watching from home, and her family. Through their unconditional love and sacrifice, my family instilled in me and my siblings a love of this great country, civic duty, community, charity, and above all, belief in America's promise. I am grateful to my siblings, Tiana and her husband Paul, and my sister Tansy, who are here with me today, and to my other brothers watching from home, my brother Joel, his wife Katie, and their children, my brother Matthew and his mom Diane, and my sister-in-law Monica. I also want to thank the best in-laws anyone could ask for, Eva and Moises. They moved here from Argentina as a nurse and a Christian pastor, and I've appreciated their love and support. Finally, my indelible cousins, who are like my extended brothers and sisters, especially my cousin Annette. They never fail to support my every move, and I love them all. I would also like to thank my best friends, Habib and Andrea, who could not be here today, their children, the Geller family, and their children who are watching from home, and to those friends who traveled here with me today, my college roommate, Michelle, who is celebrating her birthday today, and my friend and former colleagues, Susan and Michael. To the incredible women of my basketball world, and to Coach Fellows, thank you for your support and for making me a stronger person. And finally, I would like to thank my friends in the law, specifically Mike Bedart, the McNicholas family, the lawyers of the Los Angeles legal community, my friends in the California Judicial Council, and the many judges and justices across the state of California with whom I have had the honor of working. Last but not least, I wish to thank the extraordinary bench officers with whom I serve on the Los Angeles Superior Court. I could not have asked for a more dedicated group of people with whom to work, and I'm humbled by their ongoing commitment to the people that we serve. Together, all of these people, in their own ways, have helped me strive daily to uphold the Constitution and its ideals. I am grateful for this opportunity to thank them, and I welcome your questions.
Thanks, Judge Murillo. I'll recognize Senator Butler.
Thank you, Chair Durbin, and congratulations to our nominees, to their families and friends who are joining them. They don't sit at this table without you, without your support and care. And so we are appreciative for you being here. I want to also thank my colleague and senior senator from California, Senator Padilla, and his staff and Independent Judicial Committee for bringing forth such great nominees for us to consider. And I excitedly join him in supporting these nominees and am honored to be able to introduce them to the committee this morning. It's California Day in the Senate Judiciary Committee, and these are incredible nominees representing some of the brightest minds and jurists in our state. We just heard from Judge Murillo, who I will start with, of course, born in Pomona, raised in Chino, and attended undergraduate law school, all in the great state of California. Part of what shaped Judge Murillo's upbringing was competitive basketball, as she noted, as something that she and I have in common. Judge Murillo's father was a longtime women's basketball coach at Chino High School, where the court is named after him due to the number of championships that he won there. While he's not here with us physically today, I'm confident that he would be proud of his daughter who's sitting before us, and how the lessons that he taught her are showing up in her public service. Judge Murillo is joined by friends, colleagues, family, including her husband, Christian, as was noted there, 3 children, her sisters, and her brother-in-law. While in law school, Judge Murillo completed an internship at the district attorney's office in the downtown Los Angeles courthouse, where she now works. Upon graduation, she knew she wanted to return to the LADA's office. In 1996, Judge Murillo was hired as a deputy district attorney, beginning her 17 years of service as a prosecutor. Throughout her prosecutorial career, Judge Murillo worked on a variety of matters, including juvenile criminal cases, felony criminal matters ranging from theft to homicide and white-collar crime, including embezzlement, tax securities, and fraud. Judge Murillo tried approximately 68 cases to verdict in state court, half of which were jury trials. Since 2015, Judge Murillo has served as Superior Court Judge on the Superior Court of California in Los Angeles County. On the bench, she has presided over approximately 55 jury trials in civil, felony, and misdemeanor matters, and written thousands of decisions. Of those decisions, none have been reversed with significant criticism by a reviewing court. I think it notable when talented jurists with time-consuming professions still choose to dedicate themselves to mentoring the next generation. Judge Murillo has taught at the University of Southern California School of Law and the University of California Irvine School of Law since 2022 in torts, criminal law, and criminal procedure. It would take much longer, Chair Durbin, than we have time for today to read out the list of awards that Judge Murillo has won, to describe her involvement in her community and share words of praise from her colleagues. I will just conclude by highlighting that in her own words, Judge Murillo describes her values as being influenced by her union member parents and grandparents, who shaped her understanding of hard work, fairness, and community. I'm confident that she possesses the experience and character to serve the Central District well. To Judge Cheeks, who has been nominated to the District Court of Southern California. Today, I know, is such a special moment, and I'd like to welcome Judge Cheeks' wife and mother, who are here with him. As was noted, it does take a village, and thank you for being the village behind Judge Cheeks. Judge Cheeks was born in Albany, Georgia, a Southern man after my own heart, attended the University of Miami for undergraduate, and as was noted, American University Washington College of Law. Judge Cheeks began his legal career as an assistant district attorney in the New York County District Attorney's Office, serving from 2003 to 2010. During that time, Judge Cheeks was assigned to various divisions, including narcotics, immigrant affairs, and appeals. In 2010, Judge Cheeks began serving as an assistant U.S. attorney in San Diego. His primary duty was prosecuting typical border crimes, such as illegal entries, human smuggling, conspiracy to import drugs or guns into the United States. In 2013, Judge Cheeks opened his own law firm dedicated to criminal defense and civil cases. He was appointed to represent many of his over 300 indigent clients by the state of California. Since 2024, Judge Cheeks has served as a U.S. magistrate judge in San Diego. In his tenure, he has demonstrated effective courtroom management, fair treatment of the parties that appear in front of him, and a command of the law that reflects his aptitude and demeanor for the federal bench. Like Judge Murillo, Judge Cheeks has also served as an adjunct professor for a decade at Thomas Jefferson School of Law in San Diego for a year, and then California Western School of Law. I look forward to supporting Judge Cheeks and Judge Murillo's confirmation and would urge my colleagues to do the same. Thank you, Chair Durbin.
Thank you very much, Senator Butler. I'm going to start the questions and note the fact that both of the nominees before us have some similarity in their background. It turns out you both have been professors of law at various times of your life. and also have been prosecutors with some very important cases. It is interesting that we have a number of nominees over the years who have been prosecutors and make great judges. We have had fewer when it comes to the public defense side, but that has been changing. There is at least a movement on one side of this committee to diversify the bench when it comes to that experience. Could you address the basic question, if I am accused of a crime and appear before you as a judge, look at your background and say, oh, this judge has been a prosecutor over and over again. Do I have a chance before this court? What is your response to that if you're the judge sitting and trying to assure the person that justice is going to be followed? Judge Cheeks?
Thank you for the question. I would respond with absolutely there will be a fair shake with anyone that appears in front of my courtroom, regardless of the type of case, particularly if an individual comes in front of me that has been accused of a crime. As you mentioned, I have a prosecutorial background of 10 years prosecuting cases, but on the other hand, I also have 10 years of being a defense attorney. So I know both sides of the criminal justice coin very well, and as a sitting judge, it is my duty to give everyone that comes before me a fair shake, give them an opportunity to be heard, and to apply the law to the facts unbiasedly and with an open mind.
Judge Murillo?
Thank you. I would agree with Judge Cheeks, but I would remind you, Senator, I've been a judge for about almost 10 years. Yes, I was a prosecutor for 17 years before then, but I had a pretty balanced view of my role as a prosecutor, always intending to not only prosecute the cases that I had to the fullest extent of the law, but also balancing that against maintaining the rights of the defendants and also maintaining a healthy respect for the defendants. As a judge, I try to treat everybody in my court with humanity, dignity, and respect. I call everybody by their names. I give everybody a fair opportunity to be heard. I try to be prepared. And I think in the 10 years, I hope that I have conveyed that to the people that appear in my court.
Judge Cheeks, you've written some articles relative to the George Floyd murder and the whole issue of race and criminal justice. Would you like to describe your position to the committee?
Yes, as a defense attorney, I wrote a variety of articles detailing issues with regards to criminal justice issues, race issues, George Floyd. I didn't really take a position in those articles mostly. What I wanted to do was to educate the reader on what was going on, identify the fact that there are some issues or problems going on in the world, and just throw out the question of how can we solve it without actually stating how to solve it, because I don't know how. And I'm very open about my position as an individual, particularly as a Black man, and all of my experiences, and I find it helpful, and others have told me that they find it helpful to hear my experiences to help shape the way that they think and the way that they engage in this type of conversation. And so even though it opens myself up a little bit with regards to the experiences that I've had, I found it helpful, and then others have told me that they found it helpful to know that it's happening within the legal community. Sometimes people think that it's far away and it only happens to people that are far away. But I've been told it's been good to know that someone that they know has gone through some experiences.
And you've also addressed the issue of child parenting. Would you like to comment on that?
Yes. I wrote an article about parenting my children who are mixed African American and Hispanic. And I wanted to sort of tell my apprehensions about how I'm going to raise them with regards to how they're going to be able to deal with challenges in life, but particularly challenges because of their skin color, if that were to come. And I wanted to just express some apprehensions about having those difficult conversations with my kids. They're only 6 and 8, and when I should have that conversation. And so I just wanted to express that there are some issues that I'm going to have to speak to my children about that others may not have to.
Right. The famous conversation which parents of minority children have to protect them in situations that others may not face. Judge Murillo, your thoughts on the subject? Microphone.
I'm sorry, Senator, my thoughts on the subject of which portion?
This whole question of minority relationships with our criminal justice system.
I think it's a delicate issue for legislators to try to come up with solutions to address. In my role as a judge, when those issues come before me, I do my best to analyze the facts of each case and the circumstances. And I do that with an awareness of some of the fear and issues that are presented by those cases, and I do my best to resolve them in a way that is fair to all parties.
Thank you.
Thank you.
Senator Kennedy.
Thank you, Mr. Chairman. Judge, congratulations. Judge Cheeks, I see you're quite a prolific writer, and you say I heard you answer Senator Durbin's question, you said you don't take a position in these articles?
I said I tried not to take a position in most of my articles.
Well, you didn't succeed. In October 2020, you published an article entitled, "I Can't Breathe." You remember that article?
I do remember that article.
Okay. You were talking about Mr. George Floyd's tragic death. Here's what you said, quote, your words, not mine, quote, "What happened next after Mr. Floyd's death is nothing short of amazing. Mostly peaceful protest broke out almost immediately in Minneapolis, and the use of excessive force by police officers became the villain in a sea of protesters," end quote. Did I read that accurately?
That sounds correct, yes, Senator.
All right, and then in October of 2019, you wrote an article entitled "Raising Responsibility: A Concerned Parent's Perspective." You remember that?
I do remember that, yes.
Did you take a position in that article?
I recall my position being talking about how am I going to address issues with my
So
children.
you did take positions, unlike what you told Senator Durbin.
What I told Senator Durbin that I try not to take positions.
Okay. Well, I want to read you from your article. Quote, your words, not mine. "Needless to say, I have a guarded opinion about the police. How do I teach my sons to respect them and fear them at the same time? There can be no question that police officers have some of these same internal or external biases." Let me repeat that. There can be no question that police officers, not some, all police officers have some of these same internal or external biases described above. Do some of them view black males differently than others? I think so. Sounds like a position to me. Do some think black males are more dangerous than others? I think so. Did I read that correctly?
Yes, you read that correctly.
All right, now, and then in May of 2019, you remember writing an article for a publication, the title of the article, the title of your article in which you say you didn't take a position was called "The Federal Dungeon Part 2, Court Proceedings." You remember that?
I do.
Okay. And you were talking about, it was then under President Trump, not President Biden. The Department of Justice then had a zero tolerance for illegal entry into the United States, because that, of course, is the law. And this is what you said about that. Quote, "Technically, the law was broken, but these particular defendants, poor, hungry, hardworking, and not dangerous, deserve a pass from prosecution." End quote. Saying that illegal immigration should not be criminalized is a position, is it not?
It is. What I'd like to add is that everything that I wrote while I was an advocate, not a sitting judge.
Oh, I see. That makes a difference. Did you
that
mean it when you wrote it?
When I wrote it,
Did you mean it?
I meant it when I wrote it because
Okay, but you don't mean it now?
I do not mean it now.
So if you
Right
take
now.
off your advocate hat today, do you have your advocate hat on today?
I am no longer an advocate. I'm a sitting magistrate
Okay,
judge.
so so you don't tell the truth when you're an advocate, but you do when you're not? Is it okay to lie if you're an advocate?
I don't follow the question.
I think it's pretty clear, and I think you follow it. You've taken a lot of radical positions, Judge, and you can't make this catwalk backwards. Now, you can't make this catwalk backwards. I have one question for our second judge here. Judge, you remember a couple of years ago going on a broadcast called Visible Voices Podcast? All right. Here's what you said. It was just a couple of years ago. Mm-hmm. So we're not talking way back in law school or anything. We're talking about a couple of years. You'd been on the bench how long? 8 years then?
I've been on the bench almost 10.
Yeah. Well, but when you said this in front of God and country, you'd been on the bench 8. You said it in January 31, 2022. Here's what you said, quote, I think that COVID has brought a lot of these issues to bear, especially in the legal profession, where I tell a lot of people all the time, we, the people, never included people of color or women. When you have an institution that is set up by property-owning white men for 200 years or so, it wasn't geared towards thinking about what would be the best work schedule or how we could really incorporate women with children in this field. So it's been a challenge that COVID was exacerbated, end quote. Did I read that correctly?
Yes, Senator, you did.
And then you go on later in the podcast to call for quotas based on gender, don't you?
No, sorry, never
Yes, you
ever
do.
claimed
If the
anything
senator
about
will give
quotas.
me time, I'll read what you said. May I finish reading what you said? The witnesses denied believing in quotas based on gender, and I have the quote.
Senator, you may read the quote, and then she will give an opportunity to respond.
Okay, here's your quote, Judge. Your words, not mine. Quote, I think recognizing implicit bias is really important. Me too. But I'll be honest, I don't think that's enough. Because the truth of the matter is nobody is going to voluntarily give up their position in favor of women. Women have to demand it. Women have to be willing to require and hold people accountable, hold men who are in those positions accountable, and say, quote, why don't we have an equal number of supervising judges, close quote. You didn't tell me the truth, did you? You believe in quotas based on gender, don't you?
Senator, your time's expired. I'd let the witness respond.
Thank you. No, I have never advocated on behalf of quotas. I think it's undisputed
Well,
that
what
at the
was
time.
this?
Please
I just
continue,
read it.
I
continue
think
to
at the
respond.
time that the Constitution was written, there is no question that it did not include women, and it did not include people of color in the definition of we the people. We, as women and people of color, have only recently been able to be judges or jurors or politicians. But the systems that were created when I was excluded and when people of color were excluded continue. All I was commenting upon is that the diversity in the judiciary builds integrity in the system and public confidence in those institutions. I never mentioned anything about quota. Thank you.
Good try, Judge.
Senator Butler?
Good try. Good try.
Just one question to both nominees. Chair Durbin, thank you. Judge Cheeks, are you prepared to apply the laws of our country and Constitution fairly and justly if you were nominated?
Absolutely, and I have been doing so as a magistrate judge ever since I took the bench.
And Judge Murillo, same question.
Yes, I agree as well, Senator Butler. Thank you.
Questions, Chair, thank you.
Thank you, Senator Butler. I'm sure you do. Judge Cheeks, how is a magistrate chosen in the federal court?
In federal court, a magistrate is chosen through a merit selection committee of local attorneys. They interview everyone that applied. They choose the top 10 to interview, After they interview the top 10, the top 5 of those go to be interviewed by all of the district judges in the district, and the district judges vote and choose the magistrate judge.
Is that the process you went through?
It is, yes.
I see. And so it is a consensus decision by the sitting judges in your district court?
That's correct, yes.
That's correct. Judge Murillo, you said that you've been on the bench for 10 years,
Yes, Chair Durbin,
and you've had civil and criminal cases before you?
I have.
I see. And I think Senator Butler noted that you've never been reversed by a higher court?
It makes me nervous to say that out loud, and I discovered that going through this process. I did not know that before.
Well, I bring those facts for the record, so it's pretty clear that if you are a radical, as some people suggest based on a writing that you made years ago, obviously there are other circumstances which gave rise to a consensus decision to give you a magistrate position and give you an opportunity to serve on the bench for 10 years and rule on cases without reversal. So I think that speaks to the basis of your qualifications for the nominations which you seek.
Thank you.
I see no other.
Mr. Chairman,
Senator Kennedy.
thank you. Mr. Chairman, as acting ranking member,
Don't let it go to your
I
head.
love the power. I didn't know what it felt like to be
It's an amazing
to
thing.
have. It is. It's better than sex. I don't know. Not really. This Senate stuff's quite an experience. I'm not going to ask for the prerogative to ask a second round of questions as you just did, but I did want to correct the record. The part where Judge Murillo's calling for quotas based on gender was not a long time ago. It was in January of 2022. Is that correct, Judge?
I'm not certain on the exact date, but I trust you, Senator, if that sounds about right.
Thank you so much. Thank you, Mr. Chairman.
No further business to come before the committee. The Senate Judiciary Committee will stand adjourned. You may receive some written questions from colleagues. I ask you to respond to them promptly. If your nomination is going to be considered this calendar year, we've got to hold to strict deadlines for gathering that information. I thank you and all of your friends and family for joining us today.
That was
This
the
meeting of the
quickest-
Senate Judiciary Committee stands adjourned.
I knew it was going to be quick,
Thank you.
but I was expecting some more. You know, maybe a little bit of Josh Hawley. I mean, he shows up a lot. You can't really go at Kennedy and Hawley for not showing up. They're good, but now what do we do? I don't know. I know there's Oversight has a markup, full committee markup hearing. It could be good. We could just check in, make sure they're doing okay at Oversight. Just give me a minute here. And there it is, right there. Are they in? They haven't even begun, or did they? And they recess. They have not even started yet. There's a lot of meetings and stuff going on right now. I'm pretty sure. Like for instance, let me pull this up for you, so you can see it and I can read it to you. Graham. Because a lot of people aren't sure how that's going to play out, and I did write that he signaled this morning, Senator Graham, that he had a meeting with Matt Gaetz. Can you see this? And it went well. So let me see what we can manage here very quickly.
I had a very good meeting with President Trump's nominee for Attorney General, Matt Gaetz, and Vice President-elect J.D. Vance. I am committed to allowing the process to go forward in a manner consistent with past practices and fundamental fairness. This process will not be a rubber stamp, nor will it be driven by a lynch mob. My record is clear. I tend to defer to presidential cabinet choices unless the evidence suggests disqualification. I fear the process surrounding the Gaetz nomination is turning into an angry mob, and unverified allegations are being treated as if they are true. I have seen this movie before. I would urge all of my Senate colleagues, particularly Republicans, not to join the lynch mob and give the process a chance to move forward. After years of being investigated by the Department of Justice, no charges were brought against Matt Gaetz. This is something we should all remember. I would also urge my colleagues to go back to a time-tested process, receive relevant information, and give the nominee a chance to make their case as to why they should be confirmed. This standard, which I have long adhered to, has served the Senate and country well. 10:09 a.m. November 20th, 2024 30.3 K views to
So it sounds like, Gaetz met with Graham this morning, and that Graham basically has a policy of not getting in the way of a friendly judicial nomination, or in this case, Attorney General nomination, unless there's evidence to suggest disqualification. And that could be a huge, harbinger. I don't think it is. It seems like he's going to let it go through because, I'm pretty sure that to some degree the ethics report, the contents of it, I don't know if they leaked, but I don't know if they're known either. But the DOJ, they investigated Gates for like 3 years and they found no wrongdoing. They didn't pursue charges. And even the View had to walk back. Something this morning. Let's see if we can find that. It should be like very easy to find. Sunny Hostin, one of two most racist women on the internet, possibly. Hold on.
Has long denied all allegations on screen. Well done, Gates. Sonny, you have a legal note. I do have a legal note. Thank you, Whoopi. Matt Gaetz has long denied all allegations, calling the claims, quote, invented, and saying in a statement to ABC News that this false smear following a 3-year criminal investigation should be viewed with great skepticism, that DOJ investigation was closed with no charges being brought.
We'll be right back.
All right. So I don't know, was that this morning or yesterday morning? It was very recent. So the ball is moving. The chains are moving, I should say, in the right direction, right? Because Lindsey Graham sending that signal is not nothing. That's not a nothing burger. He met with Gates, and it was a good meeting. The View is walking back all their defamatory language, that's also a good signal to some degree. So these are all good. It's all been good signals. All been good signals. Yes. So with the with Oversight still okay. We got Oversight.
Amendment is considered as read, and it's up to additional roll ordered. Phone first. We'll start. Yep. The committee will please come to order. A quorum is present. Without objection, the chair is authorized to declare a recess at any time. Pursuant to Rule Committee 5B and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment on which a recorded vote or the yeas and nays are ordered. The committee will continue to use the electronic system for recorded votes on amendments and passage of the bills before the committee.
That's what we're watching right now.
Of course, should any technical issues arise, which I do not anticipate, we will immediately transition to additional roll call votes. Any procedural or motion-related votes during today's markup will be dispensed with by a traditional roll call vote. Our first item for consideration is H.R. 10133, the Timely Stock Disclosure Act. The clerk will please designate the bill.
H.R. 10133, the Timely Stock Disclosure Act, a bill to amend Title V, United States Code, to require the reporting of periodic transaction reports not later than 15 days after receiving notification of the requirement to report a transaction, but in no case later than 30 days after such transaction and for other purposes.
Without objection, the bill shall be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of a substitute. The clerk will please designate the amendment.
An amendment in the nature of a substitute to H.R. 10133 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for the purposes of further amendment. I recognize myself for 5 minutes for a statement on the bill and the amendment. I support H.R. 10133, the Timely Stock Disclosure Act. Over 45 years ago, Congress passed the Ethics in Government Act. This landmark legislation addressed conflicts of interest and the appearance of corruption. The goal was, and remains, preventing real and perceived conflicts of interest among those fortunate enough to receive the public trust. Our ethics laws accomplish this by requiring certain federal employees and candidates for office to disclose financial interests that may relate to their official duties. Over the years, Congress has advocated additional legislation with similar intent, including by passing the Stock Act in 2012, which required financial disclosure flyers to publicly report certain stock transactions within 30 days. That law is intended to provide an additional layer of protection against potentially illegal insider trading that may occur if senior federal employees and congressional members and senior staff use special knowledge from their official service to trade stocks in a way that benefits them personally. H.R. 10133 would strengthen the Stock Act reporting requirements by shortening the current 30-day reporting requirement to 15 days. The idea is that the faster that the public can view the disclosures, the sooner authorities may intervene to address potentially illegal insider trading. I want to thank my colleague, Mr. Burchett from Tennessee, for introducing this legislation, and I urge my colleagues to support the Burchett bill. I now recognize Ranking Member Raskin for his opening statement.
Yep. Thank you, Mr. Chairman. I am very happy to support the Timely Stock Disclosure Act today. The Stop Trading on Congressional Knowledge Act, or the Stock Act, was signed into law in 2012 to address the problem of insider trading in Congress and the executive branch. Among other things, it requires the president, VP, senior executive branch officers, members of Congress, senior congressional staff, and others to report all transactions over $1,000 involving stocks, bonds, and commodities within 30 days of learning that such transaction has taken place, and no later than 45 days after such transaction. H.R. 10133 would reduce those reporting requirements to 15 days and 30 days respectively, requiring more timely disclosure. While this is a modest step in the right direction, it fails to meaningfully and comprehensively address the public's concern that members of Congress are able to use their access to confidential information to enrich themselves in the stock market, and that their federal policy-making decisions may be shaped by their own personal financial interests instead of the common good. Members of Congress simply should not be allowed to trade individual stocks in office. The floor of the House of Representatives should not be like the floor of the New York Stock Exchange. Many bills have been introduced to take this step, which has the support of 88% of Democrats and 87% of Republicans, according to a 2023 poll. The public's position on this is clear, it's compelling, and we should work with the other committees of jurisdiction to pursue legislation to completely ban the trading of individual stocks by members of Congress. Thank you, Mr. Chairman. I look forward to working with you on that, and I yield back.
I now recognize the sponsor of the bill, Mr. Burchett from Tennessee, for his statement on the bill.
Thank you, Mr. Chairman. I feel like I should withdraw this bill with all the support I'm receiving. That kind of scares me just a little bit. I have to go back and reread the bill. But the Timely Stock Disclosure Act is a much-needed step towards transparency. And for the record, my $9,000 portfolio, which is mutual funds, is managed by my buddy Tommy Seiler in Knoxville, Tennessee. So I totally support removing individual stock trades, and I will vote accordingly. But this bill would amend the Stock Act of 2012 to reduce the periodic transaction reporting timeline from 30 to 45 days to 15 to 30 days. And you're right, Ranking Member. I wish we could go farther. I'm just trying to get us. We're trying to eat this hog one bite at a time. And specifically, this bill requires the President, Vice President, members of Congress, and senior government officials, and at G15 or higher, and are making over $120,000 per year, to report their stock trades within 15 days after they're notified that they need to submit the report, but under no circumstances later than 30 days after the transaction itself. Congress has a 19% approval rating, and most of the country thinks this body is corrupt. I being one of those, and I don't blame them. Our constituents elected us to write laws directly impacting the American people, yet certain members consistently outperform even the best hedge funds in the stock market, raising questions about the intent behind the bills we pass, rightfully so. But Congress does not have a monopoly on government corruption. We've seen it through all branches of government. And additionally, our federal agencies are constantly writing rules that have the force of law while continuing to trade stocks. If federal employees and officials want to continue to participate in the market they regulate, there needs to be some dadgum transparency. While I believe there should be a total ban on members of Congress and high-ranking government employees trading stocks, passing this legislation is a necessary step in the right direction in helping restore confidence in the U.S. government. Thank you, Mr. Chairman and Mr. Ranking Member, for your support.
Gentleman yields back. Do any other members wish to be heard? Seeing none, The question is now on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. The question is now on favorably reporting H.R. 10-133 as amended. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. And the chair recognizes the gentleman from Arizona.
I request a roll call vote, please.
A recorded vote has been requested by the gentleman from Arizona, Mr. Biggs. As previously announced, further proceedings on the question will be postponed. Our next item for consideration is H.R. 10-132, the Federal Agency Performance Act. The clerk will please designate the bill.
H.R. 10132, the Federal Agency Performance Act, a bill to improve performance and accountability in the federal government and for other purposes.
Without objection, the bill should be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of a substitute. The clerk will please designate the amendment.
An amendment in the nature of a substitute to H.R. 10132 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for the purposes of further amendment. I now recognize myself for 5 minutes for a statement on the bill and the amendment. I support the Federal Agency Performance Act of 2024, which provides additional transparency, accountability, and priorities for the federal government. Federal agencies have many different missions. To meet these missions, they are required to develop goals and objectives. Developing the goal is an important first step towards progress. However, we know that more must be done to ensure that these goals and objectives are being achieved. The Government Performance and Results Act of 1993 is later modernized in 2010 by a reform act known as GPRAMA, collectively established a solid foundation of reforms to improve the overall performance and outcomes of federal agencies. GPRAMA addressed a number of issues such as focusing attention on cross-cutting management issues, enhancing the usefulness of performance information, increasing transparency, and ensuring leadership commitment and attention to improving the performance of federal agencies. H.R. 10-132 builds upon existing law to codify the performance management practices that have shown the most positive results. This bill requires agencies to proactively assess their progress towards achieving their strategic goals and objectives. It ensures that merely developing the goal is not enough. Agencies would be required to track their progress and develop plans to address identified risks to not achieving their stated goals. This bill also requires agencies to determine whether they need more evidence to better assess their progress. Agencies would also be required to assign senior leadership attention to completing these efforts, a common sense reform that ensures that the work gets done. I'd like to thank committee members William Timmons and Ro Khanna for leading this bill in the House of Representatives. I urge my colleagues to support this important, sensible, and bipartisan legislation. I now recognize the ranking member for his statement.
Mr. Chairman, thank you very much, and thanks to our colleagues, Mr. Timmons and Mr. Khanna, for leading this bill to modernize the Government Performance and Results Act of 1993, which I thought we referred to as GPRA, not GPRAMA. I don't know.
I'm sure that's probably right.
So, but I'm pleased to support the legislation. I want to thank the Senate Homeland Security and Government Affairs Committee Chairman Gary Peters for his leadership over on the Senate side. GPRA first established a performance management framework for government agencies and was last modernized in 2010. So we're definitely overdue for another look to make sure that the framework is operating as effectively and efficiently as it can. The Federal Agency Performance Act would codify OMB's practice of conducting regular strategic reviews of federal agency performance goals and ensure that all priority goals are tied explicitly to the President's budget with milestones that can be achieved within a single presidential term. It would also set new requirements to improve publicly available data on performance.gov, allowing greater transparency into agency progress. Additionally, it would require each government-wide priority goal to be led by at least one OMB official and one agency official. The bill makes other common-sense updates to ensure federal agencies are providing services to the American people as efficiently as possible. I appreciate, Mr. Chairman, you're bringing this up for a vote today and encourage my colleagues to support the legislative handiwork of Mr. Timmons and Mr. Khanna. I yield back.
Gentleman yields back. correctly pronouncing acronyms is not my strong suit, so I'm sure you're right. Chair now recognizes Mr. Timmons from South Carolina.
Thank you, Mr. Chairman. I also want to thank Mr. Khanna for partnering with me on this important legislation. Today, I rise in favor of H.R. 10132, the Federal Agency Performance Act of 2024. If enacted, this legislation would hold federal agencies more accountable for their performance and ensure greater transparency in how they spend taxpayer dollars. The Government Performance and Results Modernization Act of 2010 already made significant reforms to improve agency performance outcomes. This bill builds on those reforms by adding new, proven practices that will deliver even better results. Specifically, the bill requires agencies to develop strategic plans for how taxpayer money should be spent. And just as importantly, it forces agency employees to report their progress toward achieving their goals. Agencies will also need to assess the risks that could prevent them from meeting those goals and put in place strategies to address those risks. By establishing a more rigorous strategic review process, improving access to publicly available data, and incorporating evidence-based activities into planning, we create a stronger framework for how taxpayer money is spent. This will lead to greater transparency and accountability for both government-wide and agency-specific performance goals. The Federal Agency Performance Act of 2024 also incorporates key recommendations from the Government Accountability Office, which advocates for a more comprehensive approach to planning and management in the federal government. It also codifies a success benchmark by requiring annual strategic reviews of each agency's priority goals. These reviews are essential, helping leadership focus on top-level objectives and ensure that we stay on track. As members of the Oversight Committee, it is our responsibility to protect taxpayer dollars from waste, fraud, and abuse. This bill takes an important step in establishing the guardrails needed to ensure government spending is efficient and effective while rooting out wasteful practices within our federal agencies. An identical version of this legislation unanimously passed the Senate in February, and I hope this body will soon follow. I urge all my colleagues to support this bipartisan legislation, which codifies practices that have proven to encourage greater transparency, accountability, and improve agency performance. And with that, Mr. Chairman, I yield back. Thank you.
The sponsor of the bill yields back. Do any other members wish to be heard? Seeing none, the question is now on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it. The amendment is agreed to. The question is now on favorably reporting H.R. 10132 as amended. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, chair recognizes Mr. Biggs.
I request a roll call, recorded vote.
A recorded vote is ordered by Mr. Biggs from Arizona. As previously announced, further proceedings on the question will be postponed. Our next item for consideration is H.R. 10155, the Financial Management Risk Reduction. The clerk will please designate the bill.
H.R. 10155, the Financial Management Risk Reduction Act, a bill to amend Section 7504 of Title 31, United States Code, to improve the single audit requirements.
Without objection, the bill should be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of a substitute. The clerk will please designate the amendment.
An amendment in the nature of a substitute to H.R. 10155 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for the purpose of further amendment. I now recognize myself for 5 minutes for a statement on the bill and the amendment. I support the Financial Management Risk Reduction Act of 2024, which will improve the quality and completeness of financial audit data of large federal grant recipients. If an entity receives a federal financial assistance from the federal government, we should be able to closely review their financial statements and expenditures of federal funds to ensure that every transaction is legitimate. The law requires that non-federal entities that receive more than $300,000 in federal awards annually undergo this close review, otherwise known as a financial single audit. Unfortunately, long-standing issues prevent efforts from identifying recipients that should have submitted a single audit but did not. Even more troubling, the Office of Management and Budget has not designated any entity to conduct a government-wide single audit quality check since 2007. Why is this important? For example, trillions of dollars of COVID-19 related financial assistance was distributed in many cases to first-time award recipients who were non-federal entities. The recipients were receiving substantial sums of federal funds that needed this oversight. Routine government-wide reviews of these audits is important to ensure the information is both reliable and useful, which in turn helps the agency officials monitor the spending of these federal dollars. Data is important, but having the right analytical tools to use this data is important too. H.R. 10-155 will require the development of these analytic tools to use this data to identify fraud risks across the government. Rather than waiting to find out that there are pervasive or severe issues with the use of federal financial assistance funds, the federal government should be proactive in identifying and addressing any issues. This bill will also target effectiveness. The bill includes a requirement for the Government Accountability Office, or GAO, to review the effectiveness of strategies and tools that come from these government-wide reviews. It also calls for an assessment of the reporting burdens for these auditors and audited entities. Lastly, the bill asks GAO to evaluate the responsiveness of the federal agencies to the finding of these audits. This holds them accountable. I want to thank Committee Member Marjorie Taylor Greene from Georgia for leading this bill in the House of Representatives. I urge my colleagues to support this sensible reform. I now recognize Ranking Member Raskin for his statement. This is...
Mr. Chairman, thank you very much. I am pleased to support this legislation, which would indeed improve the quality and usability of independent audit data and enhance oversight of federal funds. The Single Audit Act of 1984 requires federal grant recipients who get more than $750,000 to report an independent audit of their internal financial controls annually to the government. It sought to increase accountability while reducing burden on grant recipients by mandating one single consolidated audit rather than audits on a grant-by-grant basis. In 2022, over 40,000 state, local, tribal, and territorial governments and not-for-profits submitted single audits. The Financial Management Risk Reduction Act addresses recommendations made by the GAO, which were aimed at increasing the usability of single audit information to reduce federal financial management risk. The bill codifies certain portions of OMB's Uniform Grants Guidance, requiring agencies to conduct quality control reviews on its audits, and directs OMB to coordinate a government-wide audit quality review once every 6 years. Finally, the bill would direct OMB to create a government-wide strategy on financial risk regarding single audits and instructs GSA to create analytical tools to use single audit data more effectively. It's a good bill. It will improve the quality and accessibility of audit data. It will increase transparency and accountability of federal funds. I urge all of our colleagues to support it. I yield back.
Do any other members wish to be heard? The question is now on the amendment in the nature of a substitute. All those in favor signifying by saying aye. All those opposed signify by saying nay. In the opinion of the chair, the ayes have it. The amendment is agreed to. The question is now on favorably reporting H.R. 10155 as amended. All those in favor signify by saying aye.
Aye.
All the opposed signifying by saying no. In the opinion of the chair, the ayes have it.
Mr.
And the bill
Chairman,
is, yep.
I request a
sorry.
recorded vote.
A recorded vote is ordered. As previously announced, further proceedings on the question will be postponed. Our next item up for consideration is H.R. 162, the Freedom to Petition the Government Act. The clerk will designate the bill.
H.R. 10062, the Freedom to Petition the Government Act, a bill to amend Title 29 of the District of Columbia Official Code to treat meetings held with officials of the federal government which are held in the District of Columbia as activities not constituting doing business in the District of Columbia for purposes of determining whether organizations are required to register with the District of Columbia.
Without objection, the bill shall be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of a substitute. The clerk will designate the amendment.
An amendment in the nature of a substitute to H.R. 10062 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original for the text for the purposes of further amendment. I recognize myself for 5 minutes for a statement on the bill and the amendment. I'm happy to support H.R. 162, the Freedom to Petition the Government Act. The bill amends D.C. Code to ensure that nonprofit organizations who are headquartered outside of the District of Columbia are not considered to be doing business within the district if their work is only with the federal government. requiring nonprofits who are trying to petition their federal government on various issues to register with the district government opens them up to additional and unnecessary liabilities. It also creates a chilling effect for these nonprofits. The D.C. Attorney General has already tried exploiting this situation to investigate nonprofits whose only advocacy is with the federal, not the district government. These nonprofits have not availed themselves to the district, only to the federal offices they are meeting with. H.R. 162 fixes this problem by giving these nonprofit organizations the freedom to petition their government without threat of reprisal from a jurisdiction they would otherwise not be subject to. The fix is a win for free speech and for the various organizations that advocate in front of federal officials. I thank Representative Biggs for introducing this important legislation, and I encourage my colleagues to support it. I now yield to the ranking member for his opening statement.
Mr. Chairman, thank you very much. We were doing so well there in bill after bill. We had real bipartisan unity. Now I'm afraid I've got to oppose this one, which I can't say I fully understand yet, but it clearly looks like one more attempt to interfere in the local affairs of the people of the District of Columbia, which has been a favorite political target of some in the majority of this Congress. The majority's worked to overturn a variety of local D.C. laws and to put the home rule government, representing more than 700,000 tax-paying American citizens, in a straitjacket. And there are obviously some people who prefer to govern the District of Columbia directly as a colonial population rather than to grant its statehood petition. But let's look at what this so-called Freedom to Petition the Government Act does. The title suggests nicely that the bill's about protecting the rights to free speech, association, petition, and privacy. Of course, nobody's right to petition the government or to engage in free speech or association has been violated in any way, or at least nobody has explained how it has been. Businesses, both not-for-profit and for-profit businesses, have to register to do business in any state or in the District of Columbia where they do business, and that is not a violation of their First Amendment rights. In fact, the Supreme Court has repeatedly held that it's perfectly okay for a state or for Washington, D.C. to require businesses that are doing business there to register, even if they're lawfully incorporated in a different jurisdiction. So I'm not quite sure why this is getting blown up into a big First Amendment question. It might have something to do with an investigation that has reportedly been launched by the Attorney General for the District of Columbia into the business dealings of Leonard Leo and certain allied not-for-profit organizations. There was an article in Politico which said, what happens when an attorney general dares to investigate Leonard Leo's network? And the article began by saying, allies of Leonard Leo have mounted a months-long offensive against the man investigating the judicial activist network. And I think that may explain what this bill is about, but I would invite the legislative sponsors to really explain what's going on here. The District of Columbia, of course, is not unique in requiring business organizations, whether for-profit or not for-profit, to register when they're doing business in the jurisdiction. It's very hard to see why there should be some kind of exception carved out here. Anybody who does business in any state or in the District of Columbia should be subject to the laws of that state. And if any state or the District of Columbia is violating anybody's right to petition government or right to engage in First Amendment activity, then that should be struck down. But this looks like a little bit of a wolf in sheep's clothing, and so I'm going to oppose it and would invite you, Mr. Chairman, or the sponsor to explain what this is really all about and what's the genesis of this legislation. I yield back. Thanks.
Thank you. Do any other members wish to be heard? The chair recognizes Mr. Biggs.
Thanks, Mr. Chairman, and I appreciate this markup and for consideration of my bill, the Freedom to Petition the Government Act. Federal government officials, officials at the White House, at federal agencies, members of Congress, our staff, and others are constantly meeting with nonprofits to discuss their work. So let's clarify that. These are nonprofits. They're not just any corporate or sole proprietor. These are nonprofit organizations. And they're meeting solely with federal officials on federal property. That's what the bill says. I don't know why that's confusing to you. Anyway, we meet with them constantly. They want to talk about the impact of federal government action on it. These nonprofits must comply with existing federal law to maintain nonprofit status. Currently, District of Columbia law requires that a nonprofit not headquartered within the district must register with the district to hold meetings with members of Congress or other federal officials. That's what their law requires. DC Code requires a nonprofit to register when it is doing business within the district, even if that business has nothing to do with DC. That's like if they're going to meet with the representatives of the federal government on federal government property, they include that in there, which is why we actually tried to clarify that with the ANS, with negotiations with the DC government. So this bill opens this law opens these nonprofits to unnecessary, frivolous, and partisan investigation from the DC Attorney General. And that creates additional liabilities and a clear chilling effect for nonprofits that want to engage with the federal government. And by the way, we're not interfering with DC law. DC law is interfering with Americans' right to meet with their federal government officials. The Freedom to Petition the Government Act amends the DC Code to stop this practice. Nonprofits should be able to travel to the seat of our nation's capital to advocate, inquire, and engage with the federal government free of retribution from partisan efforts to stop such outreach. It explicitly states within the DC Code that nonprofits not headquartered in the district do not need to register with the district. That's what this bill does. This protects nonprofits from opening themselves up to overzealous investigations in a jurisdiction that would otherwise have no claim over these nonprofits' actions, which is very distinct from what the ranking member was describing. This provides these organizations the freedom to engage with federal officials, and I urge my colleagues to support this common sense legislation. And I would point out we have acceded to some of the requests of the DC officials, and that's reflected in the ANS. And so I'm not representing in any way that they support this. I'm just saying that we tried to meet them where they had concerns, and that's what the ANS is doing. And so I urge passage of this, and I yield back.
Will the gentleman yield for one question?
Happily.
Do you understand that the District of Columbia has the exact same law that exists in your state, in every other state, with respect to the requirement to register if you're doing business in the state? And that language doesn't mention Congress or lobbying anybody. It simply says that if you are a corporation from another state or a foreign corporation, you're doing business there, you've got to register. And that exists in Arizona.
Yeah, so I will respond and say this. Here's the deal. The federal government, the seat of federal government is not in Arizona. It's not in Maryland. It's here. And these non-government operations, they're coming here to meet, as we say in the bill, on federal property, to meet with federal officials.
If that's all they're doing,
that's what it says right there. So they would have no.
But they're not doing business. No. But in other words, they're not.
They are. But the bill, if you read the law, their current law, it does not provide that exception.
It doesn't need an exception if they're not.
Sure, it does, because that's what they're investigating. They chose to investigate Mr. Leo. Why?
If he has offices,
he did not have offices here.
He has no not-for-profit.
He had a post office box that he checked periodically. That's what you're saying is business.
Okay, well then I think that goes to the question of whether or not he's doing business.
That's correct.
Yeah.
And that's the point we're trying to clarify. And I agree that, I'm glad you agree that was the question in the Leo case. We're clarifying it now.
But why is that? Can you just explain why? Again, I'm just trying to find out, because this is the first I'm learning of this whole thing. Why do we need to intervene to pass a federal law about this? If they're not doing business in the District of Columbia, it shouldn't be an issue, right?
That is correct. It shouldn't be, but it has proven to be. And so you would say, your position would be, well, Leo was doing business. And my position would be, he wasn't
Well,
doing business.
I have no idea
And the
whether or
point-
not he was.
Well,
Is there a case on that? Is there a case that's been brought on it within the District of Columbia?
They brought action against him. So the point I'm trying to make to you is, basically you're kind of agreeing with me, I think.
I agree. If he's not doing business in the District of Columbia,
trying to provide clarity to saying, look, if you're coming in here and you want to meet with us and you're meeting on federal property, then why would DC even consider it has jurisdiction? And in the correspondence that we've had with the DC Attorney General, he was adamant that they did at first. I think he's kind of walked back away from that. That's one of the reasons I think it has to be clarified.
Okay.
Do any other members wish to be heard?
Mr. Chairman?
Ms. Norton first.
Oh, I'm sorry.
Ms. Norton, you're recognized.
I would like to start by asking unanimous consent to enter into the record a letter from D.C. Council Chairman Phil Mendelson opposing this bill.
Without objection, so ordered.
I strongly oppose this bill, which violates the District of Columbia's right to self-government. This bill amends a D.C. law to exempt certain business organizations doing business in D.C. from registering with D.C., even though each state requires business organizations, whether for-profit or non-profit, doing business in that state to register there. The intent of this bill is to reduce D.C.'s authority to apply its law to nonprofits that are formed under the laws of another jurisdiction doing business in D.C. Why would this committee amend D.C.'s business registration law, which is like the business registration law of each state? Contrary to Republicans' claims, this bill is not about the First Amendment, which, of course, no enforceable law can violate. There are two reasons for this bill. First, this committee has abused its undemocratic authority over D.C. more this Congress than in any time in at least 2 decades. This is the 8th bill this committee has marked up or brought directly to the floor to repeal or amend D.C. laws or regulations. These bills have ranged from stripping D.C. of its authority to increase criminal penalties to repealing a D.C. environmental regulation to amending D.C. public sector employment laws. Second, the D.C. Attorney General apparently did something this committee considers radical. He enforced D.C.'s Nonprofit Corporation Act. The D.C. Attorney General reportedly is investigating nonprofits affiliated with a conservative legal activist for misusing charitable funds for the activist's personal benefit. This bill is step 2 in this committee's response to the D.C. Attorney General's reported investigation. Step 1 occurred last year when this committee launched an investigation of the D.C. Attorney General's reported investigation. My Republican colleagues are correct that D.C. has the constitutional authority to legislate on D.C. matters, but they are wrong that Congress has a constitutional duty to do so. Legislation on D.C. matters is a choice. As the Supreme Court held in 1953, and I quote, "There is no constitutional barrier to the delegation by Congress to the District of Columbia of full legislative power," end quote. The Revolutionary War was fought to give consent to the government and end taxation without representation. Yet D.C. residents cannot consent to any action taken by Congress, whether on national or local DC matters and pay full federal taxes. Indeed, DC pays more federal taxes per capita than any state and more total federal taxes than 19 states. If House Republicans cared about democratic principles, they would bring my DC statehood bill, which gives DC residents voting representation in Congress and full local self-government to the floor. Congress has the constitutional authority to admit the state of Washington, D.C. It simply lacks the will to do so. I urge my colleagues to oppose this bill.
Do any other members wish to be heard?
Mr. Chairman.
Chair recognizes Mr. Cloud.
I'd yield my time to Mr. Biggs.
Thank you, Mr. Chairman, and thank you for yielding, Mr. Cloud. So let's talk about what was just read from one member of the D.C. Council. The council person, I don't know who it was, mentioned jurisdictions of other states, that other states require entities that are doing business in those states to register. We agree with that. That's what happens. D.C. does that. We're not taking that away. But one thing that they didn't mention in there is that we're talking about the federal government. And we're talking about where are those meetings taking place, what are these NGOs coming in to do, and they are dealing with federal officers. And when you, I want to read something here that I find intriguing from a letter from the D.C. Attorney General. This is his defense of this. Out-of-state nonprofits that choose to register and do business in the district enjoy a number of benefits by virtue of that choice, including unparalleled proximity to key players and decision-makers across the federal government, such as members of Congress and their staff. But here's the deal. If you are a foreign, non-government organization or a not-for-profit, and you're coming in and you want to visit with us, under the D.C. Code, that could be interpreted to be conducting business. And if that's the case, then you are chilling free speech. And you are chilling NGOs, not-for-profits coming in. That's the problem. I mean, because he's requiring registering.
Will the gentleman yield for a question?
Yeah.
Well, has that happened? In other words, is that I was not aware that the District of Columbia was interceding with not-for-profit corporations that just come to Washington for the purposes of meeting a member of Congress and saying you've got to register before you do that.
So he's claimed that authority essentially in the Leo case. So if you look at the Leo case, which even Politico, which broke that story, admits there was nothing there. It was rumor and innuendo, but he chose to investigate that, even though it looks like Mr. Leo and whatever his nonprofits are, and I don't know anything about his case, but they all seem to be located outside, and actually perhaps even based in Arlington. And he's chosen to investigate that. He's not defended that, saying, yeah, I think they're doing business here.
Can I just ask you two other questions about the scope of your bill, just to understand? I'm really trying to understand this. So, but one is the not-for-profit corporations that are, say, organized in Arizona or in Maryland may have to also go and talk to state legislatures as well. Should they be exempt from having to register in those states doing business? Why is it not written to deal with people who are going to the state capitals, in Annapolis or Albany or whatever?
So I think that becomes a state issue, and this D.C. is under the federal control of Congress. So let me just clarify additionally.
Yeah.
If I am, because I used to work with nonprofits in Phoenix. If we have to go to, say, let's say Dallas or something like that, we don't have to register in Dallas for me to go in and stop in and meet with them.
Right.
That's what we're saying.
But I'm not aware but is that the rule here? Because I hadn't heard any complaints about that happening.
Well, I think you should. I'm sure you're privy to the responses that the local AG gave to the letters written by Mr. Comer and Mr. Jordan, the two chairmen, and that colloquy through verse that they gave, through prose that they gave. But it looks to me like he is making the assertion that, that he could do that if they chose. And so that's why I think the bill's important. And if, by the way, if you don't think that's happening, then this bill will do no harm either. But the point is, if it is happening, which I would suggest to you, this Attorney General, at least in one case, potentially did that, then maybe we should intercede.
And if I could just ask one other question about the dimensions of the proposal. It says this applies to all entities, presumably under 501c, so that means 501c3, C4, C6, or is it just C3s?
You're talking about the ANS?
You're
talking about ANS.
Yeah, it looks like
it looks to me like it's all 501c.
Okay, so have we looked at the implications of that? If there's a C4, a C6?
If they're doing business, if they're not coming in, if they're actually conducting business here, I don't know that this statute is going to provide that exemption for them. That's
I guess in that it's the grammar of it that puzzles me when you say holding a meeting with a member of Congress. Does this only apply to those 501c organizations that are holding a meeting? Or is that sufficient to make them exempt to go and hold one meeting, even if they're doing other business in the District of Columbia?
Well, that's one of the reasons that we've limited it. It's because if they're conducting business here, we get it. We understand. But in reality, if they're trying to exercise fundamental rights, then the D.C. AG should not be investigating, prosecute, whatever you
Okay,
choose.
I would agree with this, and I would get on this if you just put the word only in there, only holding a meeting with a member of Congress, because that would be ridiculous.
Well, what about if you go to lunch with a member of Congress?
But only holding a meeting or having lunch with a member of Congress. I mean, I think having lunch would incorporate it. But what I don't want this to become suddenly like an escape hatch for people who are actually doing business here and saying, well, we did a meeting with a member of Congress, so now even though everybody would acknowledge we're doing business, we're suddenly exempt from the laws.
I think you're straining at a gnat.
I really don't think I am. I think I'm going right to the heart of it.
I don't think you are going to the heart of it. I think you're saying, because I think as the council member said, gee, this whole body's been out to get D.C. We're not out to get D.C. What I'm trying to do is protect, and we're trying to carve out protections for the D.C. government as well as for citizens to come petition the government.
But is holding a meeting enough to exempt someone from D.C. law with respect to registration, even if everybody would concede that they are also engaging in business?
I don't think so.
Okay.
I don't think so. I mean,
I think we got to rework the language.
So to that end, Mr. Chairman, I would ask a unanimous request that the two letters written by yourself and Chairman Jordan, as well as the two responses from the Attorney General from the District of Columbia, be admitted into the record.
Without objection.
And also, I would also request that Chapter 4 of the District of Columbia Code be admitted into the record as well.
Without objection, so ordered. Conclude. Chair recognizes Mr. Goldman.
Thank you. I'm going to follow up on the ranking member's questions because I do want to get down to the rub, because the appearance here is that the D.C. AG began an investigation into Leonard Leo and all of his various nonprofits because there were allegations that Mr. Leo was misusing the nonprofits for his personal gain. And I assume, Mr. Biggs, you agree that that is, if true, that's a valid basis for an investigation. Is that right?
By the appropriate authority, yeah.
Okay. So then you're saying that the D.C. Attorney General is not the appropriate authority because the D.C. Attorney General does not have jurisdiction or should not have jurisdiction if the nonprofit that they are investigating only has a drop box in the District of Columbia. Is that right?
Well, I mean, you've asked a compound question and asked me, is that right? What I would suggest to you is I think that's probably right.
All right, well, let me ask it this way then. Fine. Do you agree, does this bill, and I'm going to get to what Mr. Raskin was getting at here, does this bill, in your view, say that if a 501c organization has a meeting with the federal government or Congress, then there is no jurisdiction for the District of Columbia's Attorney General to conduct an investigation into that 501c organization, regardless of all of the other activity that 501c is doing?
I would disagree with your interpretation. We've defined, quite frankly, I think a minimal carve-out ultimately saying and intimating, this is not business. This is not doing business in D.C.
So you're saying that if you have a meeting or if you are addressing the federal government in some fashion, Congress, some other executive branch agency, that does not qualify as jurisdiction. That's what this bill does. It says that if that is the conduct you are doing in D.C., then that does not qualify, that does not satisfy D.C.'s jurisdiction to investigate.
Yeah, I'm looking and I'm comparing it to 29105.05 of the D.C. Code. And we're saying, if you're here, and you notice we just said holding meetings with members of Congress, that doesn't constitute under 29105.05 the activity for which you should be required to register with the District of Columbia.
Okay, what happens if a 501c has a meeting with another 501c that is in D.C., headquartered in D.C., perhaps gives money to that other 501c in D.C., and then separately goes and has a meeting with Mr. Biggs about something else? Does D.C. have jurisdiction over that 501c?
Well, let's. It's really that's a baffling question, and you truly have a dizzying interpretation of this. I'll tell you. What we've done is we've carved out a spot, and we've said, if you're going there for meetings with members of Congress, their staff, if you're meeting on federal property, you don't fall within the jurisdiction. And what you're saying is, if they come in here and they're actually conducting business, other business, well, that's a different animal, isn't it? Do you think it's a different animal?
I don't think this bill makes it clear. I think this bill allows for stripping jurisdiction.
And
the way it's written, it allows for stripping jurisdiction of any organization, any 501c organization that has a meeting with Congress, regardless of whether they're doing other business in D.C. And that's why Mr. Raskin's suggestion that you say will strip jurisdiction if your only business in D.C. is meeting with the federal government, that's one thing, but that's not what this bill says. So if you want to clarify that, I will happily support that.
Well, so
the problem is this is...
Would the gentleman yield?
No, one minute. I'm just finishing up my time. I'm happy to continue. But the problem with this bill is what you are doing, and what is very clear that you're doing based on Chairman Comer and Chairman Jordan's letters, is you are trying to interfere and intervene in an ongoing investigation by the D.C. Attorney General into the Republicans' biggest benefactor. And when we talk about the weaponization of government, the idea that the federal government would try to interfere and intervene and supersede an investigation based on very vague language, when we all know that Mr. Leo does a lot more than meet with federal government officials and that all of his organizations do a lot more business in Washington than meet with Congress, you are trying to backdoor in a way to strip jurisdiction over Leonard Leo by the D.C. Attorney General by including very vague language that can be interpreted to say, as long as you're meeting with Congress, you have one meeting. If you have 100 meetings with other people, it doesn't matter. You're exempt from jurisdiction. And that's the problem with this bill. And I yield back.
Chair recognizes Ms. Boebert.
I yield to my colleague from Arizona, Andy Biggs.
I thank the gentlelady for yielding. I find myself, I felt we were having some kind of rational colloquy there until we kind of left the universe here, and now we're wandering in space. I'm going to try to bring us back down and say, I happen to have the code here. I encourage you to read the code, because the way we've crafted this language is, if you're here for a fly-in, doggone it, then the DCAG doesn't have jurisdiction over you, okay? That's the point. Well, you guys are trying to come up with every nefarious thing and every rationale you can possibly come up with and say, well, gee, we got to expand this language. This is a very simple, straightforward language. It says, if you're having a meeting, that's not conducting business in D.C. But the ordinance defines all kinds of other stuff that's business. We didn't touch that other stuff. We touched if you're coming in for a fly-in to meet with Moskowitz or anybody, particularly Moskowitz. In particular, we're thinking about that. You're protected from investigation hassle from the DCAG. You don't have to register with him. But if you're conducting business, we haven't touched you. That's what's baffling to me.
Will the gentleman yield?
Well, you have to ask the gentlelady. It's her time.
Thank you, Ms. Boebert. You're avoiding the question, Mr. Biggs, and it seems intentional. And the reason why we are skeptical over here is that Mr. Leo has declared he's not cooperating with the investigation. Chairman Comer and Chairman Jordan have tried to intervene and interfere in this investigation. And now we have a jurisdiction-stripping bill in the Oversight Committee that is clearly directly related to this investigation. So please spare me the outrage that we are skeptical given the timeline here. But the question I have for you is, as you interpret this bill, if you're saying a fly-in is exempt from jurisdiction, you don't have to register. If somebody does a fly-in and also satisfies one of those other elements of the code that would establish doing business in D.C., does that organization still have to register because of that other conduct, separate and apart from the fly-in?
That's the way I interpret it. That's why I said if you read the ordinance, you'll get a pretty good idea how they're attacking registration for business activities. We're simply saying, you're here, you're having a meeting with members of Congress. That's not a business activity. Now, if you go out and you start conducting other business, then there's nothing in here that protects you from that jurisdiction. We're not stripping jurisdiction. We are trying to refine and define and protect fundamental civil rights to speak out and meet with and petition your government. That's what we're trying to protect.
And by the way,
I'm not outraged. I'm happy to have the colloquy. I think it's fine. It's good. But if you're saying that you don't trust me, that's fine too. But for all of you guys who are on the other side now saying, oh gosh, we have to have bipartisanship, we have to have trust, I'm telling you what I think this bill does. I'm telling you why we did it. And you are approaching it with this massive amount of skepticism, and that's fine because we have a history of skepticism, particularly in this committee. But if we're ever going to get past it, at some point you got to say, well, this really doesn't do everything we say. We could create every hypothetical in the world because we're a bunch of stinking lawyers who went to law school. We spend all of our time getting hypotheticals all the time. But the bottom line is we're saying, look, you're coming in, you're meeting with a member of Congress. For purposes of the D.C. Code, which we otherwise are holding harmless, that doesn't constitute doing business in the district. That's the point.
Will the gentlelady yield?
The gentlelady needs to yield.
I appreciate that. The skepticism is because laws are interpreted and they are implemented. And so you have to consider hypotheticals to anticipate how they will be interpreted and implemented. And the concern I have here is if what this bill is actually intending to do what you say it is, A, it's not written clearly, and B, it would not accomplish the goals of Chairman Comer and Chairman Jordan, because it would almost certainly not strip jurisdiction from the D.C. Attorney General against Leonard Leo.
Reclaiming Boebert's time, Ms. Boebert's time, I'll say, and you've just undercut your whole stinking argument where you've developed your skepticism, because I wouldn't protect Leonard Leo with this. What we're doing is we're protecting the people who are flying in from any kind of overreach on the part of the D.C. AG. That's the point.
Is there an example of that you can cite of that happening?
Well, then if you can't find an example, then why do you care? Because then it's no harm, no foul.
Well, I'm asking you, is there an actual example of somebody, of the D.C. Attorney General doing an investigation of a 501c that's only business and only contact with Washington, D.C. is to fly in to meet with a member of Congress?
I would refer you to the responses of the DCAG to the letters from Mr. Comer, or Chairman Comer and Chairman Jordan, where, at least the way I interpret it, he's implying that he has that authority.
Okay.
Well, it is weird.
Ms. Boebert's time's expired. Mr. Moskowitz.
Thank you, Mr. Chairman. First of all, I think this is healthy, right, having a discussion about a bill. I think that's the whole point of workshopping things. So just to go back to Ranking Member Raskin's question, which I think you're answering. I think we just want it to be just a tiny bit clearer. Because obviously legislative intent is part of the record. So your intent, and you believe the language, is not an exemption if you're doing business in D.C.
That's the way. That's correct.
Okay, yeah, that's what we want to hear. It's not an exemption, right? So coming in and meeting with a member, right, if you do business in D.C. is not an exemption.
That's correct. Because you would still be subject to the code, because the only thing that would not be doing business. So we're just basically saying you're not doing business pursuant to the D.C. code if you're meeting with members of Congress or the staff.
Perfect. So I'll say it in reverse. If you don't do business in D.C., coming and meeting with a member of Congress doesn't give D.C. jurisdiction.
Correct.
Okay.
If the gentleman would yield. Thank you very much. I actually think we've made tremendous progress here, because I think substantively we agree. I think we're converging around the idea that a not-for-profit that's incorporated elsewhere doesn't, quote, do business in the District of Columbia simply because there's a meeting with a member of Congress or, as you've said, another federal representative or employee. If you come in to meet with the IRS, you come in to meet with the Department of State, that doesn't turn you into someone doing business in the District of Columbia. I think that the language is a bit inartful, so it could be open to different available interpretations, but, I would be prepared to support that idea if we could, work that language out more specifically, despite the fact that it's not clear that it's necessary, but I think we all would agree to that.
So I think if you would yield, Mr. Moskowitz. Yeah. So the language we have here was developed in consultation with the mayor's office. That's how we ended up with that specific, which is, I can't see it without my glasses. Yeah. 11. It's bracketed 11. So that language itself was developed in consultation with the mayor's office, which is why it says what it says.
I mean, given the legislative history that's involved in this conversation, I really have no particular problem with it. I don't quite see its necessity, but there's a lot of stuff around here that's not necessary.
Yeah.
I wouldn't fight it. I don't know that I would support it because I don't see it as being necessary, but I like your clarifying explanation that it's just the activity of holding a meeting itself does not confer the status of doing business in the District of Columbia.
That's correct.
All right, and I yield back. Thank you, Mr. Moss.
Mr. Moskowitz, may I yield? I want to just clarify that this is part of the reason of the skepticism, is that if that is the intent of the bill, it is a useless bill. It is redundant, it is unnecessary, because I don't think anyone can cite a particular case or investigation that hinges on jurisdiction based solely on one fly-in or one meeting with Congress or one meeting with the federal government. And that's where the skepticism becomes, is that it's unusual to write a law to address something that is not a problem, where a problem doesn't exist. And if you are making clear that jurisdiction is not conferred based on only a meeting with Congress or the federal government, I don't have objection to that. If what this bill says, and this is where it's not clear, that if you have a meeting with Congress or the federal government, then it exempts you from jurisdiction, that would mean that entities that do lots of business in Washington, D.C., and also have a meeting in Congress no longer are subject to the jurisdiction of Washington, D.C. And that obviously would be a very problematic bill. So I urge you to correct and clarify that, Mr. Biggs, and I don't think you will get a lot of objection because it's not clear in the bill.
I can be loud without the microphone. You mentioned something about the mayor's office. Can you expand about that? Did you work with the mayor's office?
Our staff did, yes, that's correct.
Okay. Giving you the rest.
Okay, thanks. The statement was made that we don't normally get ahead of issues. So I'd say word number one, we're getting ahead of issues. Number two, who around here has been around here a little while and hasn't seen superfluous bills come to the floor? Now, I'm not saying this bill's superfluous. I'm just saying that's not a reason not to support the bill. Third thing is, I'll give you an example, because we are amending the code section, which is entitled "Activities Not Constituting Doing Business," which is why it's worded or framed the way it is. It may not be artful necessarily, but that's why I think it came up the way it was. But let me give you an example one. It isn't, if you're solely maintaining accounts in financial institutions, you're not doing business here. Does anybody find issue with that was superfluous? And that's the point I'm trying to make ultimately is, I think it is necessary, and it is clarifying. And I think, and I would offer this to the ranking member, if at the conclusion of the day, if this is moving forward, I'm happy to sit down and craft more artful language, if that's something that the ranking member would like to do. So with that, I'll yield back to Mr. Moskowitz.
Mr. Moskowitz's time has expired. Any other members seek recognition? Mr. Mfume. Oh, yeah, Mr. Mfume.
Thank you, Mr. Chairman. I'm going to cast all caution to the wind and extend this colloquy just a little longer, but I'd like to extend it. I'd like to extend it by yielding my time to my Marylander on this committee, my colleague who is the ranking member, so that he might, in fact, have the last word to conclude his position. I yield to Mr. Raskin.
Okay. Thank you very much, Mr. Mfume, for that. And I really have nothing to add. I appreciate the comments of the gentleman from Arizona. I think that we've arrived at substantive agreement on this. I think we probably differ only as to the necessity of passing it at this point, but I'm happy to engage in further discussion with you about that, and I'm happy to yield back to the distinguished gentleman from Baltimore.
Thank you very much, Mr. Chairman. All's well that ends well. I yield.
All right. Any other members seek recognition? Seeing none, the question is now on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it. The amendment is agreed to. Now the question is on favorably reporting H.R. 162 as amended. All those in favor signify by saying aye. Aye. All those opposed signify by saying no.
Mr. Chairman.
Chair recognizes.
Request a recorded vote, please.
A recorded vote is ordered by Mr. Biggs from Arizona, as previously announced. Further proceedings on the question will be postponed. Our next item for consideration is H.R. 8690, the Stop Secret Spending Act of 2024. The clerk will please designate the bill.
H.R. 8690, the Stop Secret Spending Act of 2024, a bill to amend the Federal Funding Accountability and Transparency Act of 2006 to ensure that other transaction agreements are reported to usaspending.gov and for other purposes.
Without objection, the bill shall be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of a substitute. The clerk please designate the amendment.
An amendment in the nature of a substitute to H.R. 8690 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for the purpose of further amendment. I recognize myself for 5 minutes for statement on the bill and the amendment. I support the Stop Secret Spending Act of 2024, which requires federal agencies to report complete and accurate information on usaspending.gov for how they spend appropriated funds. Since 2006, agencies have been required to be more transparent with how they are spending taxpayer dollars. The Federal Funding Accountability and Transparency Act, and later amended by the Data Act of 2014, established usaspending.gov, a public database of all government spending. This transparency is critical because it ensures the American people that agencies are using their hard-earned money appropriately. Unfortunately, over the years, we have found that there are gaps in usaspending.gov. Agencies more and more have been utilizing authorities for contracting mechanisms known as other transaction agreements, or OTAs. OTAs are not subject to certain federal acquisition laws and requirements, and most importantly, are not required to be reported to usaspending.gov under current law. The Government Accountability Office has found that agencies use different methods to report the billions in spending related to OTAs. However, it is unknown if they are reporting consistently or if this information is even complete. That means we do not have full transparency over how billions of dollars are spent by federal agencies. This bill corrects that issue by requiring OTA spending be reported to usaspending.gov under Data Act. The bill also requires agencies to report annually on funds that previously were unreported for a variety of exemptions. Agencies will need to report the amounts and reasons why these appropriated dollars were not reported. This provides more transparency to the public and allows all of us to hold these agencies accountable. Lastly, this bill restores the requirement for agency inspectors general to review the entirety of data submitted by usaspending.gov to ensure that it is complete and accurate. Transparency does not mean anything if the information isn't complete or accurate. This bill will ensure that information will be both complete and accurate. I thank Representatives Barry Moore and Jimmy Panetta for leading this bill in the House of Representatives. I urge my colleagues to support this common sense bill. I now yield to the ranking member.
Thank you, Mr. Chairman, and thanks to Representatives Moore and Panetta for their strong bipartisan work on this bill, and to Senator Ernst for her work on the Senate companion. usaspending.gov, the official source of government spending data, is a public database of federal agencies' direct expenditures, displaying federal contract, grant, loan, and other financial assistance awards totaling more than $25,000. Prime contract recipients are required to report details on their first-tier sub-recipient awards. The website is maintained by the Department of the Treasury. It provides accurate, consistent, reliable, and searchable data so the public can trace the use of our taxpayer dollars. However, agency reporting requirements are ambiguous when it comes to reporting so-called other transaction agreements, OTAs, which are legally binding agreements that are considered different from standard federal contracts and grants. A GAO review found over $40 billion in agency OTAs from fiscal year 2020 through 2022 that were therefore not reported on usaspending.gov. H.R. 8690 would enact a GAO recommendation to require agencies to include these OTAs in their reports to usaspending.gov, taking a big step towards making the public record of federal spending far more complete. H.R. 8690 would require the DOT to report, the Treasury Department to report annually on the total federal spending on awards for which data has not been posted on usaspending.gov, as well as the reason such data has not been posted. It would implement 2 more GAO recommendations, including requiring Treasury, OMB, and other agencies to ensure that usaspending.gov data is complete and accurate, and requiring Treasury and OMB to periodically assess and determine which agencies have to report data to the usaspending.gov website. The public deserves transparency and accountability in how our tax dollars are being spent. This bill would strengthen accountability and transparency and empower usaspending.gov to further meet its mission. I encourage all of our colleagues to support this bipartisan legislation. I yield back to you, Mr. Chairman.
Do any members seek recognition on the bill? Seeing none, the question is now on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed by saying no. In the opinion of the chair, the ayes have it. The amendment is agreed to. The question is now on favorably reporting H.R. 8690 as amended. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. Chair recognizes Mr. Biggs.
I request a roll call, please.
A recorded vote is ordered by Mr. Biggs. As previously announced, further proceedings on the question will be postponed. Our next item for consideration is H.R. 9040, the Taxpayer Exposure Risk Reduction Act. The clerk will please designate the bill.
H.R. 9040, the Taxpayer Exposure Risk Reduction Act, a bill to require covered agencies to issue strategy and implementation plans for the transfer of credit, guarantee, and insurance risk to the private sector, and to require the implementation of such plans and for other purposes.
Without objection, the bill shall be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of a substitute. The clerk will please designate the amendment.
An amendment in the nature of a substitute to H.R. 9040 is offered by Mr. Comer of
Without
Kentucky.
objection, the amendment is considered as read, and the substitute will be considered as original text for the purposes of further amendment. I now recognize myself for 5 minutes on the statement on the bill. Currently, the federal government manages nearly 148 federal programs or activities that put federal agencies at risk of bearing financial losses. Inherently, these financial risks are assumed by the American taxpayer and create uncertainty when budgeting for dramatic costs arising from unpredictable covered events. Rarely do federal agencies explore the potential budgetary benefits of shifting some of these costs to the private sector, which specializes in managing these financial risks. As a result, American taxpayers are left suddenly footing the entire cost of activities ranging from managing mortgage financing to student loans to crop insurance. Mr. Donald's and Mr. Kristamorte's Taxpayer Exposure Risk Reduction Act would direct federal agencies to assess the budgetary and cost-saving potential of transferring risk to the private sector. Agencies would then publicly report the findings of these assessments. The bill would provide implementation authority for them to do so in instances where such transfers do not increase costs to the federal government or program beneficiaries. H.R. 9040 represents a creative, straightforward effort to improve government budgeting and efficiency. I thank the sponsors for introducing the bill, the sponsors, Mr. Donalds and Kristamorte, and I now recognize the ranking member for his statement.
Thank you, Mr. Chairman. Regrettably, I've got to oppose H.R. 9040, the so-called Taxpayer Exposure Risk Reduction Act. This is a staggeringly broad and momentous bill that would make dramatic changes to how federal agencies manage financial risk, allowing public agencies to transfer credit risk to the private sector. And obviously, the private sector is not doing this on an altruistic, not-for-profit, philanthropic basis. The private sector is only going to be involved if they believe that there's profit to be made in doing this. Now, federal risk guarantees exist in a number of areas and agencies, including home mortgages, college student debt, farm business loans, small business loans, and disaster insurance. None of those areas, Mr. Chairman, are within the jurisdiction of this committee, and we haven't had a single hearing on this extremely complicated bill that could have sweeping economic and fiscal consequences, whether or not they're intended. The federal government also directly assumes risk in certain insurance programs and federal pension programs, making it the policy of the federal government to transfer credit, guarantee, or insurance risk to the private sector is a massive change and raises very complex concerns about this one-size-fits-all master approach to addressing insurance and government programs. I want to ask unanimous consent that a letter from a number of concerned groups, including Americans for Financial Reform and the Center for Responsible Lending and others, describing their concerns with this legislation to be entered into the record.
Without objection, so ordered.
The authors of the letter argue that this mandate would put Wall Street in the driver's seat in the rollout, access, pricing, and servicing of critical federal guarantee programs ranging from home mortgage lending to small business and farm loans, and could result in significantly increased costs for taxpayers and diminished or more expensive access to credit for American citizens, families, farms, and small businesses. Transferring credit risk to the private sector does not necessarily minimize the cost of such risk to the taxpayers. The private sector obviously must be compensated to accept the credit risk. And I don't think we know the first thing about the market of that risk, and we have not looked at historical analogies to doing this. In times of financial recession and stress, I know that private sector guarantors are far more likely to be unable to execute on their credit guarantees than the federal government is. Experience has shown that in times of economic stress, investors far more prefer to deal with the government, and private sector guarantors may simply fail to be able to deliver on credit guarantees. A number of striking examples of this, of course, occurred during the 2007 to 2009 financial crisis. At the very least, Mr. Chairman, I would say this is a subject that should not be rushed through in some kind of hasty way. We need to have serious hearings about this, along with the committees of substantive jurisdiction over all of the specific questions like home mortgages, college student debt, small business loans, the farm sector, and so on. So I'm not prepared to gamble on this approach right now, and I would strongly oppose H.R. 9040, the Taxpayer Exposure Risk Reduction Act. And I'm happy to yield back to you.
Gentleman yields back. I would like to ask unanimous consent to enter into the record a letter from the Council of Insurance Agents and Brokers and Reinsurance Association of America addressed to myself and Mr. Raskin in support of the Donalds-Cristomorte bill. Without objection, so ordered. Do any other members seek recognition? Chair recognizes the sponsor of the bill, Mr. Donalds from Florida.
Thank you, Chairman, for convening this important markup today. I appreciate your leadership in addressing the critical issue of reducing taxpayer exposure to financial risks while maintaining a balanced and effective approach to risk management. The Taxpayer Exposure Act represents a thoughtful step forward in identifying and mitigating obstacles that place undue financial burdens on taxpayers. This legislation aims to enhance the efficiency and stability of federal credit, guarantee, and insurance programs while transferring risks to the private sector where feasible, ensuring that taxpayers ultimately benefit. This bill builds upon successful models already in practice, such as FEMA's National Flood Insurance Program, the Federal Housing Finance Agency credit risk transfer programs with Fannie Mae and Freddie Mac, and the Export-Import Bank's initiatives. By requiring federal agencies to develop and implement robust strategies for transferring risk, we empower these programs to operate more effectively while reducing costs to taxpayers. This legislation strikes the right balance between prudent financial management and the essential support these programs provide to communities and industries nationwide. I look forward to discussing this proposal forward, working with my colleagues to advance this important legislation. Again, Chairman, I want to thank you for your dedication to this issue. Additionally, I would like to thank Congressman Krishnamurthy for his valued work on this bill, and I yield back.
The sponsor of the bill yields back. Do any other members seek recognition? Seeing none, the question is now on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. The question is now in favor.
Could I request a roll call vote on that?
Yeah, well, we got one more. Yeah,
Okay,
you want to
yeah.
request it on the full bill, right?
Yeah,
That was the
yeah.
substitute.
Oh, that was-
Okay. Yeah. The question is now in favorably reporting H.R. 9040 as amended. All those in favor signify by saying aye. Aye. All those opposed signify by saying no.
No.
Recorded vote has been requested by Mr. Raskin. As previously announced, further proceedings on the question will be postponed. Our next item for consideration is H.R. 10151, the Modernizing Data Practices to Improve Government Act. The clerk will please designate the bill.
H.R. 10151, the Modernizing Data Practices to Improve Government Act, a bill to amend Title 44, United States Code, to modernize data practices to improve government and for other purposes.
Without objection, the bill shall be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of substitute. The clerk please designate the amendment.
An amendment in the nature of a substitute to H.R. 10151 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for the purposes of further amendment. I recognize myself for 5 minutes for a statement on the bill. Data is the backbone of modern technologies, like artificial intelligence, which are being used to improve federal government processes, save taxpayer dollars, and increase oversight and accountability of federal agencies. Federal agencies should be encouraged to use these emerging technologies when appropriate and with the necessary safeguards to benefit everyday Americans. However, these tools are only as good as the data that informs them, which is why the federal government needs a coordinated effort towards data management and governance. In 2019, Congress established the Chief Data Officer, or CDO, Council to promote data sharing between agencies and further data-driven decision-making at agencies. Data is not going anywhere. It's increasingly the most valuable asset of organizations across the world. In fact, some have argued that data is the new oil, the most valuable resource on the planet. That's why I'm excited to support the Modernizing Data Practices to Improve Government Act, which has been brought forward by Representatives Summer Lee and Nancy Mace, as well as Senators Gary Peters and Todd Young. This bipartisan legislation reauthorizes the federal government's leading coordination body on this increasingly valuable resource, the CDO Council. To ensure this is done responsibly, a senior agency official for privacy is added to the council to make the privacy and security of the American people central to government-wide data policies. In doing so, agencies will be better equipped to establish safeguards that prevent inappropriate disclosure of personally identifiable information in publicly available data. Data management challenges are not new, but the effects of their failures are more pronounced in the age of AI and emerging technologies. So, we must ensure the federal government's use of AI will benefit the American people in a way that fosters public trust and upholds American values. It is necessary to ensure that the data leadership of federal agencies have a clear role in helping inform the adoptions and responsible use of emerging technologies like AI. The Modernizing Data Practices to Improve Government Act provides this assurance. Again, I thank Representatives Summer Lee and Nancy Mace for their work on this important issue. I urge my colleagues to support this timely, important piece of legislation. I yield to the ranking member for his opening statement.
Thanks much, Mr. Chairman, for bringing this good government bill before the committee today, and thanks again to Summer Lee and Representative Mace for their leadership. The Foundations for Evidence-Based Policymaking Act of 2018 established the Chief Data Officer Council, or the CDO Council, to improve the way that the federal government manages, uses, protects, disseminates, and generates data in our decision-making and operations. Since its inception, the Council has undertaken significant work to ensure that federal agencies use data to direct, streamline, and to enhance the transparency of government programs and services. Congresswoman Lee's excellent bill would extend the CDO Council's authorization for 7 years from the date of enactment, ensuring that the work continues. It also updates the Council's purpose and functions to include a direct focus on data governance in order to improve data collection and use, ensure the transparency and quality of public data assets, and better support the reliable and secure use of emerging technology and AI. Additionally, the bill would amend the Council's reporting requirements, directing it to provide a biennial report to Congress and OMB on its progress in establishing the government-wide best practices for data governance, promoting interagency data sharing agreements, supporting agency use of evidence in policymaking, and improving access to federal data assets. Data is a crucial strategic asset, and this bill will help ensure that the federal government continues to leverage this asset for the good of the entire public. I'm happy to support it, and I encourage all colleagues to do the same. I yield back to you, Mr. Chairman.
Gentleman yields back. I ask unanimous consent to enter the following letter of support into the record, a letter from Data Foundation in support of the legislation. Without objection, so ordered. Do any members wish to be heard? Chair recognizes the sponsor of the bill, Ms. Lee from Pennsylvania.
Thank you, Chairman Comer and Ranking Member Raskin. I'm happy to speak today about my legislation, the Modernizing Data Practices to Improve Government Act, a bill rooted in a simple concept. Our government works best when it makes evidence-based decisions. That starts with having high-quality, reliable data and the tools to evaluate and use it effectively. For many, the idea of building a data-driven culture within the federal government might sound abstract or unrelated to everyday life, but that couldn't be further from the truth. Data isn't just numbers on a spreadsheet. It's how the federal government makes smarter decisions, improves services, and ensures resources reach the people who need them most. It's how agencies anticipate challenges and create policies that reflect the realities of the communities we serve. When our federal agencies fail to use data and make evidence-backed decisions, we risk making uninformed choices. And that's why the Chief Data Officer Council has been such a critical resource for federal agencies. Since its creation in 2018, the CDO Council has helped federal agencies treat data as a strategic asset and improve how they govern and use it. But as we move forward into the age of artificial intelligence and other emerging technologies, the stakes and challenges are higher than ever. A 2023 survey from the Data Foundation found that more than 55% of federal chief data officers are already using AI, and 95% plan to adopt it within the next year. Yet nearly half of these CDOs cited the lack of clear guidance as one of the biggest barriers to using AI responsibly. High-quality data and smart data practices are the foundation of any successful AI system. When federal agencies use AI responsibly, it can improve efficiency, foster innovation, reduce waste, and better meet the needs of people. But without strong data governance, poor quality data doesn't just create inefficiencies. It amplifies risk, deepens inequities, and undermines trust in public institutions. As the CDO Council approaches its 2025 sunset date, its role has never been more critical. The Modernizing Data Practices to Improve Government Act extends the Council's authority for 7 more years, enabling it to continue supporting federal agencies and establishing the data protections and governance needed for the responsible adoption of AI and other emerging technologies. This bill also requires the CDO Council to report to the Office of Management and Budget and Congress on key data governance challenges, including strategies to mitigate risk posed by emerging technologies, assessments of barriers to their adoption across agencies, and guidelines for the ethical use of synthetic data. Additionally, it directs OMB to recommend ways to clarify and enhance the roles of chief data officers, equipping them with the tools, resources, and expertise they need to strengthen federal data practices and ensure responsible use of AI. At a time when Congress is rightly focused on building up our public AI ecosystem through investments like the CHIPS and Science Act, we cannot overlook the importance of building strong data governance practices to make these technologies work. Without reliable, high-quality data, even the best intentions behind AI tools can fall short. This bill ensures we're not just chasing innovation, but creating the solid foundation needed for innovation to succeed and serve people equitably. I want to thank the Chairman of Homeland Security and Governmental Affairs Committee, Gary Peters, and Senator Todd Young for their bipartisan leadership on this issue in the Senate, as well as the Subcommittee on Cybersecurity, Information Technology, and Government Innovation, Chairwoman, for her support. I look forward to working with the committee to advance this bill, and I yield back.
The sponsor of the bill yields back. Any other members seek recognition? Seeing none.
Morning.
The question is now on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it. The amendment is agreed to. The question is now on favorably reporting H.R. 10151 as amended. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the
Mr.
chair,
Chairman.
the ayes have it. Chair recognizes Mr. Biggs.
Request a recorded vote,
A
please.
recorded vote has been requested by Mr. Biggs from Arizona, as previously announced. Further proceedings on the question will be postponed. Our next item for consideration is H.R. 8706, the Dismantle DEI Act. The clerk will please designate the bill.
H.R. 8706, the Dismantle DEI Act, a bill to ensure equal protection of the law, to prevent racism in the federal government, and for other purposes.
Without objection, the bill shall be considered as read and open for amendment at any point. Without objection, so ordered. Chair recognizes himself to offer an amendment in the nature of a substitute. The clerk please designate the amendment.
An amendment in the nature of a substitute to H.R. 8706 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read. The substitute will be considered as regional text for the purpose of further amendment. I now recognize myself for 5 minutes for a statement on the bill and the amendment. The Biden-Harris administration has forced DEI initiatives into nearly every agency and program within the federal government. DEI initiatives destroy morale, decrease recruitment, and potentially violate federal law. These initiatives spread divisive and exclusive ideologies in our federal government workplaces, and taxpayers are left footing the bill. For these reasons, I support the Dismantle DEI Act. H.R. 8706 aims to repeal the federal DEI programs across the federal government. This bill prohibits funding for such programs and creates a new Civil Rights Act protection against requiring individuals to participate in such programs. The bill will lend legislative support to the incoming Trump administration's efforts to eradicate the Biden-Harris administration's entrenchment of leftist DEI policies in the executive branch. I urge my colleagues to support this necessary bill. I now recognize the ranking member for his statement on the bill.
Thank you very much, Mr. Chairman, for recognizing me. I strongly oppose the so-called Dismantle DEI Act of 2024, and I confess that I'm really baffled as to where it's coming from or what it means. It directly overturns 5 or 6 different executive orders by President Biden. I don't have time to go through all of the executive orders that would become roadkill under this legislation, but let's just take one of them, which simply says that there should be equity in hiring for people who belong to communities who have traditionally faced systematic denial of equal treatment under the law. And then illustratively, it identifies disabled people, people who have faced discrimination based on their religion, people who live in rural communities in the country, veterans and military spouses, people from communities of color, individuals from communities that have faced discrimination based on sexual orientation and gender identity, people who face discrimination based on their status as students or not students, people who have limited English proficiency, and pregnant women, as well as people who face discrimination based on older age. Now look, the Biden-Harris administration, as you say, has made it a priority to bring in more veterans, military spouses, people living in rural communities, people who are parents, older Americans, people who have faced discrimination, and so on. That's because we're a lot stronger when we include everybody. That's what I understand these efforts are all about. A federal workforce that actually reflects the diversity of our country makes us stronger. And the largest employer in the United States has a responsibility to lead the way and to model what it means to be open to everybody. We know of our history where lots of the groups that I just mentioned were by law or by custom or simply by discrimination excluded from participation in the federal workforce. And we know that that's been true of African Americans. We know it's been true of Asian Americans. We know it's been true of Hispanic Americans. There's been discrimination against pregnant women, and so on. So all these executive orders do is to articulate a policy that's based on federal law now, because it's against the law to discriminate on the basis of all of those different categories that I mentioned. Now, that's my first serious objection I have looking at this legislation, which I don't believe we've had a hearing on. Please correct me if I'm wrong, but I don't think there's been a hearing on it. here's my second major problem with it. It not only says we're going to dismantle any effort that's taking place in every agency and department of the federal government to make sure that hiring is taking place consistent with American law and American values, but then it says anybody who was working in one of those offices suddenly becomes ineligible to be rehired or reassigned anywhere else in the federal government. I've never seen something like that. I mean, but, we can have the policy debate about whether or not it's, good to have an HR effort that opens the doors to everybody and consciously tries to do that. But if you decide that you want to do a U-turn on what the Biden-Harris administration has done, I just don't see how you can turn it into a permanent scarlet letter for people who were assigned to those offices or who went to work in those offices to never get a job again in the federal government. I mean, that's remarkable. That comes very close to being a bill of attainder in the Constitution. I know a bill of attainder applies only to affixing a criminal stigma or penalty to someone. This affixes a professional stigma or penalty, a real scarlet letter to somebody who's just been doing their job. They might have been doing a great job at it, but suddenly we're declaring them a pariah, someone who is in exile from the federal workforce that they may have given 5, 10, 15, 18, 20 years to. That just makes no sense, and I would love to have somebody explain the logic of doing that. Imagine a veteran, say who's a doctor, I know someone who's a doctor, who then, in the VA, who then goes to work in a diversity office to make sure that the VA is hiring diverse members from the field of veterans in the country. Well, now we're saying we're going to close down your office, we're going to shut down your operation, we're going to send the message that all efforts towards diversity and inclusion stop, and then we're going to say you can't go back to be a doctor at the VA hospital, or you can't get a job even in another agency or department. You can't go work at the transportation department. You can't go work at HHS. And that, to me, reflects the sloppiness and the recklessness of this legislation, which is an attempt to take an absolute sledgehammer to efforts across the entire federal government to promote what I think is an essential American value, which is making sure that the federal government itself be open to people from every walk of life and every American community. And with that, I will yield back to you, Mr. Chairman.
I ask unanimous consent to enter the following letter of support for the bill, letter from Heritage Action in support of the Cloud bill. I now recognize the sponsor of the bill, Mr. Cloud from Texas.
Thank you, Mr. Chairman. Diversity, equity, inclusion are three words that don't necessarily mean what we think they mean. And in spite of the altruistic motives of some of the purveyors of it, diversity, equity, inclusion, as it's been initiated in our federal government as an ideology, seeks to categorize individuals based on their immutable characteristics. It is a rejection of the principles that people should be judged on the content of their character and their individual achievement rather than their sex, race, national origin, or ethnicity. DEI is a huge step backwards for our country. It has taken generations, not to mention a civil war, a civil rights movement, to move past a stain on our nation's history. But we have made tremendous progress. But to codify discrimination in an effort to remove discrimination is a woeful initiative and would undo generations of progress we have made as a nation on this. Every tear, every drop of blood, the sweat of our founders, our forefathers that have fallen would be in vain for us to continue and to reverse the path that we have. True justice is blind. It should not consider race or sex. And it's the duty of us as lawmakers to write just laws, and it's the duty of the executive branch to be just in administering them without deference to race, creed, religion. Yet the Biden administration has pushed through DEI initiatives into every policy and government department. What this bill seeks to do is really three things. It seeks to close the DEI offices that have been set up in virtually every single agency. And as well, this federal government has pushed these policies and sort of force-fed them on the American population by requiring that anyone who does business with the federal government, contractors, also have to adhere to these DEI policies, as well as the grant writing process. So this would write what may be a well-intended policy, but has done great harm to our country. It's been very divisive. A new report from Do No Harm counted 500 DEI actions that the Biden administration took place or planned to take. DEI ideology simply does not work and only serves to divide our country. DEI ideology also results in absurd government-funded programs and has been a complete waste of taxpayer dollars and is dangerous, as sometimes people who do not have the competencies to carry out the job are placed in jobs for DEI reasons. It is time for us to unwind this bureaucratic initiative and to restore a functioning government that does not give preference to race, sex, or any of these characteristics. Thank you, Chairman.
Would the gentleman yield for
and
a
I yield
question?
back.
Would the author yield for one question?
Sure.
Well, I'm just curious if you would explain the meaning and import of the provision that would make someone who works in one of those offices ineligible for rehiring or reassignment in a federal department or hiring somewhere else.
They could reapply for another office. What we are not going to do is take an office that has been stood up for the purposes of DEI and mandate that the federal government has to somehow find a place for people who have, if they are there as and their credentials are to be a DEI officer, we do not have to find a way to place them somewhere else. These were initiatives that were placed by the federal government and or by the executive actions of the president, and they need to be pushed back on. Thank you,
Okay.
Chairman. I yield back.
If I could I just pursue that for 1 second? Okay,
I yield it back to the chair. Thank you.
Yields back. Do any other members seek recognition? Ms. Stansberry from New Mexico.
All right. Well, thank you, Mr. Chairman and Ranking Member, and to the gentleman for bringing this bill before this markup here today. I will have an amendment on the bill later on in the debate, but, you know, as I say often in this committee, I'm a former federal employee. I used to work at OMB. One of OMB's jobs is to help manage the federal workforce. They work very closely with OPM, and we deal a lot with, you know, the regulations and the legal system around federal employment. And I really want to emphasize the comments that were made by the ranking member about how unusual this bill is. You know, we just had a letter introduced into the record from the Heritage Foundation that is supporting this bill because of misguided efforts to essentially stoke segregation, division, and create a victim-oppressor narrative, essentially, is what this letter of support says. But what is particularly peculiar about this massive bill that's been introduced, and I want to note that the co-sponsor of this bill, or this primary sponsor of this bill in the Senate, is Mr. J.D. Vance, our Vice President-elect, is it literally, as the title says, is about dismantling diversity, equity, and inclusion programs in the federal government. It revokes executive orders. It amends the Civil Rights Act, and it amends other parts of the federal code that protect our federal employees. And then it has this peculiar section that the ranking member talked about, which is actually essentially creating lists of federal employees and contractors that would never be eligible to work for the federal government again. Now, we have a word for that in common parlance: We call it blacklisting. And blacklisting comes from the 1950s when, here in this House of Representatives, there was a committee on un-American affairs that was convened under Joe McCarthy. The purpose of that was to purge the federal government and to accuse federal employees and blacklist them from future federal employment. So I'd like to say, welcome to the new House Committee on Un-American Affairs and to the new McCarthyism, because we have arrived here today
Will the
with this
gentlelady
bill.
yield?
So let's talk about
Will the
what
gentlelady
exactly
yield?
is trying to be accomplished
No.
by this bill and by the upcoming administration, which the Vice President-elect is participating in here. Now, okay, let's take the argument to its logical extension that this is really about making sure that we have qualified individuals inside the federal government. So my question is then, why is the president-elect choosing absolutely unqualified cabinet secretaries to be at the head of every single agencies? We've got now a worldwide wrestling executive who's going to run education. We've got a sexual predator who was about to have a bipartisan report released by the House of Representatives to be our AG. We've got a Fox News commentator who's going to run the military for us. So if my colleagues across the aisle want to talk about qualifications, they want to talk about efficiency, they want to talk about the federal workforce, then let's talk about it, because you're talking about putting into place leadership in these federal agencies who are absolutely unqualified, who are dangerous, and know nothing about the agencies that they're about to be appointed to lead. So this is not about qualifications. This is not about having a qualified federal workforce. This is about laying the ground for the purge that they plan on January 20th and in the days afterwards. And we know that because the very organization for whom the chairman just submitted this letter of support is the Heritage Foundation, who wrote Project 2025, which gave us the blueprint for the purge itself and what they are planning inside every single one of these agencies. So we need to be clear-eyed about what this actually is and about what is trying to be accomplished, and why 4 weeks before we're about to adjourn for the holidays, the Republicans are bringing this bill to a markup without an actual hearing. This is modern McCarthyism. They are preparing for a purge. They are going after members of the federal government who are advancing because they are people of color, women, LGBTQ+, other members of our community who have been excluded systematically from participating in federal service and leadership positions, and then they're going to put their own unqualified loyalists in there to take out our federal workforce. That is what this bill is about. It's about creating a statutory framework to do that, and we're going to fight it every step of the way. With that, I yield back.
The lady yields back. Any other members seek recognition?
Mr. Chairman.
We'll rotate back and forth.
Thanks, Mr. Chairman.
Mr. Biggs from Arizona is recognized. Then we'll go back.
Thank you. I appreciate the gentlelady's statement. I assume that she's referring to Pete Buttigieg or Javier Becerra or Mr. Mayorkas, who were unqualified appointees of the current administration. I find that interesting. But I also find it interesting because this bill it has some interesting things in here. The first section, Section 1201, or Section 3, which is 1201, says that you cannot discriminate for or against any person on the basis of race, color, ethnicity, religion, biological sex, or national origin. That sounds, you're going to read that to my constituency and most Americans, I think they're going to say, hey, that's not a bad idea. You cannot require as a condition of employment, as a condition for promotion or advancement, or as a condition for speaking, making a presentation, or submitting written materials that an employee undergo training, education, or coursework or other pedagogy that asserts that a particular race, color, ethnicity, religion, biological sex, or national origin is inherently or systemically superior or inferior, oppressive or oppressed, or privileged or unprivileged. I don't know. As we look at this, you can either celebrate moving together unitedly as the United States of America, we as a people, where we accept each other and try to move the country forward, or you can say, well, look, we're going to divide everybody. And that's what has happened under this administration through the codification of these executive orders. Oh, they haven't been codified, but through these executive orders, which are designed to actually separate instead of bring people together. That's a shame. And I respect that we have differences across the aisle on this issue, but I hope that one day we really will be a united country, united, and I think this bill is trying to make the point that systemically established these executive orders have done the exact opposite than that. So with that, Mr. Chairman, I'll yield to the gentleman from Texas if he needs the time.
Thank you. There was an insinuation that this is McCarthyism, that it creates some sort of list. I would challenge the questioner to find that in the bill text. It is simply not there. The bill says that, and I will quote, that the head of a federal agency that closes or terminates or winds up a program or office under the paragraph shall undertake an appropriate reduction of force. So if we have stood up an agency for the purposes of DEI, that we will reduce that force load on our federal government for the same amount that it was at. It went on to say it may not transfer, reassign, redesignate any employer or contractor with a position or function that is eliminated. It does not prohibit anyone from reapplying for an office or using their background in another, their experience in another initiative or area of expertise in our federal government. It does not create a list of that employee or ban them from ever participating in government. It just says if we have created an agency for the purposes of DEI, we are going to reduce that office and not have it be a burden on the American people. If we hired people for the purpose of something that we are not going to be doing anymore, the public service, as we all know in our offices, is not a right. It is a privilege, and if there's a need for that office, then great, but being employed for the purposes of something doesn't automatically guarantee you continued employment in our federal government unless you're meeting a need that provides an ROI to the taxpayer, which this does not.
Gentleman yields back. Who else seeks recognition? Mr. Garcia? Or Mfume?
Yeah.
Okay, Mfume.
Thank you very much, Mr. Chairman. I'm going to stand in strong opposition to this, and I look forward to the larger debate both in the committee and certainly on the floor. I just think it's a bad way to go about trying to solve a problem. And, you know, when I look at this, I have to look through the lens of history in terms of how we got here. And so for me, historically, this really all found its weight in trying to deal with a very real American problem of discrimination and servitude. For me, this was about a race of people who had suffered, endured, and survived 2 centuries of slavery, oppression, deprivation, degradation, denial, and disprivilege. And so the culmination of the act of Congress on July 2nd, 1964, with President Johnson, was to put in place, once and for all, the gateway to that opportunity. And so that has put us on a course of evolution, This initially was about black Americans. That umbrella opened over the years, and it went on to include other defected or affected groups, Latinos, the disabled, gay Americans, and I could go on and on and on. If this is all about President Biden's executive order, then I would strongly suggest that it ought to be a executive order that countermands that goes against it, if that's the goal you're trying to get to. However, stepping and wading into this as the Congress to now amend that 1964 Civil Rights Act sends the wrong message, whether intended or not, to most affected groups. And I can tell you it definitely sends the wrong message to black people in this country. I don't think that this is going to cure a situation that, quite frankly, has yet to be proven to me that it exists. And so if we follow the mandates of Project 2025, and if we are reducing force, threatening federal employees by changing Schedule F requirements, doing other things that put us on a slippery slope, I don't want to be a part of that. I really don't. And so I will fight this, and I will ask other members of this committee to fight it. Let the incoming administration do what it wants to do on this, but don't pull the United States Congress in to amending the 1964 Civil Rights Act in a way where all of these communities are going to be severely affected down the road. I just think it's bad policy. I don't believe it's insightful, and we're going to debate this over and over and over again because I don't think that too many minds on this side of the aisle are ever going to be changed. There are too many people who are the great-grandchildren and great-great-grandchildren of a system that worked against them to now see this effort, and I'm not impugning the gentleman's integrity by any means. I just think that this is the wrong way to go about doing it. I stand opposed, and I yield back.
Would the gentleman yield?
Yes.
Thank you, Mr. Mfume. Thank you for your eloquent statement of purpose, which I think describes how we all feel on the Oversight Committee. This is a very sweeping attack on the progress that we've been making as a country to leave behind the legacy of racism and sexism, discrimination against veterans, discrimination against the disabled, discrimination against pregnant women, and so on. I want to say that to the distinguished gentleman whose bill it is, I appreciate the clarification that this is not an attempt to keep people who work in such offices ever from being rehired again. So that's a step forward. But I hope he understands that he is treating people who work in these offices completely differently from everybody else in the federal government, because right now we have several regulations and laws, including one that applies specifically to veterans. So that's the one in my mind. And let me tell you what it says. If a veteran's working for the federal government and the office closes that the person is in, then they have the ability to be reassigned to another office if they're qualified for the job, and if obviously the job has got to be legal. You're making jobs like that exist in a DEI office illegal now. So, but if there's another lawful position open, these people would not be able to be reassigned to them or be put into them simply because they had worked on diversity before. And that strikes me as a very radical statement, and I don't know anything like it in the civil service or the personnel law. And thank you for yielding, Mr. Mfume.
Thank you, and reclaiming my time. Mr. Chairman, I've got 3 unanimous consent requests for submission into the record. An official statement from the American Federation of Government Employees, of the AFL-CIO, an official statement from Mark Morial, the President and CEO of the nation's National Urban League, and an official statement of the Human Rights Campaign, all in stark opposition to the bill.
Without objection, so ordered. Who else seeks recognition on the bill?
Mr. Chairman.
Is it, who, I can't remember. Okay, Mr. Garcia.
Thank you, Mr. Chairman.
I'll get it.
I do agree with the comments that have been said from House Democrats on the committee. I wanted to say a few things. I think we all want our agencies to serve the American people as efficiently as possible. We want to make sure that our federal employees are the most qualified and dedicated people to our country and our government. When I was mayor of Long Beach for the last 8 years, I had a workforce of about 6,000 people, including an incredible police department, firefighters, an efficient port. And one thing that I'll tell you that folks in my community value about working in our city was that they were working with diverse personalities, diverse people, folks that they learned from, that they made their work better, and vice versa. And so we know that inclusive workplaces actually also retain and are ways to recruit top talent. And so this type of actions and this bill does exactly the opposite of that. And in fact, I believe we will recruit less qualified individuals when you start removing incentives for diversity and for creativity in the workplace. And clearly this bill has nothing to do with good government. There's no common sense. And unfortunately, it's about purging, in my opinion, Donald Trump's enemies. Now, if the majority wants to make sure that our government runs more efficiently, they should start, and certainly the president-elect should start by actually appointing qualified people to run these government agencies. I mean, the nominees so far has been quite embarrassing as we've heard them from the president-elect. I mean, you have a Fox News personality for defense secretary. You have RFK Jr., who doesn't believe in vaccines for health and human services. You have Tulsi Gabbard, who has praised dictators and essentially, in my opinion, is a Russian propagandist for our intelligence services. You have Matt Gaetz, who has been accused credibly of sexual misconduct and a bunch of other horrific actions. These are the people, by the way, who the incoming administration would actually bypass security clearances, FBI tests, yet many of these same managers that are in these current agencies are required to take those same exact tests and exams. And so I think this is incredibly hypocritical when there are same members of this committee who are praising those agency heads that are going to be coming in who have had little scrutiny, and yet they want to remove important programs around diversity, around supporting all people, around uplifting equality within our government. So I strongly oppose this bill. I think this is moving us completely backwards and quite frankly violates a lot of the progress that we've made in the civil rights era. And so with that, Mr. Chairman and our ranking member, I yield back.
Chair now recognizes Mr. Higgins from Louisiana.
Thank you, Mr. Chairman. To my colleagues on both sides of the aisle, I'm an original co-sponsor of this bill, and I've noted some of the comments here, and I believe we should take a step back and ask ourselves, you know, what do we seek in our republic regarding individual rights, liberties, and freedoms? And do you believe in those core tenets of our republic or not? We have an opportunity before us with this bill to push back against it. The ranking member mentioned a sweeping attack. Yes, this is what we have suffered. We have suffered as a nation a sweeping attack against equality. That's exactly what we're fighting against. Another colleague mentioned oppression and degradation. It's exactly what we're pushing back against. This is a bill that eliminates government-sponsored oppression of individual rights, liberties, and freedoms in the land of the free. Freedom of opportunity, not result. And reflected upon the gentleman's comments of our former colleague, former Representative Gaetz, he's not here to defend himself. So let me speak on his behalf for all Americans accused of any crime at any level. I refer you again to our Constitution. Every American has the right to be recognized as innocent until proven guilty. Representative Gaetz has certainly demonstrated that he is a brilliant litigator. He's represented the interests of his district and his own principles will sometimes vary from mine. He and I have very different opinions about some things. He's a highly qualified and brilliant man. And to attack him with accusations by name in this committee is wrong. The man's not here to defend himself. So I support the bill, Mr. Chairman. It is quite simply a strong response to the oppression of our individual rights, liberties, and freedoms as Americans, regardless of color or creed or political affiliation or where you stand upon the economic strata, what your background is or your heritage. All of us should be counted as Americans equal as we move forward through the course of our life on our journey, and we should not face obstructions that are baked into our government bureaucracies that exclude citizens strictly based upon their color, their heritage, their creed. This removes those oppressions. Mr. Chairman, I yield to you, good sir, to balance of my time.
Yield.
Yes, sir.
Yield to the gentleman from Texas.
Yeah, first of all, I want to thank you, Mr. Nfume, for realizing we can have different views with the same goal and have altruistic motives on both sides. I just want to thank you. I appreciate that. Our founding documents talked about having a nation where we recognize that all people were created equal. Martin Luther King talked about that being a promissory note because, as we know, that had not always been the case and has not always been the case in our country. And it took too long and has taken too long for us to get where we need to go. But he also said that we shouldn't use the results of segregation, and I think we could also say discrimination, as the justification for future segregation or discrimination. That's what this bill seeks to do. It seeks to reverse some of the policies that have, instead of looked at merit or qualifications or the like, and institute a policy where you are hired on those things instead of where the first thing we look at is factors about our character, our personality, our skin color, our sex, whatever the case is in qualifications for a job. And I'll just point out, there's many of these examples, but the Air Force's Diversity and Inclusion Resource Book has recommendations for unconscious bias, race-specific learning, cognitive diversity teaming, general diversity and inclusion and belonging, and it includes a book title called White Rage. This is the kind of things that are going. We should not discriminate at all in our government. This bill supports that, if you read the first title. And we just do not want to go down the path where we've spent decades and literally generations moving away from these sort of discriminatory practices. The idea is not to codify these as we continue to move forward and work toward a more perfect union. Thank you.
Would you yield? Would you gentlemen yield?
My time's up. It's not my time either, but it's up to the chair. I'd be happy to.
Yeah, if you want to yield, yeah, go ahead.
Sure. Yes, sir.
Would the gentleman agree that what this bill does, in essence, is to come up with a new definition for discrimination?
I do not agree.
Well, then if we use the old definition, the bill is way out of line, in my opinion. And the notion about government-sponsored oppression, which my colleague from Louisiana talked about, for me, government-sponsored oppression was the Black Codes. For my parents, the Dred Scott decision, the Runaway Slave Act. I mean, that's going hardcore to when the government is actually sponsoring oppression. But if we're talking about doing away with diversification initiatives, this is an axe. This is not a knife. It's not pinpoint. It's an axe, just to do away with everything under this new discrimination, which leaves a lot of people unprotected, a lot of people out of work, government employees and private sector employees to some extent. But most of all, it doesn't solve the problem. It doesn't deal with the real problem of discrimination, racism, and the things that we have come to abhor and say and pledge that we're all against. This is just so broad that I believe that, as I've said before, I'm going to stand in opposition to it. And I can only talk about this from my perspective as a black man living in America. And I'm telling you, it's the wrong thing and the wrong way to do it. And I would strongly suggest, as I said, and I'll yield back, the gentleman who's kind enough, and the chair, I really believe that in this instance, the Congress should not be wading in to amend the Civil Rights Act of 1964 because of an executive order by a president that you may or may not like. That ought to be undone, I think, by another executive order if you're going to do it that way. But to do this, I just can't support. I yield back.
Gentleman's time expired. Any other members seek recognition? Ms. Lee? Yeah, Ms. Lee, you recognize.
Thank you. Thank you, Mr. Chair. I'm not in favor of the Dismantle Diversity, Equity, Inclusion Act, or what it maybe would more aptly be called the dismantling any semblance of support or opportunity for certain American acts. We know who those Americans are, Americans who have not enjoyed centuries of unfair advantages by keeping others enslaved or segregated or disenfranchised or incarcerated or redlined or gerrymandered or excluded by law. Americans who've lived with disabilities or had their relationships criminalized or their gender expression demonized. If we're being honest here, this bill, which will wipe out every diversity, equity, and inclusion program in our federal agencies, plus those who contract with us, plus those who receive grant money, plus our schools, is nothing new. This is just the final piece of a decades-long obsession with targeting and dismantling anything that might give marginalized people a fair shot, including DEI programs, which honestly started the second the Civil Rights Act passed. Policies like affirmative action and diversity, equity, inclusion are the closest things we've had to the mythical bootstraps that some of my colleagues insist historically and currently harmed communities need to pick themselves up by. After centuries of efforts to keep us out of schools and universities, from jobs and elected office, Republicans targeting these policies are no accident. Why do predominantly conservative white men believe that the success of a black person or the opportunity or access of a black person is an existential threat to them? DEI is not given any unfair advantage that society itself does not already confer on certain Americans. It merely exists to ensure that all other people, that women, minoritized folks, queer folks, disabled folks, have the same opportunities to succeed and thrive in our workforce and our schools as people who have not had those opportunities systematically and legally stripped from them do. Is our country not greater when all of us have opportunities to succeed and contribute and survive? Our success and our survival as a nation is bound together. Diversity, equity, and inclusion programs only exist to band-aid over decades, hell, centuries of discrimination against people's skin color, their religion, disabilities, gender, or sexual orientations, you name it. Contrary to Republican conjecture, remedying past discrimination is not, in turn, a discrimination. And we're not going to sit here and pretend racism is over just because one black person on the Supreme Court agreed that it should be. What DEI does not do is give some kind of magical pass to better jobs, like some of our colleagues are implying. That middle word, equity, does not mean more than or better than. It means treating people fairly and impartially. It means working to fix generational and systemic discrimination to the betterment of all of us in all of our institutions. But instead, Republicans are trying to bastardize the term DEI to be a slur. When Justice Ketanji Brown Jackson was up for confirmation and when Vice President Harris was added to the ticket, they called them DEI hires. They want you to believe that a Harvard graduate with over 20 years of experience, who happens to be a black woman, is not qualified, but a Fox News personality is qualified to run the Department of Defense, and the WWE executive is qualified to run the Department of Education. Let's be real. There is an attempt to create a direct correlation between our race, being a black person, and our qualifications. So much as to say that there is no way to be a black woman. There is no resume that a black person could have that would qualify them unless that black person is a Republican. And there is a quota there. And while all of this has happened at the top level of our government, I can promise you these same things are happening on every single level of government and private sector. But those people don't have a national platform to speak out against discriminatory treatment. Where is a federal worker supposed to turn when another coworker says a racist comment to them in the break room? Where is the same-sex couple who is denied housing supposed to, because of their relationship, supposed to turn? Where is a pregnant woman who was fired for being pregnant supposed to go? Often the only place that they have to give them recourse are the diversity, equity, and inclusion programs. These folks just want to do their jobs, serving the American people in an environment that feels safe and supports them. Making work a better, safer environment for some does not mean it automatically is worse for others. And those complaining about DEI training are probably the ones who need it the most. My Republican colleagues have got to stop punching down on already marginalized communities and face their own fears of a level playing field privately. It's shameful. I yield back.
Gentlelady yields back. Any other members seek recognition? Mr. Burleson from Missouri.
Thank you, Mr. Chairman. We just left this room last night listening to a FEMA director who was apologizing for the failures of her agency, an agency that, by the way, made its top priority and its focus and mission on diversity, equity, and inclusion. You would think that their mission and goal should be on providing aid and support to the American people in times of disasters. Just months ago, we had another individual sitting at this table during a hearing who was apologizing for the failures of Secret Service because of the events that happened in Butler, Pennsylvania. A same agency who made it their number one priority not to protect key individuals. It's not their number one priority. The number one priority is diversity, equity, and inclusion. And look, I think that what's happened here and what I think that we may not understand is I think we perceive DEI as a shift from the Civil Rights Act and into, instead of discussing equality of opportunity, we're now focused on the equality of outcome. And it's only common sense, it's only logical that you cannot dictate an equality of outcome unless you eliminate the equality of opportunity. This agency has done that. In my opinion, they have moved on from the Civil Rights Act and moved on towards this equality of outcome, which, in my opinion, is shoehorning some form of Marxism into what is a noble cause, which is to try to root out and eliminate discrimination in the workplace. And so that's the motivation behind this, and that's why I'll be supporting it.
Gentleman yield.
Does the gentleman yield?
Someone asked if you,
Does the gentleman
okay,
yield?
Stansberry asked. Okay, no. Gentleman's time's expired. Any other members seek recognition? Yes, Ms. Presley from Massachusetts.
Thank you. This bill, titled the Dismantling DEI Act, is an utter disgrace. Having sat and read the text in preparation for today's markup, I have yet another example to tell my constituents about the unserious work of the Republican Party. Now, I'll work with anyone serious about progress who wants to center the people who call this country home. This isn't it. The Committee on Oversight has the broadest jurisdiction in the entire House of Representatives to investigate any topic it chooses, but we are debating legislation that denies the sky is blue, water is wet, and racism is real. The major provision of the bill says to ban anything that acknowledges racism. And a few pages later in the exact same bill, there are multiple provisions discussing the presence of racism. This Republican approach is as predictable as it is nonsensical. On one hand, they're saying that racism does not exist. On the other hand, they are saying there is rampant reverse racism. Well, how do you reverse something that never existed in the first place? Riddle me that. While this Republican policy may have a new name, it's the same old tired game. Look, y'all are entitled to your opinions, but not a denial of the facts. Do you all know your history? Do you know American history? The original Constitution counted enslaved individuals as 3/5 of a person. During World War II, the federal government forcibly relocated and incarcerated 110,000 Japanese Americans. The FHA practiced redlining in the 1930s and 60s to deny mortgages to Black Americans, which is why we have a racial wealth gap today. I could go on. The GI Bill. which is supposed to be race neutral, denied access to Black Americans, denying them equal access to education and housing benefits, which is why we do not have generational wealth. Don't talk to me about merit when those Black servicemen fought for our freedoms. And I'd also just like to take a personal note of privilege to say, please keep Dr. Martin Luther King Jr.'s name out of your mouths. Yes. Your perversion of his words and his mission when his children have asked you to stop invoking his name and perverting his work when he was a proud and unapologetic Black man fighting for equality for Black Americans and all marginalized people. So you all are entitled to your opinions, but not a denial of the facts. But I'm not surprised that you would deny American history. What I am, though, is committed. Committed to speaking truth to power, committed to standing up for marginalized communities and vulnerable people, committed to ensuring that everyone has equal opportunity to buy a house, to work a job, to pursue higher education, and to live in a society that is fair and just. A colleague across the aisle invoked the phrase of, we must do everything to stop government-sponsored oppression. Well, I've just enumerated numerous examples, which is exactly why we have legislation and an executive order to reverse this harm. And that is why I'm committed to opposing this bill and urge my colleagues to do the same.
Gentlelady yields back. We'll go back. We'll rotate sides. Chair recognizes Mr. Perry from Pennsylvania, then we'll recognize Talib after that.
Thank you, Mr. Chairman. I yield my time, such time as he may consume, to the gentleman from Louisiana, Mr. Higgins.
I thank my colleague, and I appreciate my Democrat colleague for exemplifying exactly the kind of oppression of freedoms that we're referencing. How about we'll quote whoever we want to quote? How about that's my First Amendment right? That's exactly the kind of baked-in oppression. Like, how dare a white Republican quote Martin Luther King? We actually had a congressman say that just now in this committee. Well, thank you, good lady, for once again exemplifying the type of oppression that we stand against. You know I'm right. You know I'm right.
Order. Mr. Higgins has the floor.
And we will quote who we please to quote.
A disgrace.
And we will continue to speak freely because now I'm a veteran. That's the country that I serve. That's the Constitution I swore an allegiance to. And that oath has no expiration date. I will fight for it with my last life's blood. For my right to speak freely and yours, good lady. You will never hear me saying, how dare you quote anybody you please to quote. And that exemplifies, America, precisely the type of institutional oppression that my colleague, Mr. Cloud's bill, for which I'm an original co-sponsor, hopes to push back against.
But Mr. Higgins, have you read your own bill? Have you read your own bill?
No,
Because it is trying to
Mr.
regulate speech.
Lady.
It is actually
Hey, Ms.
regulating
Stansberry, you're out of order. Ms.
I yield
Stansberry,
back
you're
to
out of
Mr.
order.
Perry.
It's Mr. Perry's time. Chair recognizes Mr. Perry.
Thank you, Mr. Chairman. I yield the balance of the time to the gentleman from Texas, Mr. Cloud.
Mr. Cloud.
Thank you, Mr. Perry. I'll just say, I think this is what makes progress hard on this front. The idea that we can't have a conversation on government policies that have been put in place. My intent, in my opening remarks, I acknowledged many of the things that have been talked about, the stain on our nation's history that we have in some ways moved past, but there will continue to be work to be done. It's sad and sickening that in a fallen world, in a nation as diverse as ours, and we are one of the most diverse nations in the world, there still remain people who cling to old, racist, ignorant ideologies. My concern is that the way this has been implemented into many of the agencies in our federal government, this has been listed as the #1 agenda in agencies that are supposed to be doing other things. Yesterday, Mr. Burleson mentioned FEMA. And one of the things is they're trying to weigh someone's religion and how they give out aid. That's crazy. That kind of stuff shouldn't be happening in the United States of America. There's research that's gone into this. Journalist and researcher Jesse Singal wrote in the New York Times that there's very little evidence that many of the initiatives work. The specific type of diversity training that is currently in vogue, mandatory training that blames dominant groups for DEI problems, may well have a net negative effect on the outcome managers claim to care about. Forbes senior editor Jenna McGregor wrote, compulsory diversity training aimed at people's biases or preventing discrimination behavior appears to actually do more harm than good. I did not benign the intents or the motivations in these policies, but what we are finding and what businesses are finding now, a number of them have implemented these policies and realizing they're not working. They're not accomplishing the desired ends for us to continue to move toward a more perfect union. And that's why we're seeing a retraction from them. My concern is getting our federal government to a place where race and sexism and all these things are not the first thing we look at in our hiring, in our grant writing, in our contracting. I think it would make us a better country.
All right, gentlemen, time's expired. Chair now recognizes Ms. Tlaib from Michigan.
Thank you so much, Mr. Chairman. You know, I sometimes remind people I grew up in the most beautiful, blackest city in the country, the city of Detroit, because I need you to understand sometimes your lens becomes different when you're in a community just embodied with the constant, I think, struggle of not really, because you will never truly understand what it means to be black in America. Never. You have to acknowledge that. If you don't, I don't think we'll ever be able to pass. You have to know. I believe it in my heart that you do. And you know, this black pastor told me, you know, I'm sitting in the pew, of course I'm sticking out, and Pastor Bland Jr. looks at me in the audience, and I just felt like he was just looking at me, but you know, if you're a good pastor and you know what you're doing, you always think he's just talking to you. And he said, you know, our country is not divided, it's disconnected. And when I think about that, I think about the fact that we continue to disconnect because we allow segregation to live and breathe in a way because you know, people are more comfortable that way, right? You hear people say, well, that's not my fault. I really am a better public servant, a better American, and everything because I went to a beautiful, diverse high school, you know? Because where I lived, that's the high school you had to go to. We all went to those neighborhood high schools. There was something beautiful, though, because I went to school with Hungarians and Polish and Latinos and black folks and Muslims and I mean, just all different kinds of backgrounds of people from all different likes. And it was something I think that many of our neighbors across the country will never, ever really experience. And I think it keeps us divided. When I think about this bill, I think about not just, obviously, the importance of diversity and inclusion and trying to make sure that our government is reflective of who we serve. But many of the people we hire, it's also their lived experience. Their lived experience is going to have them lead with some sort of compassion that we'll never again have similar because we haven't lived the life that they have in our country. And I'm not just talking, I'm talking about all different backgrounds. And I just feel like we're in here talking about this in a way that I feel like is just going to continue to divide us. And the acknowledgement that everything's okay. There's no way you haven't been in spaces where you hear it. In the Michigan legislature, Chairman Comer, a man, you know, was a minority witness in the Michigan House and used the N-word in such a derogatory word. My own state representative was in tears afterwards, thinking of her child, her beautiful, lovely son, adult son, but just thinking, my God, he thought that it was okay, that he was somehow emboldened to use that word in the people's capital, in Lansing, Michigan. We have a lot of work to do. I just think this is not it. We got to make sure that we're focusing. No, really, we got to make sure that we're putting people in the room. That sometimes we got to make sure they are in the room together, because they're not going to come in the room together unless we require it or urge it to happen, because we know if we do that, then all the services, the way we move as a federal government, will be reflective in a way of leading with that compassion I think that is needed. I just urge us to please just step back and understand that. And I'm not going to tell you, I fully understand where you're. I just know that there's no way you don't know that racism is very clear in these spaces, especially here in an institution that wasn't ready for someone like me. And sure the heck sometimes isn't even ready for the American people, our own neighbors across our country, that will have to be inflicted in coming to get whatever services. God, it's something beautiful if they can look at somebody that is reflective of them and understand their lived experience. And I think we're getting farther away from that. And I know you don't see it, but I'm an attorney. I read this. You're going to allow these protections to fall apart when you do this kind of legislation. You will. It'll allow these protections to fall apart because you're going to allow people to get fired solely because you're dismantling, again, a policy and a process of creating a culture, again, that's reflective of our country. With that, I yield back, Mr. Chairman.
I yield back. Any other members seek recognition? Which one do you want, Crockett or Moskowitz? Frost. I'm going by Mr. Raskin. Moskowitz.
So
recognized.
So I really have a question for the sponsor. So I've been sitting and listening and trying to hear your intent and talking about discrimination. But the problem is that argument falls apart on page 6, line 17 through line 20. And in fact, if you're sincere about your intent of the bill, what I would tell you is you should delete those lines. Because actually those lines are actual new discrimination. See, you want to get rid of an office. We may disagree with it, but you can get rid of an office. You want to change policy. We may disagree with the policy you want to change, but here actually in those lines, you are creating second-class federal employees. You're creating new discrimination. May not transfer, discrimination. May not reassign, discrimination. May not redesignate any employee, discrimination. Those are protections that every other federal employee in every other office in the federal government gets. It's a right and a privilege that they get. But you're going to remove that from these people, not an office. Fine, I disagree with it, but it's an office. Not a policy. Fine, we disagree with it, it's a policy. This is people now. Now you're going to the people. You're saying, because you worked in an office that we don't think should exist, because you worked there, we're going to remove protections that every other federal employee gets, but not you, because we disagree with the office you worked in. That is straight up discrimination. And so listen, if you're serious about wanting to change the office and the policy, you should remove those lines, because the entire argument falls apart when you want to treat the people who work there completely different than anybody else. And I'm happy to yield the rest of my time to the ranking member.
Thank you so much, Mr. Moskowitz, and thanks for that powerful statement. That was the thing that jumped out at me when I first read this. This wasn't just a change in programmatic direction. It was an attempt to strip federal workers who were doing nothing other than their job, as it was defined to them and described to them, of essential civil service protections that occur to everybody who works in the civil service. And again, There's a general regulation that deals with that. There's one specifically for veterans, saying if a veteran is working for an office, say it's one of these offices that closes, that veteran has the opportunity to be reassigned to another job that he or she is qualified for, doing not the same work, but the new work of the new office. And yet, this seems to paste a scarlet letter on them saying, you worked in now the politically incorrect, ideologically disapproved office, the reviled DEI office, and now you're going to have less rights than everybody else in the workforce. You'll be fired. And it does sound like from the author, at least they could reapply. I think it would clearly violate equal protection in the First Amendment for them not even to be allowed to reapply. But why would we set up a two-tier system where there are people who work in the federal government and then people who worked in the federal government for DEI? And it does, I think, cast a pall over the whole legislation, which obviously is touching, a lot of nerves. And, Mr. Cloud, I respect, the spirit with which you offer this legislation, and I respect the fact that you are not in denial of what so many of our members want to point out, which is that our history is one that begins, of course, with slavery and the denial of rights of African Americans. In the Dred Scott decision, Chief Justice Taney, unfortunately of Maryland, said that the African American has no rights that the white man is bound to respect. And then even after the Civil War, we fought a whole war to overthrow the system of white supremacy, to emancipate people from slavery. Still, the Supreme Court said in 1896 in Plessy versus Ferguson that it was perfectly okay for government to segregate people according to local racial customs. And we know that that means discrimination and second-class services. So the legislation you offer is part of a long history and goes back to the Civil Rights Act of 1964, the Voting Rights Act of 1965. I'll yield back to you, Mr. Musk.
Just reclaiming my time. And so I would want the sponsor to answer that question because, look, if Donald Trump were to create a new agency, right, and years later, when we get power back, if we were to eliminate that agency or eliminate that office,
Mr. Chairman.
But we then said those people who worked in this area of government that we disagreed with, they're going to get less rights and privileges than every other federal employee, you would be jumping up and down that we were treating Trump supporters different. And so what I'm saying to you is, if your intent is to change policy, and if your intent is to eliminate an office, we may disagree with that, but don't punish the people who work there and treat them different than everybody else, and then say this is about trying to change discrimination. I yield back.
All right, gentleman's time's expired. I think we go back and forth.
Do you want me to answer?
If you want to answer the question, feel free.
Sure. The first thing I would say is sometimes in Washington, and this is a bipartisan issue, we can tend to think that the American people exist to support the federal bureaucracy. I do not adhere to that belief. I think the bureaucracy exists to serve the American people. Having said that, we do want our federal workforce treated right and properly and justly. I would point out that this legislation does what it upholds the Civil Rights Act. The first title it goes through and virtually says the same definitions about what discrimination is. The reason and the intent behind that is, and I'll give you one example, the Department of Health and Human Services currently has 294 DEI employees costing the federal taxpayer about $38.7 million in taxpayer funds. Now, we can debate whether we think the program or the office has merit. My viewpoint is that for all what the altruistic purposes may have been, as some of the quotes and studies I've read, it's having even an adverse effect at best, or at best it's having a negligent effect and possibly having an adverse effect toward the stated goals. So having said that, I'm thinking, okay, in the example of HHS, we have a $38 million office that is actually having an adverse effect, and that $38 million burden shouldn't be on the American taxpayer. That's how my calculus is working. I did not Mr. Garcia, I wish he was here because he made the comment that we were trying to get rid of DEI officers because we were going after Mr. Trump's enemies. His words, not mine. I did not view DEI officers as Mr. Trump's enemies. That was a new idea to me, a new concept that apparently he thinks that DEI officers are Mr. Trump's enemy. I think that would be an issue if they were. I didn't think that they were. But having said that, you know, if you wanted to offer an amendment, and that would help you get to support of this bill, if you thought that would make the difference,
That's the First Amendment coming. That's my amendment.
Okay.
So we can get there.
And if it passes, will you vote for it?
But I'm definitely voting for the amendment. I'm introducing
I mean, for the bill.
Oh, well, I'll have to look and see what happens to your bill. There are more amendments coming.
Ms. Crockett, is she next? Yep. Okay, Ms. Crockett.
So many of you know that I practice law, but some of you don't realize that I actually was a business major out of Rhodes College in Memphis, Tennessee. And the emphasis that I got in my business degree was on finance. And as I traveled the country campaigning this election cycle, one of the things that I talked about was this idea that in finance, we always promote this idea of diversity. If you know anything about a portfolio, the one thing that you want to do is make sure that it's as diverse as possible, because at times certain stocks will perform better than others, and they will exemplify various strengths and weaknesses. And together, a diverse portfolio is usually what any good finance person would promote. They wouldn't promote that you solely invest in vanilla wafers, believing that that is going to be the strongest portfolio, but instead they may want to add some chocolate cake and some Twinkies into the mix to make sure that we have the best portfolio, because there will be different preferences by different people, and again, there will be different strengths. But as I sit here and I think about what we say and what I'm hearing as it relates to diversity when it comes to anything outside of making money, and to be clear, we are losing GDP every time we try to push back on this idea of diversity, because all of us bring something different to the table. But you consistently said over and over the word oppression, and every time that you said it, it was almost as if I was hearing nails on a chalkboard, because it seems like you don't understand the definition of oppression, and I'd ask you to just refer to Google to help you out. Oppression is the prolonged, cruel, or unjust treatment or control. That is the definition of oppression. And so as I sit here as a black woman who practiced civil rights, let me tell you, the reason that my colleagues wanted to make sure you understood the same black history that your side of the aisle wants to delete out of classrooms is because you can then misuse words like oppression. There has been no oppression for the white man in this country. You tell me which white men were dragged out of their homes. You tell me which one of them got dragged all the way across an ocean and told that you are going to go and work. We are going to steal your wives. We are going to rape your wives. That didn't happen. That is oppression. We didn't ask to be here. We're not the same migrants that y'all constantly come up against. We didn't run away from home. We were stolen. So yeah, we are going to sit here and be offended when you want to sit here and act like, and don't let it escape you that it is white men on this side of the aisle telling us, people of color on this side of the aisle, that y'all are the ones being oppressed, that y'all are the ones that are being harmed. That's not the definition of oppression. You tell me the prolonged, cruel, or unjust treatment that you've had, and we can have a conversation.
You could start with Exodus.
The final thing that I will say on this particular issue, two things. There is an article from The Guardian, and it is a little old. It's from 2021, so I apologize. But it said that back then, just 3 years ago, white men represent 30% of the population, but 62% of office holders. These are the issues that we are constantly looking at and recognizing and trying to say, is this just? I can't even tell you how many white men have served in this chamber, but I can tell you that I am only the 55th black woman to be elected to Congress. And so when you want to talk about history and pretend as if it was so long ago, it wasn't. Because again, I am just number 55. Finally, when we start to talk about what do these numbers do as we're trying to say that diversity, equity, and inclusion is the problem, the reality is that when it comes to financial performance, companies with more diverse workforces are more likely to outperform their competitors. Companies in the top quartile for racial diversity are 35% more likely to outperform their peers on profitability. Companies with diverse executive teams are 25% more likely to generate greater profits. Diverse companies earn 2.5 times higher cash flow per employee. Diversity works. And until you can show me data that says otherwise, I think that we need to go back to being a country that listens to experts and gets out of our feelings and recognizes, again, that racism is real in this country. And until we stop pretending that it's not, we will not solve the problems that we are consistently facing. And that will bring real unity that we seek when we're looking for a more perfect union.
Does any other member seek recognition? Seeing not, or do you okay. Seeing not, what are we doing? For what purpose does the ranking member seek recognition?
I have an amendment at the desk, Mr. Chairman.
Reserve a point of order.
State your point.
I'll reserve a point of order.
Oh, okay, yes. The clerk will distribute the amendment to all members. The committee will suspend while we distribute the amendment. How many amendments do you all have? Is this it?
I think there might be 5 or 6 in the
Okay.
Like 5.
Ready? The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 8706 is offered by Mr. Raskin of Maryland.
Without objection, the amendment is considered as read. I reserve a point of order. The ranking member is recognized for 5 minutes to explain his amendment.
Thank you very much, Mr. Chairman. This has been an edifying, if often heated conversation we're having today, and I think it's actually befitting. The First Amendment and the Speech and Debate Clause, we are the world's greatest multiracial, multi-ethnic, multi-religious constitutional democracy. And it's not easy. The far more common destiny for countries with different ethnic and racial groups is one of tribal violence and racial apartheid and ceaseless ethnic conflict. So we're getting there. And we have different approaches to how to do it. Some of our colleagues have somewhat dabbled in the language of race silence now, not talking about the past, not talking about what we've gone through, and everything will be all right. Well, that was definitely not the position of the radical Republicans who led us through the Civil War and the Reconstruction period. They passed all kinds of race-conscious legislation in the Reconstruction period. They passed the Freedmen's Bureau with the explicit provision of resources for the purposes of transfer to the recently emancipated black population. The radical Republicans led Congress in passing legislation to establish schools for black people, not integrated schools, but schools for black children, explicitly race conscious. because they understood that the meaning of the 14th Amendment and equal protection and the Reconstruction legislation was not just to create some sterile notion of colorblindness, which was not in the 14th Amendment or any of the debates about it. It was to actually help people get up after centuries of oppression, as my colleagues have described it, after centuries of violence and dispossession and legalized slavery and subjugation and control. So we have a difference now, I think, substantively about whether it's best to deliberately and consciously open government up, and not just to black people and Latino people, but open it up to other people who've been traditionally left out, including veterans, including people in rural areas. Your legislation would overturn all the executive orders that deliberately try to get the government just to think about getting applicants in the door who come from traditionally disfavored and discriminated against communities. But we understand, all right, we've got an honest difference of opinion about that. But I want to go back to what Mr. Moskowitz was saying, which is even if we disagree about the validity or the utility of these programs, and we think that they've been very successful in terms of opening the government up to the whole country and being very effective and productive for America. But even if we disagree about that, and we're going to change the program, this language is intolerable, which says that people who've worked in those programs have lesser rights than anybody else who's worked for the people of the United States in our federal government. So my amendment would lift the bill's egregious ban on transferring, redesignating, or reassigning employees who work in one of these offices that gets eliminated by the bill. In other words, if we eliminate this language, we treat them like any other federal worker whose job has been eliminated by virtue of federal action. So I think that sends a far better statement about the motivations and the purposes of this legislation, and I think this is one that everybody should be able to agree to. And with that, I submit it to the wisdom of the committee. Mr. Chairman, I yield back.
Gentleman yields back. I recognize myself to speak on the amendment. I oppose the amendment. The amendment seeks to increase bloat in the federal workforce. It does this by preventing the dismissal of employees whose offices, functions, and positions are eliminated by the bill. The federal workforce is already massively oversized. We should be doing everything possible to reduce the size of the federal workforce, not to keep it filled with unnecessary employees as the amendment seeks to do. And of course, nothing in the bill precludes the dismissed employees from reapplying for a job elsewhere in the federal government. This was an issue in the presidential race, reducing the size of the federal government. The overall bill eliminates taxpayer funding for federal offices, programs, and grants affiliated with DEI.
Thank you, Mr.
It's already federal law to discriminate against anyone based on their race. And the president-elect was transparent in saying this is one of the specific areas where they were going to seek to cut waste in the federal government. We cannot continue to spend $1.5 trillion a year more than we take in. And I think that the president-elect was transparent. I feel like this issue was talked about. With all due respect to the Democrat nominee, Ms. Harris, Vice President Harris, I don't know a lot of specific things she was going to do as president. I don't think she articulated very many specific proposals. One of the proposals that President Trump talked about was eliminating all the unnecessary DEI. And we've talked about how many positions have been created over the last 4 years. Instead of fighting for bureaucratic jobs, I believe, I represent a poor area. and obviously they're poor minority districts, we should be fighting for investment, fighting for entrepreneurism, fighting for ways that we can lift up communities that have been impacted by poverty, like many of the communities I represent, many of the communities that are represented by minority members. We can do this. And I think that's what the American people want. The government's not the answer. The private sector is the answer. We need to be more efficient in government, and we are going to be more efficient in government. That is the mandate of the American people. So I oppose the amendment. I support the bill. And now I seek, Mr. Moskowitz, you seek recognition.
Thank you, Mr. Chairman. So, listen, I have agreement with my colleagues across the aisle on wanting to shrink bureaucracy, wanting to decrease the size of federal government. That's a valid point. I think DOJ is going to try to do that, right? And you're seeing Democrats come out and support that. Chris Coons did that. Senator Coons did that the other day. What this amendment is saying is it's not allowing the federal government to stay the same size. What we're saying is as you eliminate an office, as you change a policy, if there are jobs available
Administrator Criswell,
that they can transfer to, just like every other federal employee, then they should be able to do that. What you're doing is that federal employees have certain protections and rights that they get. And what you're saying is the federal employees that worked in this office aren't going to get those rights. All these people aren't going to get to stay, right? They're not all going to get to stay. That's not what this amendment is doing. This amendment isn't saying, okay, yeah, change the policy, eliminate the office, but then let everybody stay somewhere else. That's not what the amendment is doing. What the amendment is doing is saying they have certain protections, certain rights as every other federal employee in every other office. And what you're saying is because you worked there, you're not going to get those protections. I'm telling you, it is very dangerous, and I can guarantee you the favor will be returned, because that's how this place works, right? You didn't like the other day that Trump houses were skipped in FEMA. I agree with you. It was unacceptable. They were specifically given less rights and privileges and available federal help because they supported the president. If Trump creates an office that later gets removed, those people who worked in that office should not get less protection. They shouldn't. But that's what you're now saying. You're now saying where we have political differences and policy differences, if you work in that office of political difference and policy difference, you're not going to be treated like every other federal employee. So it's not about keeping the federal government the same size. Don't mix the message here, because I'm with you on that. But I really think you should take the ranking member's amendment. It really doesn't change your bill. It just doesn't allow a new precedent to be started that we're creating different classes of federal employees.
Will the gentleman yield for a brief response?
Sure.
It's your time, correct?
Administrator.
Thank you. I think the gentleman from Florida, Mr. Moskowitz, made valid points earlier. He makes valid points now. And having read the sections and sentence that Mr. Moskowitz has referenced, very specifically on page 6, paragraph 2 says no reassignment. The head of a federal agency that closes, terminates, and winds up a program or office under paragraph 1. Then there's subparagraphs A and B. Subparagraph B says, may not transfer, reassign, or redesignate any employee or contractor with a position or function that is eliminated by operation of this subsection. And I believe that the gentleman is stating that if you close down a DEI department and you have a qualified employee that would like to transfer to the construction supervision department, that executive authority within that bureaucracy should be able to transfer that person from the DEI department to the other department. Is that correct?
If that job were available.
If that job was available, yes.
That would be a right that every other federal employee would have.
I concur with that concept, but the ranking members amendment is far more broad. So I'm going to oppose the ranking member's amendment because it eliminates the entire section of 101. But if you were to offer an amendment, specifically what we're describing, I would support that amendment. I yield.
Everybody yield back. Any other member seek recognition? Mr. Gett, Mr. Cloud. Well, we was Moskowitz, now Mr. Cloud. Okay, Ms. Stansberry.
All right, thank you so much, Mr. Chairman. I want to rise in support of the amendment and reiterate, but also explicate a little bit on this concept. So, you know, you learn a lot about a bill not only by what it says, but by what it doesn't say. So if the explicit purpose of this bill, like we're just going to take your logical argument here, is to do away with these DEI offices, which you believe are not necessary, which obviously we disagree with on the premise, then why not just be silent about what happens to federal employees that are involved in these offices? But the bill is not silent about them. The bill includes these phrases that the ranking member's amendment is striking because literally the bill has punitive outcomes for employees that work in these offices. And that is what this amendment is trying to strike, is the punitive measures that are put into place. I know that we've already read pieces of this, but one of the sections that it would strike says no reassignment. So the heads of a federal agency that closes, terminates, blah, 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 may not transfer, reassign, or redesignate an employee or contractor. So if this was just like, okay, we're going to shut these offices down, there's no reason to have punitive language to the employees that would work in these offices. But it doesn't just state it once, it states it twice in the bill. And that's why we're invoking McCarthyism, these blacklists. Like, these are folks who are being penalized for working in offices that deal with anything doing with diversity and helping work with our federal workforce to address these issues. So that is what the amendment is trying to achieve. I also want to just take a moment while we're on this topic, is almost all of the discussion today has been about the first several sections of the bill and basically the federal workforce. But if the stated purpose of this bill was really just about like, oh, we're going to, change the way the federal government does its DEI stuff, then why on earth does this bill include sections at the end that is tinkering with the entire financial sector? This bill has language in it that says that publicly traded companies on the stock market cannot use diversity as a measure of their boards. And it also says that stockbrokers and licensed folks who work in our financial system cannot engage with that. In addition to that, there's multiple sections in this bill that prohibit federal funding, whether it's grant money or it's money that would go to federal contractors who even discuss diversity. So there were some comments made here a moment ago about, we need to defend free speech. This bill is literally trying to regulate the free speech of the free market, private companies, the financial sector, nonprofits, and our federal agencies. So I appreciate the intent of trying to maybe make the federal workforce more streamlined if I was to give the benefit of the doubt to this. But this is a wholesale effort to basically do away with every initiative that has made it possible for women, people of color, and LGBTQ people to participate in the federal government, our financial sector, the military, nonprofits, and in the services that our federal government provides. So I find it laughable that we would even entertain the premise of it. I yield to the gentleman.
Thank you. Thank you for yielding. Just going to go back to my point and conversation with Representative Higgins. What the ranking member's amendment does is that language that we just discussed, that identical language appears 3 times in the bill. It's not just there once. I pointed it out once, but it's there verbatim 3 times. So it just eliminates the identical language in the 3 places it's in the bill. It's in the bill 5 times. I stand corrected. It's in the bill 5 times, but it eliminates the identical language. And let me just again go back. You guys won the White House. You're going to be in charge of this. You're going to be the one deciding if they get to transfer to a job. It's going to be Trump people who will get to approve that. All we're saying is don't make them second-class federal employees. Don't create a new subsect of federal-class employee. That's what we're saying to you. Your bill is going to move out of this committee, but this is a weakness in your bill.
Any other members seek recognition?
I yield back.
Yes, Chairman.
Mr. Cloud.
First of all, I just wanted to thank the ranking member for your kind and generous acknowledgement of history and what Republicans have done in the past to work on this issue. I had thought to bring that up because there's been allegations like we would not want history taught in schools. I would actually want all of history taught in schools. I don't view this as I realize it has political undertones. I think this is an issue of the human condition and heart that needs to be addressed more than a political one, although I'm not ambivalent to the political undertones there. But anyway, in an effort to not raise the temperature, I had not brought that up, but I appreciate you bringing that up and acknowledging that. I also appreciate the intent and what you're stating on the federal workforce. I would be happy to work with you on that. I do think that this amendment goes beyond that on the reassignment provision. If this were, for example, to be the last line of this amendment, strike section 502A2, that would be something I could support. But in its current state, and again, we did not get an advanced copy of this, so we're dissecting this live, but it seems to also prohibit the reduction in force, which if we have agencies, if we have workforce that, again, are not required by the American people, I don't think that federal workforce should be discriminated because they worked in a certain agency. In the same way, I don't think that the American people who, while I appreciate the federal government, my first allegiance is always going to be to the American people, I don't think the federal or the American people should have to have the burden of hiring and funding someone just for the sake of them getting preference and priority in transferring. So if we could limit it to that, I could accept that, or we could work. I'd be happy to work with you, but in its current state, I would have to oppose the amendment.
Would the gentleman yield?
Yes, sir.
Yeah, but thank you kindly for the offer. I see what you mean about the language about closing and terminating and undertaking appropriate reduction in force. Of course, if that language is gone, still the whole operative meaning of the bill is to close the program and the office. But that's language that could presumably be preserved or put someplace else. But what we're talking about is just the impact on federal workers who've done nothing wrong other than their jobs. Presumably, if they did something wrong, they could be terminated for those reasons. But those people, they're not guaranteed a job, but they should have the same opportunities as other federal workers potentially to be transferred or reassigned to another lawful purpose. What you're creating here with the legislation is a statement that this is no longer a lawful purpose to be engaged in various activities you've enumerated. So I'm happy to work with you on that. I don't think it's necessary to say that the workforce can be reduced because obviously it will be if the program's closed, but no problem there. Happy to yield back.
Any other members seek recognition? Seeing none. The question is on the amendment offered by Mr. Raskin from Maryland. All those in favor signify by saying aye.
Aye.
All those opposed signify by saying no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. The question is now,
Could I just seek a roll call vote on that, Mr. Chairman?
okay. A recorded vote is ordered as previously announced. Further proceedings on the question will be postponed. Do any other members wish to speak? Ms. Presley.
Mr. Chairman, I have an amendment at the desk.
Have the clerk will distribute the amendment to all members. We will pause so that members have a chance to read the amendment.
Oh, okay. All right, thank you.
Amendment to the amendment in the nature of a substitute to H.R. 8706, as offered by Ms. Presley of Massachusetts.
I reserve a point of order.
The gentleman from Arizona reserves a point of order. Without objection, the amendment is considered as read. Ms. Presley from Massachusetts is recognized for 5 minutes.
My amendment is straightforward, Mr. Chair. The text of it reads, quote, on page 30, line 22, application to HBCUs. Nothing in this section shall be construed to prevent the maintenance and funding of historically black colleges and universities, end quote. This amendment would exempt HBCUs from the federal ban that this bill places on funding for institutions that acknowledge racial oppression. As everyone on this committee can read, this bill prohibits funding for DEI practices, and it defines prohibited DEI practices very broadly, including banning the acknowledgement of racial oppression. Thus, for Title IV of this bill, it bans any organization that recognizes racial oppression from receiving grant funding. This has a direct impact on our nation's HBCUs. HBCUs were founded to provide higher education opportunities to Black Americans who were denied access due to slavery and segregation and systemic racism. These institutions are pillars of resilience, history, and excellence. Many of our congressional aides, and in fact our congressional colleagues, are graduates from HBCUs. HBCUs enroll and graduate a diverse student population, including first-generation college students and those from low-income families. While they make up only 3% of colleges and universities, they produce nearly 20% of all Black graduates. And they accomplish this feat despite chronic underfunding. This Republican bill, the Dismantle DEI Act, would result in HBCUs being banned from receiving federal grant funding. HBCU professors, researchers, and students would be cut off if this bill passes as it is currently written. That is why my amendment is necessary to protect HBCUs. I'd also like to add that some of the oldest HBCUs are in Cheney and Lincoln in Pennsylvania, Wilberforce in Ohio, and UDC right here in the District of Columbia. Each of them was first created before the Civil War and the Emancipation Proclamation. Further, several of my colleagues on both sides of the aisle have HBCUs in their home states, including Chairman Comer and many of those serving on this committee. There are HBCUs in Alabama, Florida, Georgia, Kentucky, Louisiana, Missouri, North Carolina, Ohio, Pennsylvania, South Carolina, Tennessee, and Texas. all stand to be harmed by this legislation. But it's not just the schools who will suffer. It's the professors who teach at them, the students who enroll, the community members who live near them, and the entire country that benefits from HBCU success. Finally, when it comes to our bottom line, HBCUs generate $16.5 billion in direct national impact across the country. If they were a company, they would be placed in the top 50 of Fortune 500 companies when it comes to job creation. And that is why this amendment is necessary to protect our HBCUs, and I urge my colleagues to support them through this amendment.
Gentlelady yields back.
Yield.
I'll recognize myself. Chair recognizes Mr. Cloud to speak on the amendment.
I have no opposition to this, and as a former member of the Ag Committee, have supported funding for this, and so I do not see an issue with this amendment.
All right. Any other members seek recognition?
Support it.
You asked.
Yes, I'd like to request yeas and nays, and thank you.
Any other members seek recognition? Seeing none. The question is now on the amendment offered by Ms. Presley. All those in favor signify by saying aye. 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 All those opposed signify by saying no. In the opinion of the chair, the ayes have it, and the amendment is agreed to.
I request the yeas in appointed voter.
A recorded vote is ordered by Ms. Presley. As previously announced, further proceedings on the question will be postponed. For what purpose does the gentlelady from Massachusetts seek recognition?
Oh, Mr. Chairman, I have an amendment at the desk.
The clerk will distribute the amendment to all members.
Okay. That's okay.
Oh, they're ready.
This is going to take a minute. I'm not ready.
That's okay.
Mr. Chairman,
Well, yes, you weren't here yet.
reserve
Ready?
point of order, sir.
Point of order is reserved by Mr. Higgins. We're distributing the amendment.
Okay, thank
Yeah.
you.
Little break in the action. I am going to be switching to the House Judiciary Committee in just a few minutes. We have Xavier Becerra. He's going to be grilled by Jim Jordan and company.
The second amendment to the amendment in the nature of a substitute to H.R. 8706 is offered by Ms. Presley of Massachusetts.
The amendment is considered read. I now recognize Ms. Presley.
Mr. Chairman, my amendment seeks to ensure that this legislation does not erase or ignore the undeniable history of systemic racism in our country. It adds a section to the top of the bill that is a straightforward acknowledgement that, quote, the federal government has implemented policies that perpetuate systemic racism, end quote. Systemic racism refers to a network of public policies, institutional practices, cultural norms, and social structures that work together to maintain racial inequities. This is not a matter of opinion, it is a matter of fact that originates in the founding of this nation and has implications to this very day. Our government has been deeply intertwined with this system, from enshrining slavery and the 3/5 compromise into the United States Constitution to implementing redlining, segregation, and other discriminatory policies based on race. Now, I know that talking about the existence of racism in America makes some uncomfortable, but remember, this is a bill that you all brought up. So to my colleagues, let me just say that acknowledging these truths is not an act of blame. It is an act of responsibility. We must take responsibility. If you are serious about ending reverse racism, you need to acknowledge that it exists in the first place, and that means voting in favor of this amendment.
Gentlelady yields back. I'll recognize myself. Oppose the amendment, which adds a rule of construction to the bill's amendments to the Civil Rights Act to state that nothing in the bill should be interpreted as denying that the federal government has implemented policies that perpetuate systematic racism. Nothing in the bill speaks to the issue. Therefore, no rule of construction is necessary. I urge my colleagues to oppose the amendment. Any other members seek recognition? Seeing none. The question is on the amendment number 2, offered by Ms. Presley. All those in favor?
Yeah.
All those?
I'm sorry, can I be recognized?
Are you seeking recognition to
Yes,
speak?
yes, Mr. Chairman.
I thought we'd already recognized you to speak. I guess somebody, can you yield Ms. Presley time?
May
Mr.
I?
Mfume?
Chairman, yeah, I would yield time to the gentlewoman from
Subcommittee will come to order.
Mr.
Without
Mfume yields
objection,
his
the chair
time
is
to
authorized
Ms.
to
Presley.
declare a recess at any time.
Thank you. Ignoring
Today,
systemic
the
racism
subcommittee
will not.
meets to conduct oversight into the activities of the Office of Refugee Resettlement administered by the Department of Health and Human Services. We welcome HHS Secretary Javier Becerra to answer questions that we have arising from his administration of this office. I think we'd all agree that if a child shows up lost and alone on your doorstep, you've got a moral obligation to find out where that child lives and return them safely home. The last thing any decent person would do is to take that child to a stranger's house and leave them there. Yet it appears this is exactly what this administration has been doing for the last 4 years. In just 4 years, this administration has deliberately allowed 7.6 million illegal aliens to enter the United States, releasing more than 5.7 million illegal aliens into the country, while more than 1.9 million known gotaways evaded apprehension, an illegal population larger than the state of Arizona, our 14th largest state. And among them have been an estimated 530,000 unaccompanied alien minors. That's about the entire population of the state of Wyoming. Instead of protecting these children until they could be returned safely home or until their rightful families could be located, HHS deliberately circumvented protocols designed to protect these children and abandoned them to poorly vetted sponsors in the United States. The House Judiciary Committee estimates that roughly 150,000 of these children have now disappeared. They've simply vanished into a dark underworld of sex and drug trafficking, forced labor, gang activity, and crime. Of course, many are not helpless children, but rather teenagers or adults posing as teenagers who themselves present a mortal threat to the public. Take the case of Walter Javier Martinez. He was transferred to the Office of Refugee Resettlement as an unaccompanied alien child, despite a previous arrest in El Salvador for illicit association with MS-13. One call to Salvadorian authorities would have confirmed this. Maryland authorities later noted that he had gang tattoos. Instead, Martinez was released into our country, no questions asked, and on July 27, 2022, he brutally attacked and killed Kyla Hamilton, who was sound asleep in her own bed. While the prime suspect in her murder, Martinez was placed in a foster home with other children and enrolled in a local high school. He has since admitted to 4 murders, 2 rapes, and additional other crimes. Juan Carlos Garcia Rodriguez from Guatemala, also fast-tracked into our country by this administration as an unaccompanied alien child and released to an unrelated sponsor who was himself an illegal alien. On August 12, 2023, he murdered 11-year-old Maria Gonzalez in her own home, wrapped her body in a trash bag, and stashed it under her bed for her father to find. We don't know how many more such monsters are among the 150,000 unaccompanied alien minors that HHS has lost track of, or how many helpless children have been abducted and exploited. but we are slowly finding out tragedy by preventable tragedy. What we know is that in 2021, Mr. Becerra removed the requirement that ORR provide biographic and biometric data for all adult members of a sponsor's household to check for criminal histories. What could possibly go wrong? Records produced by a whistleblower show that in 2021, HHS disregarded repeated warnings by a case manager about the MS-13 affiliation of one sponsor attempting to take custody of 2 unaccompanied alien children. According to the New York Times, Secretary Becerra berated employees for not processing minors fast enough, saying, quote, "If Henry Ford had seen this in his plant, he would have never become famous and rich. This is not the way you do an assembly line." In July 2021, concerned employees drafted a memo warning that labor, quote, labor trafficking was increasing and complaining that the agency had become, quote, one that rewards individuals for making quick releases and not one that rewards individuals for preventing unsafe releases. According to press reports, Mr. Becerra told then ORR Director Cindy Huang that, and I quote, if she could not increase the number of discharges, he would find someone who could. Huang resigned a month later. Now, the American people have already passed judgment on these policies in the recent election. But those responsible have much to answer for to the victims of their policies and to history. And we welcome the Secretary here today to account for his actions. With that, I yield to the ranking member for her opening statement.
Thank you, Mr. Chairman. At the outset, I just want to note that this is the first Immigration Subcommittee meeting without Representative Sheila Jackson-Lee. She was not only a long-term member of this subcommittee, but she served as its ranking member from the 105th through the 109th Congress. And when it came to advocating for those in need, there was simply no better champion than Representative Jackson-Lee. Back in 2020, I remember when reports emerged of women being subjected to forced medical procedures in immigration detention that left some women unable to bear children. My office found a survivor who was Representative Jackson-Lee's constituent who was about to be deported, and I reached out to the representative who jumped right on it. Not only did she stop her deportation once, she actually stopped it twice. She was a relentless advocate, and her voice on this subcommittee will be missed. On today's hearing, I want to start by commending Secretary Becerra for coming before the subcommittee today. Our staff went back and looked, and we believe that this might be the first time that the Health and Human Services Secretary has ever come before the Immigration Subcommittee. It shows once again how accommodating the Biden administration has been when it comes to oversight. Unfortunately, this is just another show hearing by the majority. With just 6 weeks left in the 118th Congress, this is only the second immigration-related hearing in the Judiciary Committee to which our colleagues in the majority have actually invited a government witness. Today's hearing will be one final attempt by the majority to use all their same false talking points, that the Biden administration purposefully created a border crisis and lost, in quotes, lost tens of thousands of children, all of which we know is wrong by the facts. And I'm sure the Secretary will address this as well. But let's just be clear, these children are not lost. HHS's legal authority ceases once an unaccompanied child is united with a sponsor, usually a parent or a close relative. While HHS conducts 3 follow-up calls to ensure that everything is going well between a sponsor and a child, the agency has no ability to force their way into the home. If no one answers these 3 calls, then HHS is no longer in contact with the child. Now, that does not mean that the child is, quote, lost. And further, this is not a new policy. Previous administrations have dealt with similar reports of missing children who have been released from HHS custody. For example, in 2018, there was a widespread report that the Trump administration, quote, lost contact with approximately 1,500 unaccompanied children during just a 3-month period. Those children were also not lost. They were following the same procedures that this administration has followed. Soon, Republicans will not have anyone to blame. In a few short weeks, they will have full control of the government. Republicans will actually have to govern and take responsibility for what happens in the country. Unfortunately, this majority has shown again and again that they're not serious about finding solutions to our complex immigration system. While we will hear Republicans ranting today about children being trafficked into the country, the only legislation that this majority has passed on this issue would actually gut protections for unaccompanied children. That cruel, inhumane, and unworkable bill, H.R. 2, would allow unaccompanied children to languish in Border Patrol facilities for up to a month. It would force children to appear within 2 weeks before an immigration judge with no access to an attorney, and it would send children back to their home countries where they are at high risk for exploitation and abuse. Their bill, by the way, would also decimate the bipartisan Trafficking Victims Protection Reauthorization Act, or TVPRA, which Congress passed on a sweeping bipartisan basis and established the U.S. government's central framework for keeping unaccompanied children out of the hands of traffickers. Democrats want to protect children and not make it more difficult for them to stay safe. And we have more work to do, real serious work to do to make that happen. I was devastated last year reading articles about young children who were taken advantage of by unscrupulous sponsors and employers, and the potential warning signs that were missed. This increase in child labor is a trend that has been steadily on the rise, especially since 2018. It's completely unacceptable, and I've been shocked to see Republican state legislatures respond by passing bills that actually weaken the protections on child labor. In response, HHS finalized regulations aimed at protecting unaccompanied children that are placed in HHS's care. The rule improves HHS's placement and release processes for unaccompanied children. It strengthens kids' privacy and legal rights, and it sets minimum standards for emergency and influx facilities designed to hold children when there is insufficient space in permanent facilities. The Departments of Labor and Health and Human Services have also put in place a variety of new efforts to combat exploitative child labor, including a new interagency task force to improve coordination and information sharing amongst agencies. At the same time, we know that the Office of Refugee Resettlement and the administration overall need to do more to ensure the safety of kids. And to do that, we in Congress have to provide sufficient funding to these agencies for that critical work. That includes funding to increase post-release services for children after they're placed with a sponsor, as well as appointment of counsel for all unaccompanied children to ensure that they understand the extremely complex immigration system. Improvements in both of these areas would help protect children from mistreatment, exploitation, and trafficking. And that funding, unfortunately, is something that the Republican majority has been unwilling to do. The Department of Labor also does need to be more aggressive in going after unscrupulous employers to the fullest extent of the law. Many of these employers were using E-Verify, which just goes to show how ineffective that system is. And they should be held accountable for hiring kids and subjecting them and all other workers to harsh conditions. I look forward to hearing from the Secretary today. The protection of children from exploitation, abuse, and trafficking should be a bipartisan issue, and I hope my colleagues approach it in that way. I thank you for your service, Mr. Secretary, and I yield back.
I'm now pleased to recognize the Chairman of the House Judiciary Committee, Congressman Jordan.
Thank you, Mr. Chairman. So let me get this straight. So a lost child is not actually lost. We just can't find him. 150,000 of them. That's the issue, and that's why we're glad the Secretary is here today to finally answer some of our questions. I do appreciate the Secretary showing up. Had a chance to serve with the Secretary when he was in the Congress. And I appreciate the ranking member. I just disagree with what you had to say. We've worked on other issues together, but you know, you can't say, oh, they're not really lost. We just can't contact them. That's the problem, 150,000. And I appreciate the chairman's work and this committee's work. The chairman was the primary driver of H.R. 2 that we passed a year and a half ago that would have solved so many problems with our border and with our immigration system. So I appreciate the work that he's done, and I appreciate this hearing. With that, I yield back.
Thank you. Next, pleased to recognize the ranking member of the House Judiciary Committee, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, today the Immigration Subcommittee is conducting an oversight hearing on the Department of Health and Human Services. I'm all for the committee exercising its robust oversight authority, and I certainly hope the committee plans to subject the incoming administration to the same degree of oversight it has utilized for the outgoing one. And what an administration it is shaping up to be. A Fox News host who advocated for pardoning war criminals and thinks women should not serve in combat as a Secretary of Defense. A pro-Putin propagandist for Director of National Intelligence. A former congressman whose only experience with prosecution is his own alleged criminal entanglements to serve as Attorney General. And most applicable to today's hearing, an anti-vaccine, conspiracy-peddling extremist with a penchant for eating bears for Secretary of Health and Human Services. These may be some of the most unqualified candidates for cabinet posts in living memory. It turns out, when you burn through the serious people in your first administration, there are slim pickings for the second one. We in Congress have an important job as a co-equal branch of the government. We have a mandate to conduct oversight over the executive branch, and the Senate is constitutionally required to evaluate and, if appropriate, to confirm or reject presidential appointees. We were elected by our constituents to perform these responsibilities, no matter which party sits in the White House. The responsibilities we have are serious, but this majority is deeply unserious, and this hearing is sure to exemplify this fundamental lack of seriousness. I am sure that we will hear today a great deal about the children the Biden administration allegedly lost, although this is a thoroughly misleading claim based on half-truths and without necessary context, as the ranking member of the subcommittee pointed out. To be clear, there are systemic problems at the Office of Refugee Resettlement that have endured across administrations of both parties, and any child who is harmed as a result is one child too many. But while the Biden administration has taken important steps to address these concerns, the policies the majority has pushed throughout this Congress, coupled with those that President-elect Trump plans to put in place, would gravely harm immigrant children and make the situation far worse. For example, the majority's marquee immigration legislation would gut protections for unaccompanied children, increasing the exploitation of children, and send them back to the traffickers and abusers Republicans claim to abhor. Republican-led states like Florida, Iowa, and Arkansas have all made it easier for children to work longer hours in more dangerous jobs, paving the way for exploitative work conditions for all children. And President-elect Trump has promised to bring back some of his cruelest and most harmful policies, including family detention and remain in Mexico, and he's not even ruled out bringing back family separation. Does anyone truly believe that these are pro-child policies? The Republican majority has also failed to provide the Departments of Health and Human Services and Labor with the resources and authority they need to properly protect these children and to go after exploitative employers. Is there any reason to believe that they will do so under the next administration? And do we really believe that the person nominated to be the next HHS Secretary, a man whose theories and views contributed to the preventable measles deaths of dozens of children in Samoa, would adequately protect children in this country? Do we believe a government beholden to Elon Musk and his promise to cut trillions of dollars from the federal budget is going to adequately fund programs designed to ensure children are properly cared for? When we inevitably get reports of children being torn apart from their parents or shipped off to countries they cannot remember or have never lived in, of inhumane conditions in the tent city detention centers the incoming administration plans to set up, or of deaths in custody, are we going to see the majority exercise its oversight authority and hold the Trump administration to account? I won't be holding my breath. Secretary Becerra, it's good to see you. I appreciate you being here today and all of the good work that HHS has done under your leadership. I look forward to your testimony, but if you came here in hopes of a thoughtful, meaningful debate on policy, I'm afraid you'll be sorely disappointed. Thank you, and I yield back.
Thank you. Well, now that we've come to a bipartisan agreement on these vital measures, it's time to introduce today's witness. Mr. Javier Becerra is the Secretary of Health and Human Services, a position he's held since March of 2021. Secretary Becerra previously served as the Attorney General of California and was a member of the House of Representatives between 1993 and 2017. We welcome him and thank him for appearing here today. We'll begin by swearing you in, Mr. Secretary. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Thank you. Let the record reflect the witnesses answered in the affirmative. Please know your written testimony will be entered in the record in its entirety, and accordingly, we'd ask that you summarize it. So, Mr. Secretary, you may begin.
Mr. Chairman and ranking member and the members of the committee, thank you for inviting me to discuss the work of the U.S. Department of Health and Human Services Unaccompanied Children Bureau within the Office of Refugee Resettlement. Before I begin my comments, I do want to add my words to those of the ranking member who mentioned our former colleague, Sheila Jackson Lee, a dear friend, someone I had a chance to serve with for many, many years, and a true champion of people who really just believed in their government and in their Constitution. So we miss her, but it's good to know that we always think of her. Mr. Chairman, let me begin by clarifying some confusion or misunderstanding over ORR's work. First, ORR is not an immigration or law enforcement agency. It does not possess such powers and does not render decisions in those areas. Second, pursuant to congressional mandate, ORR provides temporary custody and care, including support services for unaccompanied children. ORR fulfills its congressional mandate by funding nearly 300 programs in 29 states, including shelter programs, transitional foster care, long-term foster care, group homes, heightened supervision facilities, and residential treatment centers. At these facilities, our contractors deliver child-focused services in accordance with child welfare best practices. That includes access to health care, education, recreation, counseling, and legal services. And third, HHS's custodial responsibility and oversight for unaccompanied children through ORR ends once we place the child with an appropriately vetted sponsor. As important as this work is, we know, and child welfare experts will tell you, that the best place for a child is with a family, in a home, in a community, not in a congregate care facility. That's why we work so hard to find and vet potential sponsors for an unaccompanied child. In fact, an overwhelming number of children released to a sponsor by ORR were placed with a parent, legal guardian, or close family member. As any parent will tell you, to really raise a child, you have to be all in. The children we encounter at ORR enter the country without any parent or adult guardian. The challenge for these unaccompanied children is immense. We have worked tirelessly over the past 46 months to build a sustainable network of trained and licensed caregivers who can meet this challenge. Our network of small-sized caregivers means no child stays in a barrack-style housing. We work to keep tender-age children separate from older adolescents. We strive to house siblings in the same facility together. We expand services so children can receive information and guidance from legal advocates. We expanded care management and sponsor placement operations to 7 days a week. We established the UC Ombuds Office so that staff and stakeholders may raise concerns to an independent, impartial body. We established the ORR Integrity and Accountability Team to further identify and prevent attempted fraud. We executed a memorandum of agreement with the Office of Trafficking in Persons, with the National Center for Missing and Exploited Children, and with the Department of Labor to help protect the children after they leave our care and custody. And we extended our access to post-release services to every child we place with a sponsor. Like parenting, the work of ORR and our network of caregivers is nonstop, and we are constantly striving to improve. We set clear rules for standards of care, and we have zero tolerance for behavior by care personnel that threatens the safety and well-being of children. All incidents of inappropriate behavior must be reported to ORR, and we take action as well as report and coordinate with appropriate authorities. These are the trademarks of an enterprise that understands its weighty responsibility towards the very vulnerable populations we serve. I want to publicly express my gratitude to the ORR team for never letting up against the many challenges they face daily in prioritizing the safety and well-being of the unaccompanied children who come into our care. These dedicated professionals may not be the parents of these kids, but they are, and all of us at HHS are, all in. Mr. Chairman, that concludes my testimony. I look forward to your questions.
Thank you, Mr. Secretary. We'll now proceed under the 5-minute rule with questions. The chair recognizes the gentleman from Arizona, Mr. Biggs, for 5 minutes.
Thank you, Mr. Chairman. Secretary Becerra, do your policies at ORR place priority on speedy placement of the unaccompanied child with sponsors or taking care of their safety and protection once they've been placed?
Thank you, Congressman, for the question. The safety and well-being of children in our custody is our #1 priority.
Well, so that's important to know because your record indicates that biometrics for the sponsors were eased up there. The use of DNA, I'm going to read from your directive from March 22nd, 2021. Use of DNA is only used for the purpose of establishing biological relationships for purposes of sponsorship and is not submitted to law enforcement personnel or run against law enforcement databases. Catch that last part? Not submitted to law enforcement personnel and not run against law enforcement databases. And to get this part, submission of DNA by the parent is voluntary. How in the world does that protect the child, the unaccompanied minor, when actually what you're doing is you're saying the parent, whether you submit to DNA, that's voluntary. So you're going to be taking whoever it is, the sponsor, their word. So how does that protect the child?
Chairman, thank you for the question. We use a number of tools to make sure we can identify the child and certainly do the background checks on anyone who wishes to be a sponsor. We always hope that we can get the most direct information about the the people who are wishing to sponsor these children. And we use, as you mentioned, a number of techniques, including fingerprinting and DNA on occasion when it helps us to identify
on occasion. And if you don't have the DNA and you don't have the fingerprints, how in the world are you checking the databases for the background? How are you vetting them?
We have a number of techniques that we use to make sure we're
What are they?
They can include any number of things such as, sometimes it will include fingerprints, it will include a direct interview with the individual, it will be a check on citizenship documents, it will be a
How often do you use fingerprinting or DNA?
Again, it depends on the type of information we have to identify the individuals who are wishing to sponsor.
So let's read this one here. This is from Directive 10 days later, March 31st, 2021. Effective immediately, background check requirements for adult household members and alternate adult caregivers identified in a sponsor care plan are not required as a condition of release under any Category 2. So it's not required all the time, right? It's just it's voluntary for DNA for parents. So how can you say that your #1 priority is the safety of these unaccompanied children when you're placing them in sponsors' homes that, in an occasion, have had criminal gang affiliations because there's been no proper background check? How can you say that?
Congressman, if you follow child welfare best practices, you do an extensive background check. We follow child welfare best practices, so we do those extensive background checks, which could include any number of things.
So how did it happen? I've got this report I'd like to submit to the record. This is Senator Grassley's report.
Without objection.
How did we see children end up in the homes of MS-13 gang members as the sponsor? How'd that happen?
Congressman, I don't have any information before me that you're referencing, but what I can tell you is that no sponsor would be allowed to take a child if we have information that shows that they are engaged in criminal activity.
But if you don't do the vetting right, you don't know if they're engaged in criminal activity. That's how you end up with an MS-13 gang member as the sponsor. That's how you end up with pedophiles getting 20 children in the same home. That's how you end up there because the vetting's been crappy. I mean, that's the bottom line. So if we go on and we get to this other aspect where you say the emphasis is on safety, not speed, I'm going to read to you now the memo of concern filed in July of 2021. And the reason that I read this, even though it's dated somewhat, it seems to be still the conditions. This is from page 2. Since the beginning of this current influx, ORR field staff have seen the transformation of the Division of unaccompanied children's operations within ORR from a child welfare focus model to one that emphasizes what seems to be, quote, release to someone as soon as possible, close quote, model, close quote. So I know you've lost contact with these children, and now we're told that when you lose contact with these children, it's not being lost, but it is being lost. I ask for all of these to be included in the record, Mr. Chairman, and yield back.
Without objection, the gentleman's time has expired. Ms. Jayapal's for 5 minutes.
Thank you, Mr. Secretary. Again, thanks for coming here. Earlier this year, I know HHS finalized regulations governing the placement care and services provided to unaccompanied children in HHS custody, and my understanding is that these regulations improve the department's placement and release processes for unaccompanied children, strengthen children's privacy and legal rights, and set minimum standards for emergency and influx facilities designed to hold children when there is insufficient space. The regulations also codify the current requirement that an at-home study be conducted before releasing a child to a non-relative sponsor who is attempting to sponsor multiple children, who previously sponsored a child, or if the non-relative child they want to sponsor is under 12 years old. A lot of this seems responsive to the concerns that were raised last year following a report from the New York Times that children were working unlawfully in factories across the Midwest and that some sponsors had taken in multiple unaccompanied children. Can you just confirm to Mr. Biggs's question, you do a full background check on everybody, is that correct?
Yes, we do.
So you run them through the databases. If they have criminal histories, that's going to come up in the full background check. Is that right?
That's correct.
So can you discuss the importance of the regulations that you passed to protecting unaccompanied children in HHS's custody? And then second, can you discuss why the home study requirement for children under 12 who are not placed with a close relative is so important to protecting kids from trafficking?
Congresswoman, the rule that you've mentioned that we recently actually got through and have now put in place was important because it put a clear signal of what we do and how we do it so that all of our contractors who care for these kids understand the rules. And so they must make sure that if they're going to vet a particular sponsor, they go through the full level of extensive checking on background, whether it's a sexual offender registry, whether it's making sure that if they need it, they use fingerprints. So we want to make sure there's no ambiguity about what their responsibility is to make sure that they are putting first and foremost the safety of that child first before they place that child with a sponsor. And that foundational rule has now put in place what we've learned over time, because if you'll recall, we inherited a dismantled, a broken system for child care of these unaccompanied kids. And we had to essentially rebuild the process. Along the way, we've learned a great deal about how to do it better, how to strengthen it, and this foundational rule really incorporates that.
Yeah, thank you. So, I mean, I just want to be clear. It's not like you're just placing kids with people who have criminal records, people who are known gang members. You're going through a full, extensive background check before you place any child. I understand that many of the factories unlawfully employing children used E-Verify. And it's clear that many of our immigration laws and tools, including E-Verify, are not sufficient to meet the demands of our modern world. The immigration system hasn't been meaningfully reformed in over 30 years. You and I have both worked on that issue for a long time. What reforms to the immigration system would you recommend to help HHS protect unaccompanied children entrusted to your care?
Well, Congresswoman, one of the things that we've worked hard to do is to expand our post-release services, because as you mentioned in your opening remarks, once we have placed the child in the care of a sponsor, a vetted sponsor, we no longer have responsibility, we no longer have jurisdiction over those children. We should be able to have that post-release service made something we can do all the time. Right now, we offer it to the kids. They're not required to take it, but we're also depending on the resources to actually offer those services. If we don't have the resources, we can't offer those post-release services. That would help, certainly, if there's an employer who is exploiting a child and employing them against the law. I would hope that this committee would do the same type of hearings, same type of investigation of the employers. We follow the law at HHS, employers should too.
Yeah, really important point. I don't think we've dragged any employers up to the table to talk to them about why they are abusing these labor laws and employing child labor. I want to discuss appointed counsel because I think this is really important. It's outrageous to me that kids, including toddlers, are forced to literally show up in court facing a prosecutor and they've got no representation. I think a lot of Americans just may not know that. As you know, HHS is required to arrange for legal representation for unaccompanied children to the greatest extent practicable. And I know that you share my empathy with these kids, but so much of this is, again, contingent upon funding that is given to the agency. So given how complicated the immigration system is, just can you briefly discuss, my time is out, but the importance of providing counsel to unaccompanied children?
Giving kids the right information is crucial, and Mr. Chairman, I recognize my time has expired, so I'll be brief and say, we do everything we can to make sure they understand what their obligations are. We don't actually hire them attorneys, but we try to give them some information, provide the advocacy, but again, it's all contingent on having the resources to go to that extent of services.
Thank you, Mr. Secretary.
Mr. Biggs for a unanimous consent request.
Thank you, Mr. Chairman. I think the rule that that the witness might have referred to is Title 45. I'd like to submit it for the record, where it makes public records checks and FBI national crime checks optional for the sponsors and adults living in the
Without objection, Mr. Tiffany is recognized for 5 minutes.
Thank you, Mr. Chairman. The ranking member ripped on the Trump appointees in his opening remarks, which we largely expected. But I just asked the Secretary of the Department of Health and Human Services, do you have a medical degree?
I do not.
You do not have a medical degree. Are you familiar with the Florida grand jury presentment that they did about a year and a half ago in 2023 in regards to unaccompanied alien children?
I'm somewhat familiar with it. I was briefed on it on many occasions.
Are you familiar that in that report, it revealed that children were pimped out by their aunt, which it turns out the aunt wasn't even related to the child, the so-called aunt? Are you familiar with that story that was in there?
There are a number of incidents that are reported in that Florida report. Some of them I can probably recall better than others. Some of them I would challenge and dispute, but that one I don't remember.
And do you remember the teenage girl that was in a house with unknown men with no private bedroom for her? Are you familiar with the sponsors that utilize a strip club in Jacksonville as an address for where this child, where a child should be settled?
Congressman, as I said, I don't have the information on that Florida grand jury report in front of me. I certainly can go back and take a look at it and try to get back to you.
Are you familiar that the case managers are only performing home studies, or the case managers are only doing case studies or home studies in 4.5% of placements in Florida? Only 4.5%. In fact, discretionary home studies were 1%. Is that all you folks are checking up on, these kids that are so vulnerable?
Congressman, thank you for the question. Congress, in passing the laws that apply to the unaccompanied children, said that home studies would be reserved for those children who came to us with circumstances that showed trauma or the need for additional services. So by law, by statute passed by you in Congress, those of you in Congress in the past, we have the obligation to conduct these home studies only in those particular cases. We provide a home study.
So you decided to do the minimum?
No, that's
1%. That's what you
about
said.
to go there.
Okay, here's the law. That's all we're going to do. In the meantime, you got kids being placed in addresses like a strip club in Jacksonville, Florida.
That's what I was trying to say, is that's not the case.
In your testimony.
We do home studies at our discretion. Most of the time, we have to wait till we have the funding. No, we have the funding to do those discretionary home studies, but we've expanded them, and that's why the foundational rule has become so important.
In your testimony, you said you coordinate with the states and local municipalities to make sure that you're working with them. In this Florida presentment, it says neither U.S. Department of Homeland Security or HHS actively coordinates or consults with the state on the UAC that are resettled in Florida. Did you see that part of the study? You aren't coordinating with them? Why are you not coordinating with them?
I find that hard to believe because remember, we used to have programs in Florida that had licensed care facilities. Florida decided to unlicense these facilities, and so we've been in constant touch with Florida.
So you said you've seen some of the, what was presented here. Do you dispute the study from Florida?
I have a number of issues with the Florida report.
If you would share with me, and at an appropriate time, not today, if you want to share with me all the things you dispute in that study, that presentment by Florida, I would really like to see it. Because then I want to take it to Florida and ask them, what were you lying about? Because obviously you're telling me that there's some misrepresentation by Florida here. Is that right?
Well, one thing you could really help us with is checking with Florida to find out why they decided to not allow licensed caregivers be part of our program. All the kids that we place in care, we try to place in licensed care
Do you believe
facilities.
you're in charge of an assembly line, as the chairman alluded
If
to?
I could just conclude, but the important thing about Florida is Florida took affirmative action to unlicense centers.
I'll wait
that
for your
provide care.
answer in regards to Florida offline here. That'll be just fine. I want to ask you the Harris question. Would you change anything that you've done over the last 4 years in regards to illegal immigration?
Recognizing that we don't deal with immigration, that is part of DHS's authority. We deal with the care, the human services side of care for kids.
Would you change anything that you've done in the last 4 years with 320,000 children unaccounted for by your administration?
We work tirelessly to strengthen and improve the program of the UC, the unaccompanied children that come before us. And we work really hard to make sure we, first and foremost, protect the safety and the well-being of those kids. Every day is a challenge, and we do the best we can.
Gentleman's time has expired. Chair recognizes Mr. Nadler for 5 minutes.
Mr. Secretary, since Mr. Tiffany kept cutting you off, would you answer the question about Florida that he asked?
Congressman, thank you, because I think this is very important. It's been very difficult to deal with some of the states because we seek out licensed care facilities because that is the best practice to ensure child welfare. And so we don't place these kids with just anybody. They have to be folks who are licensed to care for kids. So when we had our facilities in Florida, they were licensed. Florida took affirmative steps to say that they would not license any caregiver who took care of unaccompanied children. And so today, if a caregiver wants to come forward to provide services to these unaccompanied children we have at ORR, we cannot have them be licensed. So what we have done is we have essentially set the floor of what licensing would require in order to get any caregiver in Florida to be able to care for our kids. But we don't understand why any state would abrogate its responsibility of making sure caregivers are licensed caregivers.
Thank you, Mr. Secretary. Mr. Secretary, as you may know, last year there were media reports about how the Office of Refugee Resettlement did not know the whereabouts of tens of thousands of unaccompanied children who have been released to sponsors since the Biden administration began. Some of my Republican colleagues have latched onto this headline to claim that the Biden administration, quote, lost these children. Let's start with the most important question. Are those children actually lost by the federal government?
Again, you're right, Congressman. That's the way it is framed. I want to be clear.
Can you explain why they're in fact not lost?
Yeah, first to be clear, we have not lost 85,000 kids. We make every effort, even after we lose the authority to continue to monitor the children, once we have discharged them and placed them with a vetted sponsor, we make an effort on our own dime, essentially, to try to reach out to them. We do what we call safety and well-being calls. We try to reach the child and the sponsor 3 times by phone to check in. The children and the sponsors are not obligated to return our call. We can't require them to do so. And by the way, even if they don't call back, that doesn't mean a child is lost.
What are some of the reasons a sponsor or child might not answer when HHS does follow up after release with a phone call?
I'm sorry, say that again.
What are the reasons a child or a sponsor might not answer when you follow up with a phone call?
They may be in school. They may be at a doctor's appointment. They may not have the phone working anymore. There are any number of reasons why they don't answer. And by the way, we do other things in an attempt to try to contact them, including, as I've mentioned, some of these post-release services.
And can you discuss why the Office of Refugee Resettlement is not able to do more? For example, why does it not go to every sponsor's house in person to talk with each child after they're released?
Well, if we had the resources to do so, it would be far easier to have a program that really reaches as aggressively. But what we don't do is shortchange in the vetting process. We make sure that we follow best practices in the child welfare field when it comes to determining whether a child should be placed with a particular sponsor. Whether you're in foster care at the state level or whether you are protecting unaccompanied children in ORR, we use child welfare best practices.
Thank you. It seems like the only actual lost children are the 1,000 children that were separated from their parents by the Trump administration that still have not been reunited to this day. But let's switch gears a bit. Mr. Secretary, thank you and all the hardworking staff at HHS for the important work you're all doing. While ORR does its best to care for unaccompanied minors, we know that the immigration system is broken, that comprehensive immigration reform is needed. My Republican colleagues' marquee immigration legislation, H.R. 2, would allow unaccompanied children to languish in Border Patrol facilities for up to a month, force children to quickly appear before an immigration judge with no access to an attorney, and send children back to their home countries where they are at high risk for exploitation and abuse. Would this kind of legislation help or hurt unaccompanied children?
Congressman, what I will tell you is that if you're going to have the best interests of that child in mind, you're going to try to be supportive of what they need. They are not adults. They don't know all the laws. They don't know all these proceedings, whether it's asylum proceeding or immigration proceedings. And you have to make sure that they are fully aware, and those who can be responsible, an adult who's supervising them, can be available to help them out.
So this legislation would not help. In your opinion, is it better to allow children to remain in the United States with vetted sponsors while undergoing a robust legal proceeding, or to summarily deport them with limited due process back to their home country and the dangerous situation they just fled?
Well, Congressman, again, I'm going to be careful. I'm the secretary. I'm no longer a member of Congress, but I do know the laws when it comes to immigration. Asylum, once you have claimed asylum, you're entitled in this country to a hearing, and that you would have to change those laws before you're able to summarily remove those protections for those who claim asylum.
Thank you, Mr. Secretary. My time has expired. I yield back.
Chair recognizes Mr. Roy of Texas.
I thank the chair. Thank you, Mr. Secretary, for appearing before the subcommittee. You mentioned the state of Florida in the context of, I think you characterized it as not being willing to work with HHS. On March 29th, 2023, a Florida grand jury released a report detailing the impact of the UAC influx at the southern border. The grand jury made some of the following conclusions of the Office of Refugee Resettlement, the component agency within HHS entrusted to you, Mr. Secretary. Excerpt, quote, a disturbing pattern has emerged whereby the same sponsor applies to receive multiple UACs, sometimes at the same address, sometimes at a different one. Some individual sponsors apply to receive more than one child at more than one address simultaneously. One address in Texas had 44 children sent to it. Another had 25. One sponsor in Bonita Springs, Florida had multiple children sent to multiple addresses, and he applied using different versions of his hyphenated surname. One address in Austin, Texas, a town which I represent, had more than 100 UAC released to a single family dwelling. Mr. Secretary, is this remotely consistent with the claims by your department that you're doing everything in your power to ensure child security?
Congressman, thank you for the question. All potential sponsors, anyone who wishes to apply to sponsor a child, must undergo extensive vetting process that follows child welfare best practices. We use a variety of tools. We try to monitor as best we can. And recently, through the foundational rule, we have established an even more extensive process for vetting as well.
Do you believe that the HHS foundational rule from April 30th of 2024 is consistent with what you just said in terms of background checks? Is it sufficient?
The foundational rule is what we've built to try to give us a better way to not only care for kids, but also make sure.
Does it require full public records background checks?
I'm sorry?
Does it require full public records background checks and FBI national criminal history checks?
As I said, we follow child welfare best practices when it comes to.
Yes or no, though? Do you do the full criminal history checks for the potential sponsors of these children?
Well, yes, we follow best practices.
Right. The answer is no.
It's a yes, we follow child welfare best practices.
Yeah, that's not my question. My question is, do you do background checks, the full criminal records, public background checks for the FBI national criminal history?
We certainly check for criminal records. We check for a sex offender in the sex offender registry. We do, again, the different
says you
things
don't.
that the foundation, that.
The rule I'm
Child
talking about
Welfare
says you do not.
I'm sorry?
The rule that we're talking about that was released on April 30th, 2024 says you do not.
We do not what?
That you do not carry out FBI national criminal history checks for all potential sponsors.
We do background checks on every individual.
Right, but that's a slippery description. What I'm saying is this rule is pretty clear in what it's saying, that you do not provide the kind of background checks, which, by the way, has created the problems. Let me move on because in the interest of time. Are you familiar with Maria Gonzalez, an 11-year-old girl who lived in Pasadena, Texas? In August 2023, Ms. Gonzalez was allegedly raped and murdered by Juan Carlos Garcia Rodriguez, a Guatemalan national who appealed at the southern border as a UAC in January of 2023 and was 17 years old. A month later, HHS released Garcia Rodriguez to a sponsor with a criminal history and who previously had 2 other UACs in his care, failed to enroll them in school as required by HHS. How about the situation with respect to another individual, Kayla Hamilton? Are you familiar with Walter Javier Martinez? Martinez was a 17-year-old from El Salvador who appeared at the border as a UAC in March of 2022. Months later, in July 22, he raped and murdered Kayla Hamilton, a 20-year-old woman in Maryland. After Martinez's release from the border and before Mrs. Hamilton's tragic death, HHS released him to a sponsor in May of 2022. Despite Martinez having gang tattoos and an arrest record for illicit association with MS-13. Mr. Secretary, how can you credibly claim that HHS is working to protect these children? And by the way, children we're talking about in the order of magnitude of 400 and something thousand children, which you are dismissing that they are lost. Let me ask you a very specific question, Mr. Secretary. Can you account for the whereabouts of those 400 and something thousand children? The 320,000 that were put in the report by the Inspector General, the 85,000 that we've talked about before in 2023. Do you know where all of these children are and that they are safe? Yes or no?
Congressman, as I explained the process, we get these kids when they are referred to us by the Department of Homeland Security. We then provide them with care while they are in our custody. We lose custody of those kids once we find a vetted sponsor with whom they can stay.
A vetted sponsor that rapes and murders the people that they're entrusted to? Because you issue a rule that doesn't even do the background check? That's what you think is appropriate care for these children? I yield back, Mr. Chairman.
We do background checks.
Gentleman's time has expired. Chair recognizes Mr. Correa of California.
Thank you, Mr. Chairman. First of all, I want to welcome you, Secretary Becerra, to this committee, and wanted to remind you that you are under oath today, sir. You a father?
3 daughters.
Care for them deeply. I think it's safe to say all of us here care for the welfare of all children, irrespective of our blood, their children, God's children. We take care of them, correct, sir?
Even if they aren't your blood children, you try to take care of them.
As a member of the Homeland Security Committee, I've had the opportunity to tour the border, both north and south of our border, gone into Tijuana, those areas where a lot of refugees, asylum seekers are actually held, waiting their turn to possibly come to the U.S. I also had the opportunity to tour a safe house holding children that had been rescued from the sex trade south of the border. Children as young as 8 years old, rescued. You looked at their faces, you know that those kids had lived through unspeakable horror. So I'm going to ask you, sir, in your opinion, is it better to allow children to remain in the United States while they're being vetted, their sponsors are being vetted, and they're going through a robust legal procedure? Or is it better to essentially summarily deport them with limited due process back to their home country or south of the border? Which, in your opinion, is best for those children?
Again, Congressman, respecting that, I don't have immigration law within my jurisdiction. What I will tell you is that we've had decades of research on how best to care for kids, especially those who've undergone trauma. What you want to do is provide them with stability. You want to provide them with the care that they need. You want to make sure that they have a safe place to be. You want to make sure that they are well-fed, they're not ill-equipped. That's what we do. It's a tough job, and we do that for a lot of these kids who've gone through hardship and trauma. If you take them out of that setting, who knows where they will end up, what will happen to them. That is why, in fact, under the law, the Department of Homeland Security does not detain these kids and hold them, because they detain adults. It's an adult detention facility that's used for those who have to be held. That's not appropriate for kids, and that's why under the law we get them. And so when you ask the question, I think you and I as parents, I have 3 daughters, I would want to make sure my children receive the kinds of services that the experts over decades of time have said are the best way to help a child heal and treat the trauma and hardship they've suffered.
You know, I hear my colleagues from the other side of the aisle, colleague from Texas, talking about children that are lost in the system, children that end up in areas not intended to. How long has this been going on? Is this something new? I mean, the refugees have been at our southern border for a couple of decades. So how long have the U.S. government been challenged to work through this issue, dealing with unaccompanied minors as they present themselves in chaotic situations at our border?
Congressman, as you're indicating, number of administrations, numerous previous administrations have had to tackle these challenges.
Both Republican, Democrat.
Republican, Democrat, dealing with the issue of unaccompanied children. And by the way, lost, you can't say because someone doesn't answer a phone call that means they are lost.
Is that part of the definition here we're using, that if you don't answer, if a sponsor doesn't pick up that phone, then that child is lost? Is that what you're saying?
That's what they're interpreting. The fact that a child may not answer a phone call that we place when we try to check in with them, they then extend
Mr.
that to
Secretary,
say that
we all
lost.
have the best interest in mind of these children.
Yes.
So I'm concerned as well. What else do you need? What other tools, what other resources do you need so somebody else can make second, third, or fourth phone call, maybe have a personnel go out and check out that home situation? What do you need to make sure we increase the probability of a safe environment for those children?
So to give you context, in 2021, when I began as secretary, about 1 in every 5 kids we were able to reach through what we are calling our post-release services. Today, we provide that to 100% of the children that we release to a vetted sponsor. What could I use? What would help us? The resources to make sure we could continue that, because the moment you make cuts to our program, our first responsibility is to provide the care in the places that we have, and the secondary thing we can do is try to provide them with post-release services. So if you cut the dollars that we use, if we don't have enough to do our principal responsibility caring for these kids, we have to make cuts to things like post-release services.
Gentleman's time is
Mr.
expired.
Chair, and I yield.
Chair recognizes Mr. Van Drew. Thank you, Chair. Secretary, I want to thank you for your service in Congress. I'm going to let you know, if you don't know it already, I'm a blunt guy, so you're going to have to forgive me in advance. But what's going on here is bad. You know, you talked about mandates. We have a human mandate, a humane mandate, an American mandate. And I hear lots of words. We talk about the bureaucracy, and we talk about, all the speeches that everybody's given, and lots of money is the answer to it. And money sometimes helps, no doubt about it. But you have to have the basic rules, the basic foundation to do things right. And just before I go into some questions and ideas here, let's tell the truth. It's tell the truth time. We ease the background checks greatly. Yes, you do very often do background checks, but they're not good enough, and that was done in the rule. We allow those who want to refuse criminal background checks, and some kids are put in those homes and in danger. Having a criminal background is not prohibited. Let's tell the truth. I can read, this committee can read, we all can read, we know what the truth is, and that all sponsors are not vetted. That's the truth. That's what's really happening. Let's deal with the real world. And you've played an integral role in establishing the Unaccompanied Children Program foundational rule. The details of the rule, to me, are so abhorrent
that it's no wonder some of the worst individuals have been able to exploit it and slip into our country. It's no wonder that hundreds of thousands of unaccompanied alien children have gone missing under this watch. The details of the rule, in my opinion, are insane. We're dealing with kids. We're dealing with children. The rule allows sponsors to refuse background checks. As I said, let me say it again. A sponsor can refuse a background check, and they still can be eligible for taking on a vulnerable child. There's no state adoption agency anywhere in this country, in any state in this country, that would allow this for any foster parent, for any adoptive parent, for any American citizen who wanted to adopt. Why are we not holding sponsors of unaccompanied children to at least the same standard that we hold them? The rule also fails to disqualify individuals with criminal records or child welfare violations from serving as sponsors. How wrong is that? Again, we wouldn't allow an adopted American citizen to do that to an adopted child. Why do we let them? But it gets worse. The rule also actively prevents the sharing of critical immigration-related information with enforcement. You said certain things aren't your job. That's what enforcement is there for. There should be a communication. There should be a dialogue back and forth, especially when sponsors are under investigation for human trafficking or smuggling. You want to know that from the feds. It's evil. It's wrong. I don't know how we justify it. The rule works to undermine age verification processes, and you can read it in the rule. I'm not making it up, which it enables adults posing as children to exploit the system and gain easier access into the United States of America. And even if there is evidence of criminal backgrounds, the rule is designated to create barriers to placing the UACs in secure facilities. This committee has seen the tragic real-world examples of it. Some of it was mentioned by my colleagues. Kayla Hamilton, 20-year-old young woman. She was brutally raped. She was brutally beaten. She was murdered by someone with ties to MS-13 who pretended to be a minor, and nobody stopped it. If we had done our job and put the safety of Americans and the safety of kids over processing illegals quickly, she would still be alive today. And I associate myself with some of the remarks that Congressman Correa said. They're kids. We all love our kids. I know you love your kids. Think about that. This woman's dead. We're not going to bring her back, ever. There's no speech, no bureaucratic action that's going to bring her back. I've seen a lot of stuff, man. I've been in the state Senate, the state assembly, county commission, mayor, congressman now for 6 years. Man, I haven't seen too many rules that are worse than this rule because it deals with kids and it hurts children. It's bad for everyone involved. It's bad for taxpayers. It's bad for American communities. And it's bad, most importantly, for the undocumented children. So I have some questions. I got 23 seconds. Secretary Becerra, I just want a yes or no. Knowing how this rule has worked, do you still believe it was the right answer to the border crisis? Yes or no? Yes or no?
Congressman, the way you've interpreted the rule is not the rule that we passed, so it'd be tough to give you a yes or no.
Well, your interpretation of the rule, do you think it was right?
Well, let me give you a quick example.
I don't need an example. I need a yes or a no. Mr. Secretary, I need a yes or a no. I can always answer questions yes or no. Is the rule good? Is it what you want? Would you continue with it? Yes or no?
Congressman, you said a sponsor can refuse a background check. That's not true. No sponsor who wishes to take a child can refuse a background check.
I read the rule. I had people read the rule a whole lot smarter than me.
That's not the rule we enforce.
I unfortunately have to yield back. Mr. Chairman, I'd like to submit these questions to the chair.
Without objection. Gentleman's time has expired. Mr. Garcia.
Thank you, Mr. Chairman, for the opportunity, and thank you, Secretary Becerra, for being here today, and to your staff for all the work and the progress that's been made to a very imperfect system, and its history goes back a long, long ways. As a former and current foster parent, this issue is near and dear to my heart. I've seen some of the trials and tribulations that children have endured as it relates to trauma. I've seen their resilience, but this remains a challenge to our system and certainly to your office and the Office of Refugee Resettlement. Is it fair to say that the protocols that you utilize in placing children are pretty similar to what most states in the union utilize when placing children?
Foster care programs also try to look to the best practices for child welfare. So I can't say they're exactly the same, but we follow the best practices of child welfare professionals.
And those are pretty rigorous, I might say, as someone who is currently abiding by them. So yes.
You would know.
Most of these children arrive after experiencing severe trauma. Can you describe some of the resources that ORR provides to children as it relates to mental health and emotional well-being, and if they're made available in other languages besides English?
So yes, because so many of the kids come with no familiarity with language, with English, so we do provide language services support. In terms of behavioral health, we do a full assessment of the child once the Department of Homeland Security places them in our care. And we try to make sure we're checking for their physical and mental health to make sure we provide them with the professionals that they might need. And so that could be any number of things. Obviously, the smaller they are, the more intense and professional the service must be. But on behavioral health, mental health services, we will do an assessment and then provide them with the services that they need in our care.
And under your leadership, Mr. Secretary, HHS has finalized much-needed regulations aimed at protecting unaccompanied children. The regulation implements and codified protections required by the Flores settlement and enhances the legal framework as well for the case and treatment of unaccompanied children. Can you describe how the new regulations will help improve the protection of unaccompanied children?
And again, we're talking about the foundational rule, which, to respond to the previous questions by the Congressman, it would be inconsistent with the Flores settlement, the court case, for us to not do background checks. So we must do background checks, not only because our rule says it, but because the case law says we must do it as well. Well, what else do? We provide an ombudsman office. That office is there to make sure staff or stakeholders can report any incident and do it with someone who's impartial and independent of the work that we do to report any incidents that are of concern. We make sure that we provide enhanced medical services, to your point about behavioral health. We provide enhanced educational services to children, and we try to provide legal advocacy services as well.
Thank you. And my final question is, I'm asking you to look at the future from what you have internalized so far during your tenure in your position. As we continue to see migration driven by violence, political unrest, climate change, and economic instability, especially in the hemisphere, how is ORR preparing or should be preparing for potential future surges in possible unaccompanied children at the border?
We have, and this is an excellent question, Congressman, because we never have a clear sense of how many kids will come to our care from the Department of Homeland Security. Obviously, in 2021, there were large numbers. Today, we have got a system that really can manage the children that are coming to us. But what we do is we have to prepare, because we can't afford to not have a place for a child. The consequence is to leave them in an adult detention facility at DHS. And so we make arrangements with potential care providers to have them available. We also have what we call emergency influx facilities that we can quickly ramp up in the event that we have a large influx of children, so we can provide them the services they need.
Very well. Thank you very much. My time's almost expired. Mr. Chairman, I yield back.
Gentleman yields back. Chair recognizes Mr. Moore.
Hey, thank you, Mr. Chairman. Mr. Secretary, welcome. You know, before my time, I understand that this committee had 3 hearings on lost children under the Trump administration. At that time, it was only 1,000 lost children. And if I remember correctly, there was a certain member, and I won't give her name, but her initials are AOC, put on a white suit and went to the border to protest this 1,000 lost children. And now, my friend, the New York Times, actually, this is not a Republican rag, by the way. I reported in February of 2023, HHS had lost over 85,000 unaccompanied children. And my question to you is, as this process continues, I think you're in over your head. I think the administration has buried you. I don't think there's any way you can keep track of what's going on the southern border, and we're losing children by the droves. And when you talk about background checks, how is it that one individual could get 20 children? How does that happen, Mr. Secretary?
Congressman, thanks for the question. Actually, I think I heard two questions there. The first is on 85,000 lost kids. Again, not answering a phone call, that does not mean a child is
Secretary, let me
lost.
tell you something. If my wife calls one of my kids, and on about the second call, we don't know where that child is, it is pandemonium around the Moore household. And I got news for you. When you're losing children to the tune of 85,000, there are parents somewhere in this world, and I don't know where the parents are, that are sending these children here for some reason. And they're being trafficked. They've been used for child labor. And again, this is the New York Times. This is not a Republican talking point. This is not a Republican rag. This is the New York Times talking about the mismanagement of this administration of these children and how we've lost them. And so my question to you is, how does one sponsor get 20 children? If we're background checking, in fact, how does that happen?
Congressman, every sponsor must go through a background check process. Every sponsor must be able to show.
Mr. Secretary, what if they're a foreign national? Are you background checking if they're foreign nationals? Is it possible that MS-13 is bringing their people across the border and taking custody of these children and putting them into trafficking and other unspeakable sort of things? Is that possible?
Remember, I mentioned in my opening testimony that the vast majority, 80–90% of the kids that we place are placed with the parent.
If you're not doing bioidentical, if you're not identifying these people biometrics, how do you know they're the parents?
So there are many ways to provide or to prove identity. You can look at citizen.
So they can prove identity to take custody of children, but not to vote. Is that what you're telling me?
I'm sorry, can you repeat that?
So you're saying voter ID doesn't need to be required. There's no way to verify somebody's identity. But if they're going to take custody of a child in a foreign country, you're saying they do have an ID or they need to have an ID.
You said voter ID?
Yeah, what I'm saying, in other words, is you require an ID for these people supposedly to take these children, but then you say, many times on the left, they say, well, you know, voter ID is racist or discriminatory. So explain to me, how is it that you're verifying the ID of these people if they don't have IDs and nobody can get IDs?
Thank you for the question. Identity documents are one of the many tools that we use to try to ascertain the relationship of the child with the potential sponsor. But there are many other things that we'll do. If there's a sponsor that has not provided sufficient identification and proven that tie to the child, we can turn to things like fingerprinting if we need to.
So you think this person that got these 20 children is related to all 20 of those kids? Is that what I'm hearing, or?
What I can tell you again is that every sponsor must go through a vetting process in order to be able to sponsor any child.
But if they're a foreign national, we do vet those people as well, or?
Anyone who wishes to apply to sponsor a child must go through the process. If they decline to go through the process, they cannot sponsor.
Well, earlier one of the members mentioned that a certain sponsor had kids delivered to different addresses. How do y'all cross-reference that? How do you justify that?
I'm not familiar with any case that you're referencing, but what I will tell you again is when we
That was a Florida grand jury case, by the way.
When we go through the background checks, we ascertain any number of things, including residence, where the child will be placed. We check on the household members in that place as well, in the home. So we go through the process of not only vetting sponsors, but we also check with those members in the household.
So in the Florida grand jury case where the one child was delivered to the strip club, did y'all vet that location? I mean, was that considered a house? I mean, is a strip club now considered a house for children being trafficked or lost?
As I mentioned, Congressman, we can discuss the Florida report. There are many issues that we have with that report.
Let me ask you a real quick question. I'm going to change subjects real quick. And many of the members have mentioned it, the Kayla Hamilton case, where Mr. Martinez, he came across as an unaccompanied child and then ended up killing Ms. Hamilton. How many UACs, unaccompanied children now, do we have in secure facilities? Are you housing in secured facilities? Do you know?
We use secure facilities if we don't believe that we can manage the children or keep the children that they would be around safe, or perhaps even for the safety of the individual. I don't have that number. I can take that back to my team.
Yeah, we'd be curious to know that. I'm kind of trying to figure out how in the world I had this situation in one of my areas where a young lady was raped by a 31-year-old that identified as an unaccompanied child, and he came to this country and then drug a 14-year-old girl into a restroom and raped her, and yet he was identified as a child, and I don't know how you understand like a 31-year-old. How do y'all identify that as a child? Is there any test on age when the kids come here? Do you get any documentation on birth certificates, anything like that?
you're going to many of the documents and the ways that we try to ascertain not just the child's identity, but also get back into the background of anyone who wishes to sponsor.
How does a 31-year-old identify as a child?
Gentleman's time has expired.
I
Ms.
yield back.
Ross.
Thank you, Secretary Becerra, and I apologize
No.
for my tardiness. I understand that some of the questions that I was going to ask you about unaccompanied minors have been covered. So I'm going to just find out what you think the status of temporary protected status individuals are. And given the conflicts that are going on around the world and the people who are seeking asylum in so many different ways, could you reflect on where the Biden administration has been with TPS and share advice that you would give to the incoming administration for how to deal with people who come here seeking refuge under TPS?
Congresswoman, you're taking me back to my days as a member of this body, in fact, a member of this committee as well. As Secretary, we do not have jurisdiction over issues like temporary protected status. That falls under the jurisdiction of Department of Homeland Security. But what I will tell you is this: the TPS process is one that has helped many individuals who are afraid that if they return, they would return to violence, persecution. And the temporary protected status system has been in place under many administrations, Republican and Democratic. It is a way that we have been able to protect families, individuals and families, from the harms they could face if they were to be sent back home.
And my next question to you is, you've had this job. It's been a tough job because you inherited just a complete mess, particularly for unaccompanied minors and for family separation, and you've made some progress. If you could give advice to the next administration for maybe the top 3 things that they should do to build on the progress that you've made. We know nothing's perfect, but what should they do if they really wanted to make a difference in this area?
First and foremost, Congresswoman, safety and well-being. That has to be always the first priority when it comes to unaccompanied children, is safety and well-being, recognizing that some of these kids are in our care after going through some truly traumatic experiences, some severe hardship, and our job is to try to help care for them, but our principal job is to place them in a better setting than the congregate care facilities that we have, because you want to help them, help cure them from those devastating experiences that they have. And the best place to do that is in a home, in a community, in a place where they can be with people who care for them. And while we care for them, again, congregate settings, we do the best job we can. And so I would say, on top of always putting safety and well-being at the top of your list, secondly, making sure you have the resources so that not only the care you give while they're with you is good, but that you can help provide the services that help make the transition to a new sponsor, one that will work for the child.
Okay, and then finally, what was the most inspirational thing you got to do serving as secretary?
Oh my gosh, we're talking beyond the unaccompanied children program?
Yes, because your term's coming to an end, and so it's always nice to reflect on something positive.
Yeah, in all my notes, I didn't prepare for that question, Congresswoman, but what I will tell you is that watching as more Americans today have access to health care because they have their own health insurance than ever before, record number, more than 300 million Americans today have their own health insurance coverage. That's never happened in the history of our country. President Biden made that possible. We have more people today. Virtual country has been vaccinated against COVID, and so we've been able to function. We don't have to wear a mask everywhere we go. We don't have to distance. We don't have to watch our loved ones die in isolation because we can't be with them. Having gone through a pandemic that none of us had experienced before was something that was a tremendous challenge, and watching how we tried to make sure America got healthy so our economy got healthy was critical. I would simply say it's giving us a chance to do what we're supposed to do, is improve the health of the American people.
Well, as a legislator from North Carolina, I want to thank you for your assistance with Medicaid expansion.
Absolutely.
Because that's the most important thing that happened in our state during your tenure. Thank you, Mr. Chairman, and I yield back.
Gentlelady yields back. On behalf of Mr. Briggs, the chair would request unanimous consent to place into the record a copy of the appropriations language of funding ORR at $6.4 billion for fiscal year 2024. Chair recognizes Mr. Rulli for 5 minutes.
Mr. Chairman, I yield my time back to the chair.
Oh, well, thank you. Mr. Secretary, you mentioned, well, the 3 calls that you make to follow up, it could be they just aren't by the phone or they're at school or at work or something. So, okay, so you make the 3 calls and you can't contact either the sponsor or the child. So now what?
Congressman, I would pose the question back to you because
Oh, now what? I mean, did you just shrug your shoulders and go on?
No, that's why we have tried to expand.
What are you doing then?
Well,
I mean,
that's
as
why
Mr.
we've
Moore
expanded.
said, if it was my child and I couldn't get a hold of them or the person that's looking after them in 3 separate phone calls, I would be freaking out. Now, you're the surrogate parent in this case. What do you do after the 3 calls go unanswered? You're telling us, you're assuring us, these children aren't lost, but how are you following up after that? Or are you?
Congressman, if you'll give me a chance to respond, because you pose a great question, because you and I as parents would want to make sure that we know what's going on with our children. And we make every effort. We don't have
3 calls, and then what after that?
Congressman, our responsibility is to provide care while they are in our custody. Under
Mr.
the law,
Secretary, you have dropped them off at a sponsor's house. You now can't get a hold of them. That's on you. What do you do after that? What I'm hearing back is you don't do anything. You shrug your shoulders and then send another batch of kids out to another group of sponsors' homes. That's frightening to me, and it's frightening to everybody who has watched this terrible, terrible situation unfold on your watch. Mr. Van Drew mentioned your Unaccompanied Children Program foundational rule and noted that this was a giant step back from rigorous vetting. Failure to categorically disqualify sponsors with criminal or other child welfare history concerns, instead requiring case managers to first consider a potential sponsor's resources and strengths, never mind that they've got a criminal conviction. Barring the sharing of immigrant information for potential sponsors with law enforcement officials, finding out, are these people trustworthy? And weakening the veracity of age determinations of UACs by requiring forensic evidence that indicates that an adult is posing as a UAC, in your rule's words, should not be used as sole determining factor, but only in concert with other factors, and then shifting the burden of proof so that the ambiguous, debatable, or borderline forensic examination results are resolved in favor of finding the individual is a child. That doesn't sound like a step forward in rigorous vetting. That sounds like a step backwards to me. As mentioned, Senator Grassley's finding, and one particularly disturbing case, that one child was placed with a known affiliate of the dangerous MS-13 gang. Now, according to the documents, HHS disregarded multiple warnings by a case manager about the potential danger of the UAC being placed in this home, this rigorous vetting that you're talking about. You were actually warned by the case manager that you were placing this child with an MS-13 gang member. That doesn't sound like rigorous vetting to me. Since January 20th of 2021, when this administration took office, can you tell me the total number of unaccompanied children that HHS has placed with known or suspected gang members?
Was that a question to me?
Yes.
And please repeat the question. I thought you were making a comment.
The question is, how many children have been placed with known MS-13 gang members? We know of one. What do you know?
Congressman, obviously, when we go through the extensive vetting process, we would make sure that what we try to do is place them with someone who will keep them safe. Obviously, someone who is involved in gang activity would not be someone we would consider.
And yet you did so anyway after you were warned by the case manager. You've placed, what, 440 UACs with sponsors? 440,000 during your tenure?
We have placed a large number. I don't know if that's the precise number, but a large number.
Well, and again, you assure us that the department undertakes rigorous background reviews of all of these sponsors. So can you tell me how many sponsors have been rejected for failing to pass background checks?
Well, certainly no sponsor who where we flag certain activity, whether it's criminal records, where we flag.
Well, how many have you flagged?
I certainly can try to get back to you with some information on that. I can take that back to my team. I don't have a number with me as we speak.
Do you know how many you've disqualified because of previous murder convictions?
I don't have those kinds of numbers.
How about child abuse convictions?
Certainly none of those individuals, when they go through the vetting process.
What about trafficking and child pornography? The ranking member reminds me that Mr. Ruley's time has expired. The chair now recognizes Mr. Hunt of Texas.
Thank you, Mr. Chairman. The Biden-Harris Refugee Resettlement Program is not your grandfather's refugee program, and I'm going to tell you why. You grew up thinking that refugees meant the most vulnerable people in the world, but not so much under the Biden-Harris administration. The left could never leave anything alone, and not even the U.S. Refugee Resettlement Program. Biden has reimagined U.S. refugees. You might have missed this, but the Biden-Harris administration in January 2023 created a program called the Welcome Corps. Under the Welcome Corps program, U.S. permanent residents, non-citizens, can recommend and sponsor non-citizens to be U.S. refugees. Yes, you heard that correctly. Non-citizens can sponsor non-citizens to become refugees in my America. Let's make an analogy that the liberal elites will understand. Imagine you are a member of a country club. You pay dues and you enjoy all the benefits that come with being a member of that club. Then one day, you invite a guest to visit the country club, and then the guest invites another non-member to visit the club. And before you know it, the membership is irrelevant. Another member may then ask, how are you inviting people to the club? Are you a member? And the guest will say, no, but I'm a lawful permanent resident. The whole purpose of reimagining the U.S. refugee program is to demean and devalue what it means to become a U.S. citizen. Citizenship matters, borders matter. Having borders is a difference between having a country run by President Trump or by a Haitian warlord barbecue. I am sure that some of you are familiar with the recent Spirit Airlines flight that landed in Haiti and was immediately met with gunfire. And as I said, borders are important. In 2020, under President Trump, close to 12,000 refugees were admitted into the United States. But just this past year, under the Biden administration, the number of admitted refugees has ballooned to over 100,000 people, the highest number in 3 decades. Let me tell you about another Biden-Harris initiative for non-citizens. The Biden-Harris administration has the initiative for refugees called the New Americans Partnership, which is an initiative that fosters collaboration between housing agencies and refugee resettlement agencies to support the housing needs of said New Americans. New Americans? What about the Americans that are already here? Americans are dreamers too. Americans are refugees too. They're refugees of Democrat-run cities. Now, I am sure there are Americans living in Inglewood who would love to move to Beverly Hills. I'm sure there are Americans living in Harlem that would love to move to the Upper East Side. I am sure there are Americans living in the South Side of Chicago who would love to move to Lake Forest. Take a look at the last census. Americans are fleeing Democrat-run states for the haven of Republican states. Why is that? Under the Biden-Harris administration, Americans are left behind while the needs of new Americans are pushed to the front of the line of tax-paying Americans. There's a reason why President Trump won every swing state this year and the first Republican to win the popular vote in 20 years. Americans are sick and tired of being treated like second-class citizens in our own country. President Trump created opportunity zones for Black Americans. President Biden and Democrat mayors created opportunity zones for illegal immigrants. For the left, it's the new Americans first and Americans last. I've said this before, it's not the great replacement theory. This is the definition of the great replacement fact. The left wants to allow millions of people into this country, whether that be legally or illegally, so that United States citizenship means essentially nothing. In this country, we don't have Americans or old Americans or new Americans. We just have my fellow Americans. Now that President Trump is back, I'm happy to say that all American citizens will be treated with respect once again. And with that, I yield back my time. Thank you, Mr. Chair.
The gentleman yields back. The chair now claims his own 5 minutes to sum up the concerns I have with all of this checking that you keep assuring us is so rigorous. Your ORR director, Don Marcos, told the committee that HHS routinely contacts foreign consulates or embassies in order to verify UAC's documents. Is that correct?
We work with the consulate offices, Mr. Chairman, to try to...
You verify the information of these children with the consulate. When you're doing that, do you ever ask for the child's criminal history? Again, we're talking about adolescents here, and sometimes adults pretending to be adolescents.
As I've said before, Mr. Chairman, we're not a law enforcement agency. We're not an immigration agency.
No, you're a placement agency. You're placing these children in what you keep assuring us are carefully vetted homes, and yet, according to your own ORR director, admitting to this committee in a transcribed interview, that when HHS contacts the consulate to verify information on the UAC, they do not ask for any criminal background information on that UAC. So they don't know if it's a gang member, and they don't ask. Why would she tell us this?
Congressman, we go through a vetting process to ensure that we can know who the child is, and then
yes,
for the placement.
Of course, that's what she testified. But then she also testified that you specifically do not inquire into the criminal background of these individuals who are 17 years old and sometimes older and pretending to be 17, with gang tattoos, with gang affiliations, and you don't, while you've got them on the phone and you are verifying information on that UAC, you don't bother to ask, oh, by the way, is this an MS-13 gang member? Does this individual have a criminal history? And then you place them in foster homes, you release them into our communities, and there are some cases, tragic cases, where they go on to murder innocent Americans like Kayla Hamilton. Mr. Tiffany asked you, is there anything you do differently looking back on these past 4 years? Is there anything you do differently in the Kayla Hamilton case?
Mr. Chairman, we work closely with the Department of Homeland Security, which does the vetting for these children when they first enter into the country.
You're placing them. You're the ones that are placing them in people's homes, and you're the one who's telling me, don't worry about it. They're all carefully vetted. They're all secure. Don't worry that we can't reach them by phone after we've placed them in these homes. It might be they just weren't paying attention to the phone. Do you understand how this do you understand how this affects the lives of a population that you've placed that's approaching the size of the state of Wyoming? Some of them innocent, defenseless children, others gang members who are 17 years old or even older pretending to be 17. And you're in charge of all of this. And you can't tell us if there's anything you'd even do differently after 4 years of this nightmare that has unfolded, not only for our country, but for these children and their families. What do you have to say for yourself, Mr. Secretary? This is the end of this administration. It's the end of your tenure. What do you have to say for yourself? Because the words that keep haunting me are those that Cromwell spoke to the Long Parliament. You have sat here too long for any good you have been doing. It is not fit that you should sit here any longer. You shall now give way to better men. Now depart and go, I say, in the name of God, go.
Mr. Chairman, if you will allow me then to respond. We work closely with various agencies. In the case of the vetting of the child, it is the Department of Homeland Security that does the initial vetting because they're the ones that have custody of that child once the child is in the U.S. The Department of Homeland Security is the agency that then goes through that process of trying to determine who this child is, including those issues that you've mentioned with regard to any past criminal conduct. When we receive the children, Department of Homeland Security shares with us the information they have compiled on that child. From there, what we try to do is make sure we care for the child, and in the process of trying to find them a sponsor where they can live in a community, we go through the vetting of the individual potential sponsor.
Mr. Secretary, when the history of this administration is written, I would not want to be you looking back on what historians say about your tenure. I'm sorry, but that's the fact. If there's no further business to be brought before the subcommittee will stand adjourned.
Well, that was an abrupt conclusion. Usually there's something like you have 5 days to answer questions in writing or something like that. Was also expecting maybe Victoria Sparks to grace us with her presence. That did not happen. Who else was not? Troy Nels wasn't there today. On the right, on the left side of the aisle, we are very thankful. Eric Swalwell was not present. Thank you. Thank you by the graces of God. Okay. Well, that's it. I mean, that's it for at least for the foreseeable future. Tomorrow, the House, Senate Judiciary, I'm getting jacked up here. The House Judiciary is going to have a meeting, and it's just a regular business meeting where they are, am I wrong about that? It's the Senate Judiciary, I think. I had this all sorted out for you guys, and then I lost it. Senate Judiciary. That's the last thing on the schedules, really, for the year, maybe? I don't know if they're going to be in session in December. But tomorrow, Thursday, November 21st at 10 a.m. is a business meeting. The Senate Judiciary, they're going to be considering reauthorizing a Cops on the Beat grant, amongst various other nominations and business. Just a regular business meeting. So that's tomorrow. Everybody, thank you so much for coming in today. Wasn't expecting to go all the way through. We started at 10 a.m. Watching some judiciary business in the Senate. We transferred over to the House Oversight, and we finished over here in House Judiciary on HHS Refugee Resettlement. Thank you for joining us here on this channel. I really appreciate it. It's been a whirlwind of a year. I mean, it's crazy.